Then again you can reach on that.
Five. My lordship.
Yes.
Matter
We'll
is
see. Yes.
Monday.
Kodi.
Serial number 25 and 27.
Wait.
Let's humble.
Give all the members. Why are you waiting? Why enter the list?
Madam.
All right. All right. Tomorrow. Tomorrow. You want it tomorrow or Monday? Tomorrow.
Yes.
Huh? Tomorrow. Intermot is there. Tomorrow.
Milord, suit for Milord.
ಓ ಏನು ಪರವಾಗಿಲ್ಲ ನಾಳೆ ಕೊಡಿ ಏನಾಗಲ್ಲ ಸರ್ ಡೆಲಿವರಿ ವಾರಂಟಿ ಕೊಡಿ ಗಿವ್ ಇಟ್ ಟುಮಾರೋ
Successive 480.
ಸಕ್ಸೆಸಿವ್ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ
Matter is partly heard, my lord.
ವಿಲ್ ಸಿ ಮಂಡೇ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ
Matter is partly heard. It's with rest.
ಆರ್ಡರ್ ಇದೆಯಾ ಹಾಂ ಮಾಡಲಿ ಬಿಡಿ ಹಾಂ ಆಯ್ತು ನೋಡು ಎಸ್
Lord, the matter is partly heard, my lord. It's with respect to
ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಕಮ್ಸ್ ಗಿವ್ ಇಟ್ ಎಸ್
Successive 482. I heard your lordship.
ಸಕ್ಸೆಸಿವ್ ಫಾರ್ ಇಟ್ ಕೊಡಿ
The
ಮಂಡೇ
trial court,
ಟ್ಯೂಸ್ಡೇ ಇಟ್ ಮೇ ಕಮ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಗಿವ್ ಇಟ್
Trial court date is there for Monday, my lord. Seeking for. Milord, suit for injunction. I am the tenant, my lord. Landlord is cutting the electricity and water connection, my lord. I am running a shop, my lord. Kindly interim order may be for consideration
Tomorrow.
Please.
My lord. I filed my statement of objection for release of amount. Land acquisition officer, he passes an order that the suit which I filed, which is pending, is not maintainable and he releases an amount of rupees 3.4 crores.
ಆಲ್ರೆಡಿ ರಿಲೀಸ್ಡ್
Release in one property, 230.
230 crore
My lord, it's a fresh matter, my lord. The warrant for attachment of movables has been issued against me
Perfect.
with an
Monday.
appropriate summons.
Monday.
It's still tomorrow, my lord.
No, sir, Monday. Yes.
My lords, it is CRP, CPC, my lords, kindly it may be taken up at the end of the list.
Why?
Actually, matter was heard yesterday, my lords.
Here.
Yes, yes, my lords, actually, it is not, it was said. that it is
Conversion,
not-
22:30. All right, give it, yes.
Ma-
Special array repeat orders are petty array
Hmm.
considering the old act, whereas there should be represented under the new act.
Give it.
Maybe issue on Monday.
My lords,
Pending matter.
my,
My electricity and water connection has been disconnected. My application has been negated by the trial court.
my lords, the memo was,
Or Monday? Yes.
my lords, not granting of the,
Fresh matter.
ಇಲ್ಲ, pending matter.
Under Wednesday. Yes.
my lords,
Matter pertaining to land acquisition have been trying to,
Tuesday.
my lord, it was supposed to be listed
Tuesday.
Tuesday, my lord. Kindly have it tomorrow, my lord.
Tuesday, sir.
my lords, the temporary injunction was
Every
not
day
granted.
You want it on Tuesday or Thursday?
ದಿನ JCB ತರ್ತಿದ್ದಾರೆ demolish ಮಾಡ್ತೀನಿ.
Dina JCB.
3 days they are getting.
2:30.
My lords, the temporary,
Pending matter ಆದ್ರೆ ಕೊಡ್ಬೇಡಿ.
Fresh matter.
ಹಾ.
my lords, fresh matter, my lords, temporary injunction was not granted. The matter.
Give it, sir. All.
My lord, requesting for tomorrow, my lord.
Why no tomorrow, sir? Give it.
My lords, the memo was moved on Monday. It was supposed
Maybe,
to come on
give it,
Wednesday,
give
my
it.
lord.
It will come.
Lordship withdrawal for 2:30, your lordship.
Withdrawal 2:30, give it, yes.
My lords, I have filed.
Attachment, handing over direction to hand over the possession of the property
Ma'am.
and they have filed application for police help. And tomorrow is the case, my lord, 2:30.
2:30.
2:30.
Sir, I filed this 14/2009, my lords. I'm seeking directions for early disposal.
Monday.
This is successive 480.
Huh?
Election petition is filed to the lower court.
Pending matter.
Fresh matter. My stay was not considered.
Give it, sir. GMCP.
This is the successive 482 petition, my lords. They file an IA for vacating stay.
Ah.
Charge sheet has been filed, my lords, and offense has been made out in the charge sheet. At the stage of interim order, my lords, all these facts were suppressed. my
You're
lords.
for the complainant.
Please, my lords, they file an IA.
Give it, yes. Thoroughly.
Probably fresh matter, your lordship,
Give
the
it.
transfer of
Lords,
khata
I have
has
filed
been
an
rejected.
Give it, give all the memos.
Application for early hearing, my lords, in the month of
Give
February.
early
Several
hearing.
times, yes, my lords.
Early hearing.
Yes,
ಯಾವ
ma'am.
ವರ್ಷದ್ದು ಸರ್?
In the month of February.
ಯಾವ ವರ್ಷದ ಕೇಸು?
22, my lords.
Wait.
Now that.
ಯಾವುದು? CPC ಯಾ?
CPC, my lords. My lords, now the trial has been concluded in. Yes, my lords.
ಸರಿ ಬಿಡಿ. ಇನ್ಫೆಕ್ಷಸ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, conclude ಆಗಿಂದ, but
ಆಗುತ್ತೆ.
the matter is posted for arguments. my lords, for-
The Masala matter was to be posted today at 2:30, my lord. It's not been.
2:30
ಇವತ್ತು ತಾವು direction ಕೊಟ್ಟಿದ್ದೀರಿ.
ಇದೆಯಾ?
ಇಲ್ಲ, not listed, my lords.
Chamber ಇದೆಯಾ? It will come, it will be listed.
In this case,
But,
serial number 32, I am filing memo for withdrawal.
Thank you. Sir. Good.
Grateful, my lord.
32 in second list.
Lord, NCLT matter, my lord, your lordships had heard it 2 days ago. Today date was given, my lord.
ಬರುತ್ತೆ ಬರುತ್ತೆ ಮಧ್ಯಾಹ್ನ ಬರುತ್ತೆ. There are 4 matters missed out.
In the, please.
My lord, that's matter for
2025 pending matter, my
25
lord.
and 27, my lord. Appear for petitioner in this case, my lord. KL Srinivas accident ಆಗ್ಬಿಟ್ಟಿದೆ ಸರ್.
ನಿನ್ನೆ ಮೊನ್ನೆ ಇದ್ರು
ಇದ್ರ yesterday evening ಆಗಿದೆ ಸರ್. ಒಂದು 10 days.
25 and 27. ಮೇಡಮ್ ಇದರಿಂದ ಅಡ್ಮಿಷನ್ ಇಂದ ಕರೆ ಬೇಡ ಬೇಡ ಇಲ್ಲಿ ನೋಟಿಸ್.
My lords, 2025 pending matter, my lords.
20 Learned Council, serial number 25 and 27. Learned Council for the Learned Council representing the council for the petitioner submits that the arguing council is met with an accident. List the matter after 2 weeks.
Serial number 6. Serial number 68, my lords. Lords, my
Wait. 68. Page was correct, madam, after admission.
withdrawal.
Yes, in terms of.
Page 14, 69 to 65. Page 14, 66 to 69. Serial number 68. Wednesday, my lords, if I request for Wednesday for guideline value and the market value, one document, my lords.
At the request of the council appearing for the 2014, madam.
It's
At
Wednesday.
at the request of the council appearing for the petition next Thursday as a last chance. Yes, next.
Page 15, 70 and 71. Page 16, 72 to 75. page 17, 76 to 78.
My lords, serial number 78, my lords, appear for the petitioner. My lords, my seniors not keeping well, my lords.
2016.
Please, my lords, 2
Next,
weeks,
same, last chance, next Thursday.
please, my lords, interim order to continue, my lords.
It's made clear in the interim order stands extended, subject to the condition that on the next date, their submissions would get completed, failing which the interim order would get automatically vacated. Next.
Please, my
Page
lords.
18, 79 and 80, page 19, 81 to 86, page 20, 87, 88.
Getting the interim.
Huh?
Getting the interim.
No, Kodi.
My lords, I'm a bankrupt insolvent, my lords. Police is coming to arrest me in the execution case.
Ali, GM court.
GM CPC barte.
DPC, Kodi.
You are end of the list.
No, end of the list.
Police, today the
Tomorrow.
police wants to arrest me, my lords.
Tomorrow.
Yes. Matter pertaining to a levy of betterment tax, my lords. I was not provided with the opportunity before
Which court?
BDM.
BDA, next Tuesday, yes.
Fresh matter, my lords. We filed an application under order 39. Civil court is sumo to
It will
dismiss.
come,
this.
sir, Monday, yes.
Tomorrow, my lords.
No, sir, yes. Next, call the case. CRP other Thursday. With CRP only Thursday, yes.
List 1, preliminary hearings, number 1.
CRP is admitted, why is it come for preliminary hearing?
My lord is pleased to direct that for final disposal.
But let it come in, we'll post it for hearing only.
Please, my lord.
Was it listed on what day? 4 nights?
Last Thursday.
Kindly.
Any date which suits, my lord.
Oh, this early hearing, preliminary, it's my order.
Yes,
I didn't know that it had been admitted.
Kindly, my lord. In this matter, we have given an error.
Who is he?
ನಮಗೆ ಅಡ್ವೊಕೇಟ್ ಕಡೆಯಿಂದ
Plaintiff,
ಸಮಸ್ಯೆ ತಗೊಂಡಿದ್ದೀವಿ
Plaintiff. Party in person?
ಪಾರ್ಟಿ
Party, ನೀವೇ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ, ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಅಡ್ವೊಕೇಟ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ಕಾಲಾವಕಾಶ ಬೇಕು
2015 ಕೇಸು. ಈ ಕಾಲಾವಕಾಶ ಕೇಳಿದ್ರೆ?
ಒಂದು 25 ದಿವಸ ಕೊಡಿ ಸ್ವಾಮಿ ಸಾಕು.
25 ದಿನ, ಅದೇನು 25 ದಿನ?
20 ದಿನ ಕೊಡಿ ಸ್ವಾಮಿ.
Wait, 20 ದಿನ ಇಲ್ಲ, 25 ದಿನ ಇಲ್ಲ. 2015 ಕೇಸ್.
The file has taken by the parties, my lord. I will file the memo for retirement during the course
Nimda?
of the day. Please, my lord.
ಯಾರು TP ವಿವೇಕಾನಂದ?
Please, R1 and R2.
Learned Counsel TP Vivekananda submits that the respondent has taken the file. The respondent is present in person and seeks 2 weeks' time to engage the service of a counsel. He is the contesting respondent, is it? Is he the contesting respondent?
Yes.
Yes.
So and so. At his request, list the matter on CRP, 3rd July. It is made clear on the said date, the submission, the matter would be heard and disposed. ಅಷ್ಟ್ರಲ್ಲಿ ಮಾಡಿ ಇಲ್ದಾರೆ ಅವರ್ ಟೈಮ್ ಕೊಡಲ್ಲ ಮತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
No, my lord. The records are called, all the trial courts.
Indirect entry.
Yes.
Number 2.
The challenges with respect to penal notification.
ಸಿಂಗಲ್ ವಿಂಡೋ ಕ್ಲಿಯರೆನ್ಸ್ ಆಗಿದೆ.
ಆಗಿದೆ ಕ್ಲಿಯರೆನ್ಸ್
ಆದ್ರೆ ಅದು ಅಕ್ವೈರ್ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಆದ್ಮೇಲೆ ಅಕ್ವೈರ್ ಮಾಡಬಾರ್ದು ಅಂತಿಲ್ಲ. The same purpose it has been sought for. Industrial, but we are the suppliers of organ components to the defense industries. And we wanted an extent, we are in the
ಏನು ಮಾಡಿಲ್ಲ, ಬರೀ ಲ್ಯಾಂಡ್ ನ ರೆಡಿ ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ. ಬ್ರೋಷರ್ ಬಿಟ್ಟು ಏನು ಇಲ್ಲ ಇದ್ರೆ.
May kindly see one document that I would request this honest see may kindly be seen.
ಏನದು?
ಅದು change of land use ಮಾಡ್ತಾರೆ ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Documents.
What document?
The position was taken, my lord, in the year of 2004, 24 itself. And also award also passed.
But the award has been passed on 12/6/2025. May kindly see over. After the matter has been, I have made a submission to this honorable court.
12/6/25.
May kindly see that the memo that they sent on
25/3/25
memo.
ಇದೇನ್ ಬೇಕಂತ ಮಾಡಿದೀರಾ ಇದಾಗ?
ಅದನ್ನ ಸಮಸ್ಯೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ we are a carbon component industry and may kindly see annexed see that we required to proceed further in annexed D at page number 49. May kindly be one see. We were required to take the change of land use. In the meantime, that original owner had expired. My father.
You have not taken change of land use?
We have applied for change of land use.
Applied.
Although the pending process is there. But may kindly, because we are setting up the same kind of industry.
It's all right, but how can
our own land, we are there in the business for over a period of time. It is not that today that we are the fresh operators. We are there from past. That's why those brochures and other things have been produced. We are from 1960 and onwards. We are there in the same defense line industries. Additional documents have been produced.
Very difficult.
Additional documents may kindly be seen.
If they wanted to run the industry, my lord, we'll give a alternative
We are the
developed land. my
sole
lord.
suppliers of this
Alternate,
kind
one
of.
ನಿಮಿಷ.
Make use of that land, man.
Alternate land ಕೊಟ್ಟಿದ್ದೀರಾ?
Alternative land, developed land, 10,000 square meter.
But award pass ಮಾಡಕ್ಕೆ ಯಾಕೆ ಇಷ್ಟು ದಿನ ತಗೊಂಡ್ರಿ?
Some
That too now when the matter is being heard, why did you?
No, recently it is,
ಅದೇ recently ಅಲ್ಲ, 4 ದಿನ ಆಗಿದೆ.
it is.
ಅಲ್ಕೋ 12/6 yesterday.
Allah,
No, no, no.
my lord, the date is, this has been, day before yesterday, we have made a submission to this honorable court that award has not yet been passed.
The March.
Now they produce a
March
document.
25th. my lord.
Even today, it has not been approved. It is pending approval.
where ಎಲ್ಲಿದೆ 12/6 ಅಂತ ಎಲ್ಲಿದೆ?
I think
Last one, my
25/3,
lord.
2000.
25/3,
25/3.
2025.
I think this has not been dated. It is page in it, the 25/3 ಅವ್ರು ಹಾಕಿರೋದು ಕಳಿಸಿರೋದು ತಮಗೆ.
But it's very difficult to accept a submission that you have been
25.
allotted, there is no industry except the land, and that should not be become
There is
subject
an-
matter
we are only,
requisition.
it's an industry to
ಏನಿಲ್ಲ,
extend it.
ಏನ್ setup ಮಾಡಿದ್ದಾರೆ ಇಂಡಸ್ಟ್ರಿನ ಇಲ್ವಲ್ಲ?
Yeah, there is lot,
that
there is
ಏನಿದೆ?
only for extension.
ಏನಿದೆ?
It's only for extension.
What extension?
We are already running an industry. That's why I produced additional documents. May kindly see this. Additional
is-
documents may kindly be seen.
Extension
Not
of
that I am
what?
now doing it today, Allah. I'm from past 1980 years. That's what exactly my submission is. This is a unique industry, what I think.
This
They are
is-
running an industry, my lord, even though it is a sick industry, my lord, they are entitled, my lord.
No, it is not.
It is even there, it is not converted.
We have
also.
Well, see,
recently,
what are the rules?
what's the rules? There is nothing of that sort which I could able to lay my hand that things
Ah,
cannot be acquired.
yes.
But my lord, the one submission that I would make is, my lord, is for the similar purpose. It is not for any other purpose. Even if we have been allotted with some alternate land where in which we could do it in this circumstances.
The learned counsel for the respondent board places on record the notice issued to the petitioners and the award passed insofar as the acquisition of the adjacent land belonging to the petitioners industry is
Also,
concerned.
possession was taken
And the learned counsel submits possession has been taken on
27,
6,
27,
2024.
2024.
27/6/2024. List the matter in B group on
Lords,
on 1st June, 1st July.
let them, my lord, let them not carry any further work on.
1st July, nothing will happen, yes.
Because they are already forming the layout, the industrial sites over there.
We'll see, yes.
Okay.
Then KLR, special order.
Special orders that will come up day before, my lord, your lordship posted it to today. The respondent number 4, LR, my lord, have brought him on record.
Lordship, I take undertaking for respondent 4A to file wakalat, Lordship.
4?
Lordship.
4A to 5.
Only A, Lordship.
4A. ಅವ್ರಿಗೆ ಮಾತ್ರ ಸರ್ವ್ ಆಗಿಲ್ಲ ಈಗ.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಆಗಿತ್ತು.
ಅದೇ now deceased.
Now he is
Counsel for the learned counsel so and so undertakes to enter appearance for the legal representative of the deceased R4-R4A. Registry to print the name of so and so is appearing for the respondent R4A. Will
short.
intermodal ಇದೆಯಲ್ಲ?
please, my lord, says
Will next week?
Yes, Lordship.
Yes, learned counsel seeks a week's time to go through the papers and make his submissions. List next Tuesday.
very well. I'm ready.
Next Tuesday or Thursday.
I'm for the petitioner in this case, my lord.
Mr. Lordships, kindly, my lords, I appear for respond number 2 and 3. Now, my lords, these are acquisitions for the BMICP, the nice highway. They are not arraigned as a party, my lords, they are the beneficiaries of the
Beneficiaries?
acquisitions.
But acquisition, you've dropped the acquisition.
No, we have not dropped, my lords.
2009 final notification.
Award is still not, award madilla, but there is, my lords, there are batch of matters pending.
Where?
Before his lordship Justice Devdas, where some of them, my lords, have given a finding.
I have given finding.
Justice Devdas, his lordship Justice Devdas has given a finding. Now, my lords, the full bench judgment of this court says there are no time limits prescribed under the KID Act, and in the absence of the same, if we can give the circumstances and explanation, then delays, it is not fixed in terms of time period.
Any explanation ಇದರಲ್ಲಿ?
Well, there is a subsisting contractual dispute between the beneficiary of the acquisition and state, and they are fighting all the way up to Supreme Court. We could provide the list of litigation that is happening.
Then we'll tag it along with that only. Number ಕೊಡಿ.
My lords, those matters are reserved. Reserved.
I list the the learned counsel appearing for the respondent board submits that identical matters have been heard and reserved by His Lordship Justice R. Devdas. In that light, the list this matter after 6 weeks. Next.
Five.
VN review ಇದರಲ್ಲಿ ಅರ್ಕಾವತಿಯಲ್ಲಿ
It's a review, yes, my lords, it's a review. My lords, just to give a prelude, my lords, to this entire litigation.
What prelude? Batch matters ಅಲ್ಲಿ ನಿಮ್ದು dispose ಆಗಿದೆ.
No, my lords, it has been disposed of. but
Then
we
why
just-
review if it is not disposed?
My lords, I was not a party in the writ petition. My lords, may kindly take, my lords, this. I was not a party in the writ petition.
All right.
My lords, what happens, my lords, is, my lords, the notification, final notification of 2004 was challenged by several persons, my lords, on say various grounds. One of the important ground, my lords, of challenge was that there was a discrimination, my lords, in denotifying about 1,000 and odd acres in the final notification, towards the preliminary notification.
You are not a party, but your lands were a subject matter of this?
But that's my lands were not a subject matter of the second final notification.
Then why are you filed review or recalling?
Yes, kindly, my lords, take 190, my lords, page 190. My lords, now, while passing the order, my lords, the learned judge has made certain observations. Kindly see, my lords, page 190. 192, my lords. My lords, for the H, my lords, at the bottom. The committee shall examine as to whether deletion of 983 points on so of lands by the government subsequent to the notification dated 23/2/2004 and before the issuance of the notification dated 18/6/2014 was in accordance with the dicta laid down by the division bench and in accordance with the directions and clarification issued by the Honorable Apex Court in Bandu Ramaswamy's case and submit a report to the BDA, who shall take steps based on so and so. Then, my lords, may also kindly read, my lords, paragraph number 11, my lords, at page 195. A further directions has been given to the committee. The committee would at liberty to examine whether the BDA has undertaken any exercise to delete lands suo moto, and if so, if it is so found, the exercise so undertaken by BDA would stand quash if it is not in conformity with the order passed by the division bench as confirmed and clarified by the Apex Court, to which effect the committee shall submit a report to the BDA. On such report being submitted, deleted lands would stand restored to BDA for the purpose of formation of sites of Rakavati layout to be sold. Now, my lords, these observations, my lords, are made against 983 landowners, acres of landowners who are not parties. My lords, may just pass on the judgments, my lords, of the Honorable Division Bench, where, my lords, specifically observations were made regarding this deletion of those lands. May just pass on the judgments.
Madi?
My lords,
what is the outcome of that?
My lords, now what happened, my lords, the Honorable Division Bench, my lords, set down certain parameters, my lords. Now, as I said, my lords, the learned single judge found, my lords, that there was discrimination in deleting the 1,098 acres in the first round after preliminary notification to the final notification.
All right.
When the final notification, my lords, came, in fact, this learned single.
Which is the division bench judgment?
My lords, division bench judgment, I'll just take, my lords, to that.
Page.
263, my lords, it starts from 260. I just request, my lords, to the relevant portion, my lords, is 382.
Sitting in appeal over what is written by the learned single judge?
No, my lords.
Then?
My lords, I have not taken in an appeal.
Sir.
No, my lords, I have a right of review, my lords, that's why. My,
yes, sir.
no, my lords, I just request, my lords, to kindly see 2 or 3 paragraphs of this.
Yes, sir.
My kindly see, my lords, the division bench said that if there is any discrimination, my lords, in respect of those lands shall be denotified. My lords, then what happened, my lords, the Honorable Apex Court also upheld the order of the division bench. Thereafter, my lords, the government issues a notification, appoints special land acquisition officers, my lords, to examine, my lords, whether these lands which are the land.
That is the subject matter of the petition now, of the learned single judge.
No, my lords, may I just request, my lords, to see one more order, my lords, of the government.
Yes,
the
sir.
government, my lords, appoints special land acquisition officers. My lords, the special land acquisition officers, my lords, looks into the lands belonging to the petitioner, and he, my lords, gives a report saying that there are 110 RCC buildings on this land. And therefore, my lords, he says, it falls within the parameters, my lords, as set down by the Honorable Division Bench. And therefore, my lords, the land of the petitioner
Where is
needs.
that? page.
Yes, my lords. That my lords will find annexure G, my lords, 218, my lords. 218.
2012.
My lords,
2012.
yes. And that, my lords, is pursuant to this report. In 2012, my lords, the petitioner's lands has been denotified. Now, my lords, in 2014, what happens, my lords, is the government accepts the report.
Where is the
of-
denotification?
My lords, there is no denotification. That is why, my lords, I wanted to show, my
Sir,
lords.
who gave you this? This is a report,
Yes,
recommendation.
correct. It's based on this report. The land of the petitioner, my lords, was not included in the second final notification which came out in 2014. Therefore, my lords, the government, my lords, issues a fresh modified scheme to acquire only 1,750 acres of land. My lords, it has consciously, my lords, excluded 983 acres as per the
You come
direction.
within those 983 acres?
Yes.
What is the direction to that committee now?
My lords, direction is to the committee by the learned single judge.
Yes.
Who says, my lords, you examine these lands.
Correct.
Whether
What
they have
has
been-
happened before the committee?
Committee has issued notice to me now.
Go and appear.
No, my lords, there are 110 RCC
Appear,
buildings,
sir.
my lords, in
Go
2012.
and tell the committee, sir.
No, my lords, that's not the point on which I am.
Yes, sir.
My lords, the point on which I am is, my lords, the modified scheme issued by the government is to acquire only 1,750 acres. Now, my lords, there is no necessity for the Bangalore Development Authority as well as the government. They did not want this 983 acres of land.
983.12 acres of land is given up is what the learned single judge has observed. And that shall be borne by the committee, and while looking into it, to take steps based on the report of the committee.
Correct.
Now committee is issued notice to you.
Correct.
Please appear before the committee, and whatever report comes, the remedy is always available.
My lords, that's not the point on which I
That's
am.
the only point.
No, my lords, I'm sorry if you can
Yes,
make
sir.
one more.
I am
My lords,
also
what-
sorry, I cannot sit over the order that is passed, already passed by the learned single
That's my
judge,
only
giving
submission.
certain directions, and if your land in particular is in 983 acres.
It is, my lords.
Then
It
fine.
is therefore I am before this court. Now, my lords, the government, my lords, has issued a modified scheme. My lords, the government did not want 986 acres. There is no scheme, my lords, for acquiring
That
983.
the committee will look into, sir.
My lords,
Committee is specifically constituted to look into that particular
no,
aspect.
my
It
lords,
will
that
look
is not the
into.
directions. That's not the direction.
Then
The
what?
directions are, my
In
lords.
accordance with the law laid down by the division bench, that is what you referred
Correct.
to
There-
now. And submit a report to the BDA, who shall take steps based on the report.
No, my lords, my only submission is, if there is no scheme, then where is the acquisition, my lords? Could the court, my lords, direct the government or the BDA to compulsorily acquire the land, my lords? That is the point, my lords.
We'll have 9,000 petitions after this, if I entertain this.
Lords, that could not be the reason, my lords, not to entertain.
Go before the committee, sir.
My lords, why should I go, my lords, in 2012, my
Oh.
lords? My lords, this report of the committee, the report of the SLO, my lords, is pursuant to the directions of the Honorable Division Bench. My lords, the Honorable Division Bench, my lords, set on the parameters. That, my lords, has merged with the order of the Honorable Supreme Court.
Correct.
Supreme Court also affirms, my lords, yes,
Correct.
you are entitled to, if there is a discrimination, your land has to be
Where is the
denotified.
reasoning for this direction in the order?
There is absolutely no reasoning, my lords.
Sir, the reason
My
in the
lords,
clause
what the-
Bharata.
what the learned single judge says is that there has been discriminations, and, my lords, there's a pick and choose method employed. My lords, I'm not on all those issues. The issue, my lords, that I want my lords to permit me to submit is, there is absolutely no scheme, my lords, to acquire 983 acres. My lords, dehouse the scheme, my lords, can the learned single judge could have directed, my lords, to acquire those lands, my lords. That's the point. And, my lords, since the division bench, my lords, in fact, set down the parameters, the SLA, my lords, who is appointed by the government to look into whether, my lords, my lands would fall within the guidelines, has applied his mind. The government, my lords, does not want my land. BDA doesn't want my land. And 983 acres not included in the second final notification. That being the case, my lords, could, my lords, the court have directed that these lands, my lords, should be acquired. That's the point, my lords. I request, my lords.
Nobody is challenged this in the division bench?
No, not 980.
Order challenge ಮಾಡಿದಾರ.
Order challenge ಮಾಡಿದ್ದಾರೆ, I mean, orders has been upheld.
Division bench.
No, my lords, I'm sorry.
I'll produce the series of those matters. So,
My lords,
just one moment, my lords.
This order is upheld.
Just one moment, my lords.
The order which
Is this order upheld, has been upheld?
my lords, not challenged by the 983 acres.
ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಅಪ್ಹೋಲ್ಡ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಅಷ್ಟೇ. ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
I'm not carrying today.
Why
But
should carry everything?
So, my lords, I'm not carrying because
Will
my
I
lords,
carry
I
my
was,
order now to the division bench.
my lords, I was on.
Yes, that's one clarification, my lords. There were parties, my lords, in the, before the learned single judge.
They were parties.
There were parties in writ petition number 38055 of 2014.
Where do I get that, sir?
My lords, may I just pass on, my lords, because it's a very lengthy cost title. They have not produced the entire one.
I was a party, my lords. I was a
But the
party.
party illa
Originally,
the
they comment
ಹೇಳುವ
stating that they were not parties.
That's- I was
and that
a
they were not
party.
heard.
The opening statement was you are not a party, I'm entitled to recall, review.
There are, I own 4 properties, my lords.
One of the property was here.
One of those properties I was acquired. That I challenge.
Therefore, they can't contend, my lords, that they were not at all heard.
I'm not heard with regard to 80.
First statement, you are not a party, I'm not heard.
No, my lords.
And
That's
secondly,
not
my
the-
lords, this writ petition now is filed with, including the properties which were part of the earlier writ petition. All the 3 properties are now they are seeking relief, my lords. They don't go on to go before the committee. That's the only real issue.
My lords, that's a wrong submission, my lords. The prayer is there, the writ petition is there. My lords, 983 acres, my lords, is not part of the scheme at all. It's not part of the notification. My lords, 2012, my lords, my land has been
Writ
denotified.
petition ಅವ್ರದ್ದು ಯಾವುದು?
38055 of 2014. May I just pass on the?
ಕೊಡಿ.
My lord.
ಯಾರು ಮುನಿಯಪ್ಪನೇ?
ಹೌದು.
Final notification.
My lords, in the final notification,
ಅಲ್ಲ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಲ್ಲ?
my lords, the
Clear,
second
clear
final,
ಆಗಿರೋದು.
my lords, second final notification. This particular land, my lords, was not.
ವಾಟ್ ಎವರ್ ನೀವೇ ಅಪಿಯರ್ ಆಗಿರೋದು.
My lords, I have appeared, my lords, but
I was not heard ಅಂತ ಹೆಂಗಂದ್ರಿ ಮತ್ತೆ?
this is not the property, my lords.
Oh, every property you have to be
My
given
lords,
separate
my lords,
hearing.
I can only make submissions when the particular property is a subject matter. My lords, in that notification, my lords, in 2014, some properties belonging to me was part of that, but not this property which was excluded. My lords, how could they draw parallels, my lords, between that and this?
Correct, how can they?
They can't, my lords.
I will draw. Yes. Anything else, sir?
My lords, that's that.
Yes. The petitioner is before, petitioners, landowners of the property as described in the body of the petition, the then landowners of the property, anta bariri, so and so, are seeking review, recall of an order passed by the learned single judge in writ petition 51929 of 2014, disposed on, it's not 27 in Baradnala, 27/9/2021. Heard so and so. The petitioners are said to be the landowners, were said to be the landowners in survey number 43/1, measuring 2 acres and 19 guntas, and other, 2 acres and 19 guntas, survey number 4, still number 1 alide ಮಾಡ್ಕೊಳ್ಳಿ madam. The lands were subject matter of acquisition for formation of Arkavati layout. There are 2 notifications. The issue in the list concerns the second notification that was issued in the year 2014. The second notification, so issued by the respondent BDA in the year 2014, becomes subject matter of plethora of cases filed before this court challenging the acquisition. One of the cases filed was in writ petition 38055 of 2014 by the very petitioners. The learned single judge, in terms of the order dated 27th September 2021, disposes the petitions by issuing several directions. The directions so issued by the learned judge is as follows. It's right from 180 to 197. Copy paste ಮಾಡಿ. The learned counsel for the petitioner now claims that the direction H by which the committee was directed to be constituted to examine as to whether deletion of 983.12 acres of land by the government subsequent to the notification dated 23/2/2014 2004 within bracket the first notification and issuance of a preliminary notification. Final notification.
First final.
First notification, correct. Was in accordance with law laid down by the division bench, and in compliance with the directions / clarifications issued by the apex court in Bondu Ramaswamy's case. The BDA was directed to take steps on receipt of the report from the hands of the committee. Pursuant to the said direction, the committee has now issued notice to the petitioner asking him to appear before the committee and substantiate his claim. The notice is issued on 11/12/20 on 26/11/2024. After receipt of the notice comes the subject petition for it having been filed on 11/2/2025. Next. The learned counsel A. Sampath would submit that the direction H, which directs the committee to look into the deletion of 983.12 acres, is an error, as there was no scheme itself formed by the BDA, and therefore the committee ought not to have been directed to look into the aspect of 983.12 acres of land, its deletion. The learned counsel would further contend that he was not heard in the matter at the time when the order was passed, and he has a right to seek review or recall of the order in which he was not heard. The learned counsel would further take this court through the order of the division bench to contend that the order of the learned single judge quoted supra was in error and is contrary to the law laid down by the division bench, which had merged with the order of the apex court, which had affirmed the order of the division bench. Per contra, the learned counsel representing the BDA would submit that the submission that they were not heard in the matter is contrary to the facts, contrary to the record, as the petitioner was, these very petitioners were also the parties in writ petition 38055 of 2014, calling in question the final notification of the year 2014 within bracket the second final notification, which is again now sought to be urged in the case at hand. He would submit that the order is passed after hearing all the parties and have been directed to go before the committee. Without going before the committee, the petitioner is now wanting to re-agitate all the issues that were considered and rejected by the learned single judge. He would further contend that the order of the learned single judge has been affirmed by the division bench, and would seek the dismissal of the petition with exemplary cause. I have given my anxious consideration to submissions made soon. The afore narrated facts are a matter of record. The notification issued, i.e. second in line, by the BDA becomes the subject matter of the challenge before the learned single judge, in the order of which is quoted supra. The learned single judge has clearly held that while constituting a committee and has clearly functioned out as to what the committee should do with regard to 983.12 acres of land which stood deleted. It is an admitted fact that the land of the petitioner comes within those 983.12 acres, which is now directed to be considered by the committee. The committee, in furtherance of the direction of the learned single judge, has issued a notice directing the petitioner to appear before the committee on 11/12/2024. You have not appeared?
I have appeared.
The learned counsel submits that the petitioners have appeared before the committee. The petitioners, having appeared before the committee and notwithstanding the aforesaid factors, have presented the subject writ petition in the garb of review or recall of an order that is passed after hearing them. The submission is that the BDA themselves, i.e. the SLAO of the BDA on inspection, had recommended that the lands of the petitioner should not form a part of acquisition. The learned counsel would place heavy reliance upon the said document dated 31/5/2012 to contend that the learned single judge has fallen in error in directing the committee to look into the aspect of 983 acres. The submission of the petitioner is noted only to be rejected. It is cost impose ಮಾಡಲಾ?
My lords, may kindly see.
ಒಂದ್ 2 ಲಕ್ಷ 3 ಲಕ್ಷ 5 ಲಕ್ಷ.
My lords, may kindly see paragraph.
ಏನ್ kindly see?
ಅಲ್ಲಲ್ಲ. My lordship may kindly see, my lords, in the second.
ನೀವೇ appear ಆಗ್ಬಿಟ್ಟು.
My lords, may
What
kindly.
is all this?
My lords, kindly see paragraph 2, my lords.
What paragraph 2?
Paragraph 2 ಅಲ್ಲಿ survey number 43/1 measuring 2 acres and 19 guntas and 43/3.
The petitioner.
My lords, may just give me
one
one.
ನಿಮಿಷ. The petitioner seeks to distinguish the submissions that he had made before the learned single judge, in which he was a party and being heard, to the submissions before this court now, contending that the submissions were made qua a particular property in a particular survey number and not this. The submission is again noted only to be rejected. The conduct of the petitioner, though, is reprehensible, of approaching the court all over again, challenging all over again, raising a challenge to the order passed by the learned single judge, is now stood affirmed by the division bench, notwithstanding the fact that he has been completely heard in the matter. A cost impose ಮಾಡಲೇಬೇಕಾಗುತ್ತೆ. Yes.
My lords, I have a genuine reason, my lords, to have filed the risk. My lords,
Your opening statement was you are not heard.
my lords, I'm sorry.
And
my
you
lords.
try to,
My lords, if I have made some
you
statement.
try to hair split that and say that it was qua other property.
My lords, may kindly bear with me, my lords, because my lords should not mistake me, my lords, that I've made a wrong statement. My lords, this survey number 83/2, which is a subject matter of this, my lords, it was not a subject matter of the writ petition final notification. My lords, therefore I said, my lords, that I was not.
983 acres ಅಲ್ಲಿ ಬರುತ್ತಾ?
ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಕಮಿಟಿ ಮುಂದೆ ಹೋಗಿ.
My lord, that's a different, but my lords, if your lordship is saying I made a wrong statement, I didn't make a wrong
You
statement.
said you have not heard.
My lords,
Sir,
I've not.
I don't think. I may
My lords,
I may forget, you may forget. Internet never forgets.
My lords,
ಇಲ್ಲ ಇಲ್ಲ ಎಲ್ಲ.
No, my lords, I have in fact pleaded, I have also challenged the earlier notification. I have not that, my lords, I have suppressed it. My lords, I said I was not heard with regard to this property.
This property ಅಂತ ಹೇಳೇ ಇಲ್ಲ.
My lords, I
I
may
was
not
not
have.
heard in the,
My
that's
lords,
why review or recall. I have a right of review, I right of recall
as
because I
regards
was not
this
heard.
property is concerned.
PONJ violation.
My lords, as regards this property, my lords. My lords, I said 983 acres of land, owners, my lords, was not heard, including me. That was my submission. My lords, I wouldn't have made a wrong submission or to suppress that fact. If I have not pleaded, my lords, in my writ petition, my lords, your lordship could enforce cost on me. My lords, I have pleaded
Yes.
about this.
In the light of the aforesaid reasons, only because it's Sampath, I'm keeping quiet.
My lords, obliged, my lords, but I have pleaded. my
The
lords.
learned, in the light of the aforesaid reasons, there is no warrant for this court to all over again consider the submission of the petitioners, which have all been considered, and the consideration of which has been affirmed by the division bench as well. This court would hold its hands in imposition of exemplary costs, which this matter appropriately deserved. Yes, finding no merit, petition stands rejected.
Obliged, my lords.
Next.
This subject site is, my lord, after receiving the amount.
ನೀವಿದ್ದೀರಾ?
Our lord, adding.
ಬಿಡಿ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
Please.
Child is not registered.
Registered.
Then it ಎಲ್ಲಿ?
Vachan is appear in the previous.
ಅಜಯ್ ಕುಮಾರ್ ಇದ್ರಲ್ಲ ಈಗ. Then at council, Ajay Kumar is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid council forthwith.
Interim order, my lord.
ಏನ್ interim ಮಾಡಿದ್ರೆ?
That they are, suppose if they are allotted to somebody, my lord.
ಆಗೋಗುತ್ತೆ, ಅದನ್ನೇನು interim ಮಾಡಿ.
ಆಗಿಲ್ಲ, allotment ಆಗಿಲ್ಲ, my lord. Still it is vacant, it is in possession of the petitioner, my lord.
Position ಇದ್ದೀರಲ್ಲ.
ಅಲ್ಲ, not to allot.
We'll take it on 2 weeks ಆದ್ಮೇಲೆ ಒಂದು Thursday ಕೊಡಿ. The petitioners, if in possession today, shall not be dispossessed
Achha.
till the next date of hearing. Yes.
Please.
7.
Covered, huh?
Yeah, cover. See, my lords, I have filed an impeding application.
Who are you?
My lords, I am the person, my lords, to whom the land has been allotted. My lords, this entire case, my lords, has got a checkered history. Where my lords,
No, you said
325.
it's covered by this.
It's
order.
covered, my lords.
It is
In
not
fact,
so. There are two reasons why, my lords, I filed my impeding application. The first reason, my lords, is that the survey number what the petitioner is
Your lordship
quoting, my
may-
lords, is
Instead of that matter, my lords, your lordship may take page number,
Allah.
page number 175, my lords. That went up to Supreme Court and.
Yavudu? Page 75.
Page 75, my lords, Annexure G. This order was confirmed by Honorable Division Bench.
All right.
Again, review was filed, review was dismissed. It went up to Supreme Court. Kindly take page number 91. It is confirmed. Now,
That's what is
in
happening
another
here.
series of matters, my lords, let me make my submission. In another series of matters, if your lordship take page number 111. 111, my lords, again, 5 matters were disposed of based on the orders of the Honorable Division Bench as well as Honorable Apex Court. In those petitions, my lords, KADB as well as the Alati, so claimed Alati has filed review petitions. The last 2 review petitions are filed by the Itasca, that is the present impleading applicant. Otherly, the findings, my lords, kindly take 129 in that order, my lords. In the review petition, kindly take 129, page number 129.
Yes.
Paragraph 10, my lords, in the bottom.
Yes.
Insofar as the review petition numbers 454 of 2023 and 455 of 2023 are concerned, these review petitions have been filed by the entity claiming to be an allotee of the portion of land subject matter of the acquisition, contending that they were not parties to the writ petition and as such review is sought for. The claim of allotee cannot be greater than the acquirer of the land and KADB, which has allotted the land. It is the actions of the KADB which has been dealt with by the coordinate bench, division bench, and Honorable Apex Court. Merely because a person is an allotee would not take away the defaults on the part of the KADB. The defaults of the KADB have been considered and inordinate delay by the KADB in requiring the acquisition to be quashed. The allotee cannot now seek for review of the order which is based on the earlier orders of the Honorable Division Bench, Honorable Coordinate Bench, Division Bench, Honorable Apex Court. Already the right of the allotee has been dealt in
No, it
Coordinate
is not
Bench's
so, my
decision, my
lords.
lords.
May make my submissions on this. That's one
Nothing.
may make 2 submissions.
No, no. Yes. Stalling petitions being disposed by this is not correct. And is not that new thing.
No, it is a new thing.
Of a kind of allotment that is already made is considered by the coordinate
Petitioner
bench.
is not even the land of the petitioner, my lords, or the name of the petitioner does not even feature in the acquisition.
Then that submission may be made by the KADB.
They cannot come to court.
I filed wakalat.
Now advocate has changed, my lords. 5 times they have taken time.
In the notification, their names are not find a place. There is no such extent also, that is not their case also. Therefore, my lord, I am only seeking short time to ascertain whether this falls within the area or not. That's the only question. I have prepared statement also. We have to file it, my lord, get approval, my lord. Their name does not find a place, my lord. If that is not their case also at all.
Where does your name figure?
Page number 6, my lords, I have stated specifically that.
Stated alla document illide.
Allah, I have stated that my name is not reflected on the
All right.
I have stated.
Then what is the order you want now?
No, my lords, they are interfering with my position.
Who is interfering?
The KADB as well as the Itasca people, my lords.
My lords, the entire land is in the possession of the government. The Lokayukta has taken note of it. My
Kindly
lords.
see.
No activity.
I show one more document, my lords. Only one more document.
ಅವ್ರಿಗೆ ಅವತ್ತೊಂದು ದಿವಸ ಅಕ್ವೇಷನ್ ದಿವಸ ನೋಡಿ ಅವ್ರ ಹೆಸರುಗಳು RTC ನಲ್ಲಿ ಇಲ್ಲ. RTC ಬಂದಿರೋದು ಆಮೇಲೆ 2010 ಅಲ್ಲಿ ಬಂದಿರೋದು ಅವ್ರು ಇವಾಗ
Position ಯಾವಾಗಿಂದ ಇದು?
ಇದು 2001 ಇದು
2007 and 8.
2007.
6 was the preliminary notification, 7 was the final notification.
Allotment ಯಾವಾಗ ಆಗಿದ್ದು ನಿಮಗೆ?
2006, my lords.
What are you doing there?
My lords, what has happened is that
Keeping the land as real estate?
No. My lords, there's an issue with regard to the way the allotment has happened, my lords. The entire issue is pending today before the Lokayukta, my lords. In fact, my lords, in my imperial.
So it is only a letter of allotment.
That agreement also has been entered, my lords, insofar as survey numbers. My lords, I have twofold contention.
No.
Similar.
You can't be allowed to contend unless you permitted to come in.
One more point.
Yes.
That's what my impleading
This total
application
extent
might
is
become
450 acres. only 325 acres is allotted to the impleading applicant. Our land falls in 125 acres, my lords. That is our case. We are not claiming their land.
ಅವರ ಹೆಸರಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ.
That's why we have not made them party.
ಹೆಸರಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಹೆಸರು ಕಾಣ್ತಾ ಇಲ್ಲ.
ನೀವು ಯಾವ ವಕಾಲತ್ ಹಾಕಿದ್ದು?
ನಾನೀಗ 6th or 7th ಹಾಕಿ.
All right. Yes, learned counsel, P.V. Chandrasekhar submits that he has entered appearance only recently and therefore would require 2 weeks' time to ascertain whether, to ascertain the issue in the matter. The learned counsel for the petitioner submits that the issue stands covered by plethora of judgments rendered by the coordinate benches of this court, observing that the right of the landowner cannot be overshadowed by the nebulous right of a allottee. The allottee has sought to file an impleading application on the score that he has, the company has been allotted land in the year 2006 and even as on date, there is no industry set up in the said. Yen madidira sir? Have you set up anything there?
No.
Have you set up, straight question, straight answer?
No.
Yes. And even as on today, there is no industry set up in the said land. In this said land, wait sir, will permit you. I am not disposing the petition. Has not set up any industry in this said land. But however contends that since the land now vests with the board, it is for the board to consider with regard to the claim of the allottee. The learned counsel, therefore the counsel for the respondent board shall steer clear the controversy with regard to the right of the petitioners qua the allotment or acquisition as the case would be.
So far.
This is the matter on 26th.
One more aspect.
I have sought for an execution of agreement of lease of saving and in that petition, there is an order of status quo with regard to the land which is being granted.
When did you seek?
I filed in the year 2013, and after which that came to be disposed of in the year 2019. And 19 my request was rejected, saying that the land, the issues pending for Lokayukta, that was challenged in the year 2022, and an order of status quo is issued by this court in a connected matter, which is a part of my including.
ಬೇರೆ ಕೇಸಲ್ಲೆಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಗಿ ನೋಟಿಸ್ ಕೊಟ್ಟು 34 ಅದೆಲ್ಲ ರೆಸ್ಯೂಮ್ಷನ್ ಎಲ್ಲ ಮಾಡ್ತೀರಾ, ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ವಾ? ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಅದ್ ಮಾಡ್ಕೊಂತೀರಾ? ಮತ್ತೆ ಯಾವ ಲ್ಯಾಂಡ್ ಬೇಕು, ಬೇರೆ ಯಾರು ರೆಡಿ ಇರ್ತಾರೆ ತಗೊಳಕ್ಕೆ, ಅದು ರೆಸ್ಯೂಮ್ ಮಾಡ್ಬಿಡೋದು ಅರ್ಜೆಂಟ್ ಆಗಿ. ಇಲ್ಲಿ 350 ಎಕರೆ ಕೊಟ್ಟಿದ್ದೀರಾ, ಏನು ಮಾಡಿಲ್ಲ, 20 ವರ್ಷದಿಂದ ಹಂಗೆ ಇದೆ. Moreover,
Lokayukta inquiry pending for more than 15 years.
So Lokayukta inquiry, they should not do anything, is it? That is why, that partisan stand they take whenever they want. Even otherwise Lokayukta inquiry pending iro ಕೇಸಲ್ಲೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. Resumptions have happened, everything has happened.
Similar matter, 4 petitions where they come seeking on the same ground. They have dismissed it with cost. In fact, 2 days ago, there was a matter listed before my lords, where NBW was not issued. NBW was issued, was not served. It is the same case, where they're going on saying that that land should be, the acquisition should be quashed, and they also they're not made us as a party. In fact, even the petition.
You are an allottee.
Those are the cases where compensation has been received. In my case, there is not even award, my lords.
ನಿಮ್ಮ ಹೆಸರೇ ಇಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ
ಏನು
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ,
acquisition ನಿಮ್ ನೇಮೇ ಇಲ್ಲ, ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಅವಾರ್ಡ್ ಇಲ್ಲ? ಆಮೇಲೆ
RTC ಎಲ್ಲ ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಅಂತ ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ, ನಮ್ದು ಇತ್ತು ಹೆಸರು, ಅವ್ರು ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ.
But your land is acquired?
Please, my lords, it is acquired. Let them clarify with regard to award also, my lords. That is the issue.
You permit everybody to hold the land as real estate. 20 ವರ್ಷ ಆರಾಮಾಗಿ ಇಟ್ಕೊಬಹುದು.
ಅವ್ರ ಪ್ರಕಾರ ಅವರೇ ಇದಾರೆ ಸ್ವಾಧೀನದಲ್ಲಿ, ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಹಾಕಿದ್ದೀವಿ.
No, I'm not talking about you, sir. Generally what the board does. No, we'll see, we'll permit you to argue. ಆಮೇಲೆ ನೋಡೋಣ. Yes.
Please.
IPF for the respondent. For petitioner lords, the matter raises of term note.
Memo of calculation versus memo of calculation.
Please.
The court has to pass its calculation.
That should have been done.
Ade correct.
Ad madilla.
Lordship, copy of a writ petition.
Kudi.
Proceed.
Petitioner to serve on the counsel representing the respondent requisite set of writ petition papers. List on next Wednesday.
Please.
Much open. Yen money salary na?
Arbitral award.
Let me, Lords, I was under arbitration, Lords, so sum was determined. According to me, I have paid the amount, Lord, but in installments.
Yes, Wednesday.
Please.
Copy ಇವತ್ತೆ ಕೊಡಿ.
I'll ensure that. Much open.
General award challenge. Say covered ಕೊಡಿ. Page number 111.
I filed wakalat for R2.
Triple one ಇದು ಎಲ್ಲಿದೆ ಯಾವ ತ್ರಿಬಲ್ ಒನ್ ಕವರ್ಡ್ ಎಲ್ಲಿದೆ
Annexure, please.
ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದಕ್ಕೂ ಕೋರ್ಟ್ ಕೊಡಕ್ಕೂ ಇದೆ
113 annexure J.
103
113.
Please.
ಸೇಮ್ ಮಾಡ್ರಿ
I filed wakalat for R2.
ಅವ್ರ ನೇಮ್ ತೋರ್ ಪಿ ವಿ ಚಂದ್ರಶೇಖರ್ ಫಾರ್ R2 ಅಂತ ತೋರಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಸೇಮ್ ಮಾಡಿ
The same terms may be incorporated. Terms may be incorporated.
ಸೇಮ್ ಟರ್ಮ್ಸ್ ಎಸ್ ಪೇಜ್ ನೀವೇ ಮಾಡ್ಬಿಡಿ ನಿಮಗೆ ಸೇಮ್ ಮಾಡಿ ಎಸ್ ನೆಕ್ಸ್ಟ್
10.
This case I appear for petition. At the outset, I seek a short adjournment, my lord, because I am running temperature. 18th or 25th?
We'll take it on 18th. List on 18th. CPC alwa idu?
CPC.
18th, yes. Pension.
Pension. Is a representative suit.
11.
Seek short accommodation, my lord. Lord, arguing counsel is.
Then special order ಯಾಕೆ?
My lord.
You are his colleague?
Yes. Kindly have it on Tuesday, my lord. He will be returning, my lord.
Notice ಮಾಡೋಣ ಯಾಕೆ ಬೇಡವಾ?
Sir, ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ last week ಅಲ್ಲಿ. My lord's order is there, my lord.
Oh, it's here. Secure instructions.
Yes, my lord.
%100% blind.
Yes, my lord.
Then why are you wanting time?
My lord, arguing counsel is not there. Hence, have it on Tuesday, my lord. Please.
List the matter on Tuesday in plenary hearing.
Please.
Yes.
Pay for petitioner.
12.
ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರು
Stay ಆಗಿದೆ.
ಸ್ಟೇ ಆಗಿದೆ ಅದರದ ಸಬ್ಜೆಕ್ಟ್ ಆಫ್
Tag this petition, same order, Chetan.
ಇಂಟ್ರಿ ಮಾಡ್ರು ಇದೆ
ಅದೆಲ್ಲ ಇದೆ ತಾನೆ?
ಅಮೌಂಟ್ ಇದ್ರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ
ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಅಲ್ವಾ?
ಇದೆ
50% ಡೆಪಾಸಿಟ್ ಅಲ್ಲಿ ಹೇಳಿರೋದು?
50 ಅಲ್ಲ, ಫುಲ್ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್.
Full amount. Subject to deposit of the entire amount.
4 lakhs ಅಂತ. 4 lakhs.
Yes. Next.
13.
Tag ಮಾಡಿ ಅದಕ್ಕೆ ಅದ್ರ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ. ಏನಿದೆಲ್ಲ?
My lord, forum number 57, my lord, actually petitioner's father, they filed forum number 50 way back in the year 1998. Annexure A, please, my lord. Thereafter, please, my lord, after lapse of more than 27 years, the application was not considered. Thereafter, the petitioner's father
What is
died.
form 57?
Lord, forum number 57, please, my lord, I filed at
Page?
Lord, I've produced the online copy, page 26. As it is uploaded in the website of the land records at page.
One moment.
Page 28 ali. Fourth, serial number 4th. ಅದು ರೆಡ್ ಹೆಡೆಡ್ ಅಂತ ಏನೋ ಬಂದಿದೆ, but there must be a mistake.
28 ಇದೆ.
28, the online. 28 ಅಲ್ಲಿ ಲೇಟ್ ಗಂಗಯ್ಯ ಅಂತಿದೆ. Mostly print ತೆಗಿಬೇಕಾದ್ರೆ there might have been some mistake.
Late Gangaya ಇದೆ.
Late Gangaya ಇದೆ. Petitioner's name is reflected in this particular portion. Please, my lord, I have referred the application number also in the petition to an extent. My lord, the application is not being considered by the
ಒಂದು ರಿಪ್ಲೈ ಕೊಡಕ್ಕೆ ಏನಂತ? ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ 2018 ಅಲ್ಲೇ ಹಾಕಿದ್ದೀನಿ.
$31,700 ಕರೆಕ್ಟ್, ಅವರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಿರೋದೇನೆ. ಲಿಮ್ನ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿತ್ತು, Final notification ಆಗಿರ್ಲಿಲ್ಲ. Whatever you have to pass orders. We'll close this.
Let them not dispossess, my lord.
If you are in possession, they will
My lord,
not
I am in
dispossess.
possession. What has happened, please, my lord, the
Till
KADB.
they pass orders on your.
My lord, what has, my lord, one submission. What the KADB, please, my lord, even they also communicated to the Tahsildar stating that so and so persons are in possession. And even at the time of the inspection, also, please, my lord, the joint inspection, which I filed at page number for a moment, at page 41, the joint inspection report also says that so and so persons are in possession and they have filed forum number, page 41 ನಲ್ಲಿ, last ಅಲ್ಲಿ. ಸರ್ಕಾರ ಎಂದು ನಮೂದಾಗಿರುವ ಬ್ಲಾಕ್ಗಳಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿ ದೊರೆತ ಮಾಹಿತಿಯಂತೆ ಮಂಜೂರಾತಿಗಾಗಿ ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಈ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು.
ಯಾವಾಗಿಂದು ಡೇಟ್?
My lord, this is dated, please, my lord, if I am not wrong, date illa, but it is at the instance of the, please, my lord, the Tahsildar and the KADB.
11/8/2021. That is final notification date.
Final, my lord, here the date is also not been reflected as per annexure 41.
ಯಾವ ಡೇಟ್ ಇದು?
ಅಲ್ಲ, ಡೇಟ್ ಅವರು ಹಾಕಿಲ್ಲ ಅವರು.
ಅಲ್ಲ, if it has reference to 11/8/21, it should be after that only.
Please, my lord, but there is no reference, but what?
Yeah, government should consider, is it?
Please, my lord.
My lord, form number 57 file ಮಾಡಿದ್ದಾರೆ. It is the government which should consider that.
We will direct them to consider.
Unless that, ಈಗ ನಮ್ಮ acquisition ಗೆ it will not cause prejudice.
ನಿಮ್ಮ acquisition ಗೆ ಯಾರು ಅಡ್ಡ ಬರ್ತಾ ಇಲ್ಲ.
Please.
Let them pass orders on the application that he has filed or consider their cases. Until such consideration, if they are in possession, don't dispossess them till you consider and communicate those orders. All right. The petitioners, then Eastern petition, what is it? Same.
ಎಲ್ಲ same.
Different petitioners?
Different petitioners, please, my lord, in respect of the very same village.
The conglomeration of these cases are presented before this court seeking a direction to the Tahsildar, the third respondent, Tahsildar, to consider the applications filed by them in form number 57. That's unauthorized occupation in accordance with law. The petitioners in all these cases claim to be in unauthorized cultivation of the respective scheduled properties that are found in each of the petitions. Accordingly, on the score that they have been in possession or in cultivation of the said properties, said lands, have sought for regularization of the said unauthorized cultivation in accordance with law by filing form number 57. By then, the form number 57 on 13/7.
In few cases, there are 50 also. In few cases, there are
form number 50 and 57. That is form to what? Land grant rules.
Land grant, form 50.
Form number 50 appended to the land grant rules, which concerning regularization of unauthorized cultivation. The learned counsel for the petitioner submits that the said application, both in form number 50 and 57, were filed before the Tahsildar on 13/7/2021. This is, the date is sandwiched between two dates. One, the preliminary notification so issued, which concerns the lands of these petitioners for the purpose of acquisition, and the beneficiary being the fifth respondent, KIDB. And the final notification, which is issued on 11/8/2021. The grievance of the petitioners is that they are in possession of the possession of the lands in all these cases, and the Tahsildar has not considered their cases for regularization of unauthorized cultivation or any other benefit that the statute would ensue in favor of these petitioners. The learned AGA would submit that if reasonable time is granted, the applications of the petitioner would merit consideration strictly in consonance with law, as the matter has to be placed before the land grant committee, committee constituted under the land grant rules, and the committee will have to take a decision. The learned counsel for the petitioner, as observed herein above, submits that they are in possession/cultivation of the land. In the event they are in possession and cultivation of the land today, till a decision is taken by the third respondent, again, shall not be dispossessed. The learned counsel for the board submits that their acquisition should not be dealt with in the case at hand, as it is only for the consideration of the application. The submission would merit acceptance. It is made clear that this court has not pronounced upon the acquisition process, either the preliminary notification or the final notification. It is a direction simpliciter to the Tahsildar third respondent to consider the cases of these petitioners qua their respective applications filed strictly in consonance with law. ಅದು ಬರೀರಿ ಮತ್ತೆ
ಅಲ್ಲ ಅದು ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಲ್ಲ, ದಟ್ ಇಸ್ ನಾಟ್
ಅನಾಥರೈಸ್ಡ್ ಕಲ್ಟಿವೇಶನ್ ಅದು ಬಿಟ್ಕೊಟ್ರದು ಯಾರು
ಅಲ್ಲ. ಸ್ಮಶಾನಕ್ಕೆ graveyard my lord entire extent is not 30 acres.
The learned the third respondent shall consider the case of the petitioners within 2 months, within 8 weeks from the date of receipt of the copy of the order, and communicate the decision taken to each of the petitioners in these petitions. All other contentions would remain open.
One submission.
ಹೇಳಿ.
One submission, my lord. I may be reserved with the liberty to proceed in accordance with law, if at all I.
ಅವ್ರ ಕೇಸಲ್ಲಿ ನೀವು ಆರ್ಡರ್ ಹೆಂಗ್ ತಗೊಂತೀರಾ?
No, hangala, because I've been restricted not to dispossess them.
For 8 weeks ಅಷ್ಟೇ. Yes.
That may be kindly be.
8 weeks, within 8 weeks, till the decision is taken not to dispose ಅಷ್ಟೇ ಹೇಳಿರೋದು.
My lord, and my lord, liberty my lord in favor of the petitioner if arises, please my lord to challenge the notification.
All contingencies left open ಅಂದಿದ್ದಾರೆ ಅದಕ್ಕೆ. Yes.
14.
Writ of mandamus to consider, my lords.
Respondent number 2.
Petitioner is before this court seeking the following prayer. The petition hurts once. An alternate site.
Alla.
Marginal land.
The petitioner registers a claim for allotment of a site in terms of his representation dated 30/5/24, 18/9/24 and 22/11/2024. The representations are for the purpose of allotment on account of the acquisition of the nim land acquire agide.
Acquire agide, ಅದಕ್ಕೆ compensatory ಕೊಟ್ಟಿದ್ದಾರೆ. In the on the northern side there is one small portion, my lords. ಅದನ್ನು ಕೊಡಿ ನಾನು amount ಕಟ್ತೀನಿ.
Land which has remained post acquisition. The learned counsel for the respondent board ಬಿಡಿ ಏನಾಯ್ತು. Learned counsel for the respondent, second respondent board submits that if reasonable time is granted, the representation of the petitioner would be considered strictly in consonance with law and appropriate orders would be passed. In that light, I deem it appropriate to dispose the petition directing the respondent board to consider the aforesaid representations of the petitioner in consonance with law and pass necessary orders thereon and communicate the orders so passed by the petitioner, by the board. Since the petitioner is now an octogenarian, I deem it appropriate to direct the board to consider the representation within an outer limit of 8 weeks and pass necessary orders in accordance with law, if not earlier.
15.
Hard sounds on that. You notice sound is there?
I already filed the
Makalat.
the previous date offering last year. Yes, my lord. After receipt of the order passed with this.
Oh, receipt, not today, always. Yes.
The petition of law. Lord, here the final, after the final notification, the award is passed in 2017. Draw your lordship attention, page number 44.
Oh, the 2017 award will.
Page number 44, my lord.
You are in possession?
Yes, my lord, I'm in possession, my lord.
Learned AGA is directed to accept notice for the
Here in
respondent.
page number 44, they say that the award, the compensation which the board has.
All right.
Take notice.
Board ga?
Board.
Board of BDNA.
Board.
Learned Counsel Ramakrishna.
See.
C. Ramakrishna accepts notice for the respondent board petitioner to serve set of papers upon the aforesaid counsel. Learned AGA for the first respondent. If the petitioners are in possession today, they shall not be dispossessed till the next date of hearing.
Lord, is also covered by the judgment, my lord.
Yes, list on 26th. Consider representation.
Yes, because making submission from the
9/6, my lord, sir, they have issued one, my learned friends heard the copy today. But on 9/6/2025, they have issued one endorsement saying the procedure what they have followed. But that is insofar as, my lords, all other landowners. My grievance is, my lords, how they have given it to private respondent as well. Let them put it on record.
My lord, one submission, my lord.
What is the?
My lord, there are two prayer, my lord, in the mandamus. The one is, my lord, regarding the third respondent is concerned, how the FAR has given by the.
Bharatiya city.
Yes,
yes, sir.
Yes. And the, my lord, the award is concerned, my, we have given the reply, my lord. And the other FAR is concerned, my lord, it comes to the planning section, we have forwarded to the planning section. Within 10 days, my lord, we will give the. Please.
Don't worry, nothing of yours is taken away now.
Regulation 7.2. Therefore, I don't have.
Your lordship.
The learned counsel for the petitioner submits that the counsel for the BDA has now handed over an endorsement dated 9/6/2025 and would challenge madbeka idna.
Idan challenge madbeka.
And would seek liberty to raise a challenge to the same. Insofar as the earlier direction of production of the procedure adopted to grant certain benefit to third respondent.
Yes, yes.
Third respondent is concerned, the council would submit that if 10 days time is granted, the records would be placed before the court.
We dispose of with the direction to the 10 days to furnish the.
We'll see.
Kodalla.
Yes, ma'am.
Next. List on 26th.
Same stage.
Huh?
Same stage.
List on 26th.
I may
In
also
final
be
hearing.
I may also be permitted to file.
Yes, next.
I'll file it in the counter.
Registry, yes.
Great.
BWSSP covered. Same ಅವ್ರಿಗೆ ಗವರ್ಮೆಂಟ್ ನೀವು ಬಿಡಿ ಆಗಲ್ಲ ಸರಿ BWSSP close disposed. Yes.
Admission 18.
In-laws, 304B.
In-laws.
Yes, my lord.
304B.
304B, my lord, that first petition is aged about 83 years. Allegation is, my lord,
Granted stay ಅಲ್ಲ.
stay, my lord.
Respondent served.
Served, my lord, unrepresented. He is aged about now 85 years. At the time of granting interim order, 83 years, my lord. And their allegation is, my lord, the 83-year-old.
That's why I have granted stay. But ಅದು 498 ಅಲ್ಲ 304B.
304B, that is specific case of the prosecution, 304B, my lord.
82. What about the second petitioner?
Second petitioner, she was not staying with the deceased and accused number 1, my lord.
Second petitioner is the mother-in-law?
Not mother-in-law, my lord. Sister of the accused number 1. She was in, at the time of marriage and after subsequently 1.5 year, my lord, she was in Delhi. And after when the accused number 1 was not well, then the accused number 1 called to the accused number 3, come back to Bangalore, my lords.
What is the death note?
Death note, my lords, she, in death note, she mentions that, my lords, I have committed suicide, I am committing suicide because of my health issues.
Husband.
She has not taken any reference of husband, in-laws, nothing, my lords. And the death note, my lords, they given with the husband to the police officer.
That is page 10 of the
petition, my lords.
ಅಲ್ಲ ಏನು affidavit ಹಾಕಿದೆ?
Yes, my lords, we have filed affidavit also, and we have given that death note to the police officer.
Respondent is represented, is it?
No, my lords.
But this affidavit is filed by you?
Yes, my lords. Even an earlier occasion also, my lords, we have filed detailed affidavit of accused number 1. We have given death note to the police officers and they have thrown it to the dustbin, my lords. And that, to that effect, we have filed detailed affidavit before your lordship, my lords. And my lords, we have given with the tower locations of the death notes, my lords. Now, ಬೇರೆಯವರೇ ಕಳಿಸಿರೋ this. In the morning at 5:30 PM, 5:30 AM.
Stay to ilwala. No, let Jagdish come.
Yes.
You should be in that court. ಸಾಯಂಕಾಲ ಬರಕ್ಕೆ ಹೇಳಿ 3:30. Where is Chowda sir?
I am not in. ಇದರಲ್ಲಿ engage ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. He's not in
He is
town?
on the way, my lords.
On the way?
Chowda sir is on the way, my lords. Jagdish sir is in Kodala.
Jagdish ಬರಕ್ಕೆ ಹೇಳಿ. I'll take it at 3:30 and 3rd.
19,
For second respondent of occasion, you had asked for the trial court records to see if the affidavit is forthcoming with the private company.
ಬಂದಿದೆಯಾ madam? TCR ಬಂದಿದೆ.
My lord, there is no signature of a complainant himself, in the complaint.
ಯಾವುದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಇಲ್ಲ.
Complaint alone. Verifying if it is not there. Complaint signature only is not there. The entire issue boils out of, my lords, the apartment.
Those two words in the
Nothing, my lord.
summary of the charge sheet is creating the problem.
My lords, but PCR may be looked into. There is no such allegation in that one.
Where is the PCR?
My lords, please.
26, my lords, 26, in the first petition.
What boils out, my lords, at para number 8, the last,
One ನಿಮಿಷ. I'll just TCR is here.
please.
Page 28, my lords.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಎಲ್ಲ?
Please, my
ಏನ್ ಗುಂಡಿ ತೋಡಿದ್ರಿ?
Rainwater harvesting was not there.
My lords, now it's a
You are,
standalone.
who are you all?
My lords, I'm a contractor, my lords. who
ನೀವು
did the
ನೀವು
I'm the association president. Now, what BWSSB mandates is that we have to dig
Rainwater harvesting.
rainwater. Now, even they have filed a suit against that. They have filed a suit before the city civil court restraining me. They don't even have an injunction in that suit, my lords. After filing of that suit, failing of that injunction, they filed this complaint.
Own statement by the complainant.
In the para 8, they said that, my lords,
13,323.
rainwater harvesting was there.
There is no affidavit.
No, my lord, kindly see, I have filed the affidavit stating this one statement by complaint by way of affidavit along with the
Oh,
PCR.
13,323 ಅವತ್ತೇ ಆಗಿರೋದು.
Same
All
day,
right.
I have filed the affidavit stating that's one statement.
It's here.
So, Next,
That is there.
Para number 8.
yes, my lord. We have filed the affidavit instead of one statement.
ಅದಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ.
Please, yes.
ಕಮಾನ್ ಮೆರಿಟ್ಸ್.
Para number 8, my lord.
ಯಾವ್ದು ಪ್ಯಾರಾ 8?
Para 8 of the PCR.
In the petition, it's at serial number, page number 28.
The last
Page number 20.
lines, my lords, is what they say. In the complaint question them, stating that when there is a existing rainwater harvesting pit in the southern side, why do we need another rainwater harvesting pit? The accused number 1, 2, 3 started abusing this once. Not their grievance.
You are the association, you are the contractor.
Please, I have done the work.
ನಿಮ್ ಮನೆ ಮುಂದೆ ಮಾಡ್ತಾ ಇದ್ರಾ?
No, we have not filed the complaint against the association, my lord. Individual capacity, we have filed the complaint. On the western side of my flat, my lord, I am staying in the ground floor. There, the petitioner here in my lord she is staying in the third floor, my lord. In front of my house, in the western side, they have digged the pit on the ground that they want to put a rainwater harvesting pit, my lord. There is a already situated rainwater harvesting pit on southern side of my plot, my lord. So therefore, I have questioned them on 1/3/2023, my lord. In front of laborers, my lord, in front of laborers, they have stated that in the garden area.
ಅದು ಓದಕ್ಕೆ ಹೋಗ್ಬೇಡಿ ಬರಲ್ಲ.
ಅಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಏನಂತ ಅಂದ್ರೆ filthy language they have used. ಆಮೇಲೆ in the further statement also, page number 46, my lord, the police also recorded my further statement. In 46 also, my lord, I have stated ಅದು ಹಿಂದಿ ಹಾಡಲ್ಲಿ ಹಿಂದಿ ಹಾಡ್ ತರ ಒಂದು ಸಾಂಗ್ ಆಡಿದ್ದಾರೆ. ಯಾಕೆಂದ್ರೆ ಅಬ್ಸೀನ್ ಸಾಂಗ್ಸ್ ಬರ್ತದೆ 294 ಬಂದು obscene songs, imprisonment for 3 months.
Does
and
not appears
fine.
in the PCR. All of the sudden it appears in the
No,
PCR.
no, no,
It's
in-
not because of that.
In my further statement recorded by the police, my lord,
Songs come in the further statement.
further statement ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು.
They forgot in the PCR.
In the complaint also, my lord, I have clearly mentioned what is happened on 1/3/2023 and 28/2/2023, my lord. There is serious allegation against them. This is a matter of trial. And in the petition, they have stated that in the public place, they have not sing the song in the complaint. But I have stated in the garden area, my lord, garden area come under the public place. Therefore, garden area, in the garden area, my lord.
Correct, sir.
In front of laborers, they have insulted me, my lord.
ನೀವು ಥರ್ಡ್ ಫ್ಲೋರ್ ಇರೋದಾ?
No, I am staying in the ground floor, my lord.
Ground floor.
ನನ್ ಮುಂದೆನೆ dig ಮಾಡಿದ್ದು. ಹಾಗಾಗಿ I objected, I filed the suit and I have taken the injection order also. They have stated, I have not taken any injection, madam. I have stated I have taken the injection order before the city civil court.
So because they sang a song, according to you, was obscene.
Obscene song, they have sung.
There are two
And
judgments
they
of
have
your
given
lordship.
life threat to me, my lord. 506 also attacked.
Life threat.
Yes, ma'am.
Contractor association members.
Contractor ಅಲ್ಲ ಇವರು
Life
ಮಾತು
threat.
ಕೇಳ್ಕೊಂಡು ಅವರು ರಿಟರ್ನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅದರಿಂದ.
Page 118, my lords, is the water bill where the my lords,
My lord.
the fine has been levied for not having my lords rainwater harvest. That's the reason my lords has a duty.
ಬಿಡಿ.
There's two judgments. It's one of the Supreme Court and one of.
294 ನಾನೇ ಒಂದು ಬರ್ತಂಗಿದೆ.
Please.
294 ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ ಅಂದ್ರೆ 504, 506 ಅಂತ ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ ಆಸ್ ಪರ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಅಲಿಗೇಷನ್ಸ್.
294 ಯಾಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ 294 ಇದೆ.
294 ಹಾಕಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಗಾರ್ಡನ್ ಏರಿಯಾ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀವಿ. ಇನ್ ದಿ ಗಾರ್ಡನ್ ಏರಿಯಾ ದೇ ಸಿಂಗ್ ದಿ ಸಾಂಗ್ ಅಂತ.
In the garden, why did you sing in the garden?
I have not. The charge sheet does not disclose
No,
that,
no,
my
no,
lords. There further
charge sheet ಅಲ್ಲಿ ಇದೆ.
there are no witness statements also with respect to that.
Yes. ಇದು PCR ಇಟ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಅಫಿಡವಿಟ್ ಇದೆ.
ಅಫಿಡವಿಟ್ ಇದೆ.
Heard reserved.
Great.
Yes.
What song did you sing?
ಪರ್ಸನಲ್ ಗ್ರೆಡ್ಜ್ ತಗೊಂಡು ಈ ತರ
Personal grudge song.
ಯಾಕೆಂದ್ರೆ ನನ್ನನ್ನ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರು ಮಾಡಿಲ್ಲ.
Personal grudge ಸಾಂಗ್ ಇದೆಯಾ?
ಪರ್ಸನಲ್ ಇಲ್ಲ ಪರ್ಸನಲ್ ಗ್ರಿಡ್ಜ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ನಮ್ಮ ಮೇಲೆ. ಯಾಕೆಂದ್ರೆ ನಾನು ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಇದ್ದೇನೆ, ಅವ್ರು ಥರ್ಡ್ ಫ್ಲೋರ್ ಇದ್ದಾರೆ. ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರು ಮಾಡಿಲ್ಲ ನಮ್ಮನ್ನ. ಬೇಕು ಅಂತ ಪರ್ಪಸ್ ಆಗಿ
going on between us and them because of the fact that they're causing a nuisance with the
No,
pets,
no.
stray dogs. That's that. There's a legal notice.
Stray
They have
dogs,
stray
correct.
dogs. There's a legal notice to which they have replied
You feed the stray dogs.
in the public premises.
No, ma.
That
That
is
is
not
why
nuisance.
ಅಲ್ಲಿ everybody has a problem in the apartment
Apartments.
complex. Well, that's the defense. If you feed stray dogs in front of everybody's house.
No, my lord, I have not done.
Not only
all those
feeding, my
things.
lords, they are
And I
accommodating
have
the
denied
street
that.
dogs in the apartment.
Maybe that in ಅವ್ರ ಮನೇಲಿ ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ.
Not in their vicinity, my lords, in the common passage.
Common passage. And there's a legal notice to that effect which they have replied to.
In that aspect, they have not lodged any complaint, my lord. Only they have taken.
ನೀವ್ ಯಾಕೆ ಸುಮ್ನೆ ಇದ್ದೀರಾ?
Let them lodge the complaint.
ಅವಾಗ ನೋಡ್ಕೊಂತಾರೆ.
We will fight it.
All right. Yes, deserved.
20.
Allegation of false promise to marriage as well as inducement.
ಯಾವಾಗ ಸರ್ವಾಗಿದೆ ನೋಡಿ ರೆಸ್ಪಾಂಡ್.
Auto survival.
You will marry now? Why?
ಇಲ್ಲ sir, false promise will. It's a
Promise will.
consensual. False promise ಮಾಡಿಲ್ಲ sir, promise ಮಾಡಿಲ್ಲ. There is no
False promise ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ,
Correct
promise
promise
ಮಾಡಿಲ್ಲ.
10-3?
24. And it is arising out of PCR ಮೇಲೆ.
PCR.
ಹೌದು.
ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಹೌದು.
The complainant is served on 10/3/2025. This court on, last one, this court on 23/1/2025 by a detailed order had granted an interim order of stay following the judgment of the apex court. The complainant is complainant, those served on 10/3/2025, has chosen not to appear before this court. The issue is with regard to the offense of rape by the petitioner by the first petitioner on alleged false promise of marriage. The learned counsel for the petitioner submits that there are consensual acts between the first petitioner and the complainant for over 2 years, where 2 years of relationship. Such consensual acts would not make out an offense for rape, is the submission of the learned counsel for the petitioner. The issue in the list stands answered by plethora of judgments rendered by the apex court particularly the one that is rendered on rendered in 2025, as reported in 2025 SCC Online SC, page 1301, where the apex court was examining the issue of a consensual relationship for a period of 1 year to become an offense of rape or otherwise. The case at hand projects a consensual relationship between the complainant and the respondent, second respondent, for over 2 years. Therefore, there is no warrant for an offense under section 376(2)(n), which deals with repeated rape, to be alleged against the petitioner. In the light of the absence of the petitioner, after having been served, I deem it appropriate to grant one more opportunity to the petitioner, to complainant, to get herself represented or appear in the therefore list the matter next week, next Thursday. Barlilla and other final order. Yes. ಅದು 741 ನಂಬರ್ ಕೊಡಿ ಚೇತನ್. Citation 2025 SCC Online SC 741 741.
Lord, there's a written submission and
Yeah.
yes. Lord, what has happened in this matter is
yes, sir.
The respondents had filed 4 suits. I had filed 1 suit. In the suit filed by me, the suit came to be compromised, and the terms of the compromise inter-alia provided that they will withdraw all the 4 suits. 3 of those 4 suits were withdrawn. The 4th suit was not withdrawn. So, my lord, I filed a memo in the pending suit saying, in view of the withdrawal of the other 3 suits, this also has to be withdrawn. My lord, even as that was pending, the suit came to be dismissed.
Dismissed on merits?
No, dismissed for default. Now, the advocate who is representing the plaintiff took upon himself to file a miscellaneous petition without the signature of the parties and examined himself as PW1 and sought for restoration. Even in those proceedings, my lord, a memo came to be filed by the plaintiffs saying we don't want to prosecute this for the reason that the matter, the dispute, the list between the parties has stood resolved earlier. The memo is rejected and the miscellaneous petition comes to be allowed, against which, my lord, I have now filed this CRP before your lordships. Now, even as this CRP is pending, there is a memo that is filed by the plaintiffs, that is 2 and 3, who were, one of them was a minor at that time, represented by his mother. Please look at the memo that is filed on 15/3/2018, because respondent's memo is a complete answer to this whole CRP being allowed. Please have a look at it, my lord. It's a memo dated 15/3/2018, and it reads as follows. The third respondent submits, my lord gets that.
Page, sir.
There's a memo dated 15/3/2018, filed by the
one moment. Yes.
It starts by saying, my lord, the third respondent. My lord gets that?
Yes.
The third respondent herein submits before this honorable court that he, along with his uncle, who is the first respondent, and his mother so-and-so, who is the second respondent, had filed a suit bearing OS number 7295 of 2002, seeking for declaration that they were the absolute owners of the suit scheduled property and for possession against the petitioners with respect to various survey numbers at so-and-so. Third respondent was a minor at the time of initiating the said suit, and he was duly represented by his mother, the second respondent, as next friend. The third respondent submits that when the suit so-and-so was posted for evidence of the plaintiff, the suit came to be dismissed for non-prosecution on so-and-so. It is submitted that the advocate appearing on behalf of the plaintiffs therein had, without our consent or instructions, filed miscellaneous petition number so-and-so seeking to restore the suit in so-and-so, and the same was pending consideration. While things stood thus, petitioners filed a suit bearing OS number so-and-so against so-and-so, who is the so-and-so, and represented. The third respondent submits that the suit in OS number 496 of 2008 was compromised between the parties herein and all other interested persons under a compromise petition dated so-and-so. It is pertinent to mention here that the third respondent, who was the 8th defendant therein, was duly represented by his mother, 7th defendant, and the second respondent herein as his next.
Now, notwithstanding all this, the suit is restored?
Yes, Suit is restored. The mother and son come before this court. There is an order passed by this court saying that the guardian advocate representing is to be discharged and further not to appear on those behalf at all. This is all orchestrated, my lord. Now your lordship may come to my list of dates. The respondent's name, my lord, in this proceeding is Lucky Ali. If this ultimately the CRP is allowed, it will become unlucky for him. This is a gross abuse of the process of court. Please have a list of dates I have produced, my lord. Along with the list of dates, it was filed on 16/9/2021. Along with that, there are two sets of documents that I have filed. One was on 10/1/2014 and another on, if your lordship looks at page 2 of that, second page, highlighted portion, 10/1/2014 and 11/1/2017, two sets of documents. Your lordship may read this with that.
I am holding this list of dates, 21/9/2021.
Correct.
In
Other
that page 8,
ಇಲ್ಲ ಅದರಲ್ಲಿ ಅದರ್ page 2 ನಲ್ಲಿ this list of dates may be read with second paragraph ಅಲ್ಲಿ
yes
10 the petitioner has produced certain documents in the course of hearing by memo dated 10/1/14 and 11/1/17.
yes
Likewise, respondents have produced certain documents along with memo dated 8/2/2017. So this may be read with that is all I'm saying. Anyway, your lordship may, because in the third column I have given the memo reference, that's why.
all right.
Lord, 1991, my lord, I purchased various lands in various survey numbers. 93, my lord, possession of those lands was interfered by the respondents, and therefore, my lord, I filed two suits.
Yes.
One was OS number 6315 of 93 and 338 of 93. Now, these two suits, my lord, your lordship may look.
Ended in a compromise.
Ended in a compromise. Please have a look at it under the memo dated 11/1/17, my lord. Page 142.
Yes, one moment.
My lord gets that.
8 to 17 is there. 10 to is there.
11/1/17 ಅಂತಿದೆ. There are 164 pages in that memo. Serial number 1 to 12 ಅಂತ ಇದೆ.
164 ಇರೋದು 8 to
8/2 ಅಂತಿದ್ಯಾ?
17 yes.
ಅದರಲ್ಲಿ page 142 ತಗೊಂಡ್ರೆ 6315 of 93.
Yes.
My lord gets that?
Yes, yes.
It is filed against the respondents.
Yes.
And your lordship sees at page 5, 146, suit is for declaration and injunction.
Yes.
In respect of the very same properties. And in the order sheet, my lord, your lordship will see at 153. That is the compromise petition that is filed. 154 ali record the compromise. The suit may be decreed in terms of the compromise.
So both suits end in compromise.
Both suits ended in compromise. Amele, notwithstanding this compromise, my lord, they filed 4 suits against me. That your lordship will get at item number 3. Notwithstanding the compromise, the sons of Muhammad Ali and family members filed suit for declaration of ownership, challenging the alienations being in violation of the trust and possession and injunctions. Those suits came to be filed in OS number 7295, 7296 and 7297 of 2002. The suits, my lord, I have produced at pages 1 to 31 of my memo dated.
Yes, 10/1/14.
Yes. Then I filed a suit at page item number 4 in OS number 496 of 2008. That was OS number 496. Then your lordship sees that 496 of 2008 came to be compromised at page 81 of this memo dated 10/1/2014. Please have a look at 81.
Compromised.
ಅದರಲ್ಲಿ ಸುಮಾರು ಜನ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ the compromise, there were several compromise petitions at different dates. ಅವ್ರು ಯಾವ್ಯಾವಾಗ ಬಂದ್ರು ಅವಾಗ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Yes.
Please, the compromise petition starts at, please have a look at page 91, my lord.
Yes.
91.
OS 7295 was dismissed.
No, it starts at 81. This is the comprehensive suit 496 of 2008.
Yes.
And your lordship looks at the same cause title. The second defendant, my lord, is the first respondent here. Maqsood Ali.
Maqsood Ali. Yes.
Maqsood Ali. And your lordship will see the minors are there, my lord, at 82.
Yes.
Now look at 91, my lord. 91, paragraph number 20. Both plaintiffs and defendants 1 to 6 submit that out of the said suits in OS number 7295 was dismissed for non-prosecution. My lord gets that. End of. And miscellaneous number so and so is pending for consideration. Both plaintiffs and defendants 1 to 6 submit that apart from filing the said suits, 15 defendant had filed P-miss number so and so, etc. Then 22, both plaintiffs and defendants submit that in view of the long pendency of disputes between the plaintiffs and defendants and in view of the friends so and so, following terms and conditions. Please look at B. Second defendant hereby agrees to withdraw the petition filed in miscellaneous number so and so, which is sitting on the file of the Honorable Citizen. And your lordship sees his signature at the bottom, my lord. Maqsood Ali, there are 92.
Yes.
Then your lordship would kindly see in consideration for his withdrawing that and under this compromise, he gets certain lands, which your lordship will get at E. The plaintiff submits that by virtue of the withdrawal of the said suits and petitions in pursuance of the defendant filing the above compromise and declaring plaintiffs have agreed to transfer 4 acres of land in so and so, situated at so and so as compromise schedule H property. Does your lordship get that?
Yes, yes.
Then F, plaintiffs have agreed to transfer the compromise petition schedule property and the same is free from all types of encumbrances. Plaintiffs have agreed to transfer the said 4 acres in the name of the defendant number 2 herein for himself and on behalf of the said children, defendants 3 to 6 in the above suit. He takes this property, he sells this property, enjoys the money, but doesn't withdraw the suit. Similarly, my lord, there are other compromise petitions also. I don't trouble your lordships.
Yes.
Then, my lord.
But what concerns miscellaneous petition 850 is only this.
Only 7295 of 2. The other 2 have been withdrawn. That I'll show your lordships. Your lordship may ask me a question. Averdu withdraw agidakke yenide anta. That your lordship will kindly take along with this memo, my lord. At page 7. This list of dates that your lordships are seeing.
Yes.
Please look at page 7, my lord. I have produced 4 documents. Does your lordship get that?
Yes.
Please look at page 8, 7297 of 2.
Yes.
Adanna withdraw ಮಾಡ್ಕೊತಾರೆ. At 15, your lordship will get. Undersigned advocate for the plaintiff submits that in view of the compromise being entered in OS 496 of 2008, be pleased to dismiss the suit as settled out of court. Page 15, I'm reading, my lord.
Yes, I've
then
seen.
7296. Similar memo is filed, my lord, in 7296 also.
Yes.
Page 18.
Yes.
My lord gets that?
Yes.
ಈ 7295 ಉಳ್ಕೊಂಡ್ಬಿಡತ್ತೆ. ಯಾಕೆಂದ್ರೆ ಅದನ್ನು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿರೋರು ಏನೋ ಅದು ವಜಾ ಆಗೋಗಿದೆ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್. ಅದಕ್ಕೆ ಮಿಸ್ಲೇನಿಯಸ್ ಅಂತ ರೆಫರ್ ಮಾಡ್ತಾರೆ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ನಲ್ಲಿ. ಈಗ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ದೇ ವಿಲ್ ನಾಟ್ ಟ್ರೈ ಟು ಚಾಲೆಂಜ್ ದಿ ಕಾಂಪ್ರಮೈಸ್ ಇನ್ 496. ದೇರ್ ಇಸ್ ಅ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್. So they file a RFA before this court. Your lordship would kindly take that 8/2/2017 off.
Yes.
Page 1, my lord. It is RFA number 154 of 2009. Page 1, my lord.
I am holding memo dated 8/2/2017.
Adralli first document is RFA 154 of 2009.
No, first document is the objections filed.
Illa.
Innonde idea. So many memos are here.
The same place where your lordship saw the compromise in 6315 and 338 of 93.
1 minute.
First document I showed. ಏನಾಯ್ತು ಅಂತ ಕೇಳಿದ್ರಿ, ಅದು ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ.
RFA ಏನಾಯ್ತು?
RFA ವಜಾ ಆಯ್ತು. ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ಮೇಲೆ ನೀವು ಅಪೀಲ್ ಹಾಕೋ ಹೋಗಿಲ್ಲ ಅಂತ ಅಲ್ಲ, ಅವನ್ನ ತಾವು ನೋಡ್ಬಿಟ್ರೆ ಬೆಟರ್. first to compromise ನೋಡಿದ್ರಲ್ಲ 6315 and 338 of 93 page 142.
So many memos here.
I know that 142 ಅಂತ ನೋಡಿದ್ರಲ್ಲ ತಾವು page 142 onwards. I think your lordship flagged it.
All right, RFA is dismissed, tell me.
RFA is dismissed. Your lordship should see the RFA and the order that is passed on that.
Hmm. Minimum papers ಇದೆಯಲ್ಲಿ ಕೊಡಿ.
ನೋಡಿ ಒಂದು ಸ್ವಲ್ಪ help ಮಾಡಿ court. Can I just assist the court, my lord? My colleague will
Sure. RFA 154 of 2009, all right.
just have a look at what is the statement that is made at paragraph. It is submitted that aggrieved by the judgment and decree passed after the cause title, my lord.
Yes.
It is submitted that aggrieved by the judgment and decree passed on 14/11/2008 in OS number 496 of 2008, partly decreeing. Therefore, this is filed anta. The name of the advocate your lordship will get in paragraph 3. It has some bearing. That's why your lordship may just make a note of it. And on 11/10/2010, in fact, there is a memo that is filed withdrawing this as not pressed.
Yeah, RFA.
RFA. And therefore it comes to be dismissed. There's an order passed by the court on 11/10/2010. Does your lordship have that?
Yes.
Appeal is dismissed as not pressed. Therefore,
Dismissed as not pressed.
dismissed as not pressed.
Yes.
So 496 of 2008, it becomes final. Lord, I'm sorry to trouble your lordships again. This memo for 8/2/2017 would just, if your lordship may kindly have a look at that.
Yes.
ಸಿಕ್ತಾ?
8/2/2017 ಇದೆ.
ಅದರಲ್ಲಿ RFA ಇದೆಯಾ ಅಂದೆ?
RFA ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಅದರಲ್ಲಿ page 34 ಏನಿದೆ?
ಒಂದೇ ನಿಮಿಷ.
Conveyance deed ಇದೆಯಾ?
Page 34 ಅಲ್ಲಿ there's some order.
ಅಲ್ಲ, is this a memo? Is your lordship looking at a memo? Your lordship is looking at some objections.
So objections, memo 8/2/2017.
ಈಗ ತಾನೇ ತಾವ್ ನೋಡಿದ್ರಿ ಅದಕ್ಕೆ. In fact, ಆ ಕಡೆ ಏನಾರು ಇದೆಯಾ ಅಂತ.
Which is that memo? 8/2/2017.
I said 11/1, your lordship said ಇಲ್ಲ 8/2 ಅಂತ. So we'll go by 8/2 only. ಆ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಂತ.
What do you want to tell ಹೇಳಿ?
What I want
Convenience compilation ಇದ್ರೆ ಒಳ್ಳೇದು. Everything in one.
ಅದಕ್ಕೆ ಈ ಎರಡೇ ಮೆಮೊ ಇಟ್ಕೊಂಡಿದ್ದೆ. 10/1 and 11/1. ಒಂದೇ ಒಂದು ನಿಮಿಷ ಕೊಡಿ ಮೇಡಮ್.
Now, on what ground is the miscellaneous application allowed?
The memo that is filed, he says all this will consider on merits ಅಂತಾರೆ. ಅವ್ರ ಮೆಮೋನು ಹಾಕ್ತಾರೆ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ನಾವು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ. This is the advocate has bulldozed and he wants it to be allowed.
And
the
court has acceded to that and allowed it.
ಅದಕ್ಕೆ ಇಷ್ಟು ವರ್ಷ ನಡೆದಿರೋದು, ಇಲ್ಲದ್ರೆ ಎಂದೋ ಮುಗ್ದೋಗಿರೋದು. He comes, he takes a helping. He gets 4 acres of land under the compromise. He makes a statement on oath saying that he will withdraw. The son and mother file an application before the trial court and before this court saying that we don't want to prosecute. The compromise in 496 is to our interest ಅಂತ ಹೇಳಿ, ಇಂಥಾದ್ರೂ ಆದ್ರೂ ಇಲ್ಲ ಇಲ್ಲ ನಿಮಗೇನ್ ಗೊತ್ತಾಗೋದಿಲ್ಲ ನಾವು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಏನರ್ಥ? Lord, I am reminded of just on a lighter note, there's a gentleman who is being buried into a grave, and suddenly the undertaker finds that this man is not really dead, he's still alive. So he pulls him out from the grave. So he says, what is the matter with you? He says, I am still alive. He said, all those doctors who have done double degree have certified you to be dead. How can you be alive? Anta ee tara aitidu. Your lordship got that?
I am in this memo.
Memo. Now,
ಅದ್ರಲ್ಲಿ ಏನ್ ಬೇಕು?
ಅದರಲ್ಲಿ
Page
page
34
page 40, 142 ನೋಡ್ಬಿಡಿ first.
142.
ಅದನ್ನ ನೀವು ಒಂದ್ಸಲಿ ಫ್ಲಾಗ್ ಮಾಡ್ಬಿಟ್ರೆ. 142 is the earliest suit.
That's exactly. 142 page number ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅದು ಎಲ್ಲಿ ತನಕ ಇದೆ?
128, 129. This is memo dated 11/1/2017.
ಆಯ್ತು ಬಿಡಿ. ಅದನ್ನ ಆಮೇಲೆ ಬರೋಣಂತೆ ಅದಕ್ಕೆ. ಇದರಲ್ಲಿ page 34 ತೆಗಿರಿ.
Yes.
Page 1 is the RFA.
Page 1 is the RFA.
RFA. ಅದರಲ್ಲಿ page
page 1 is not the RFA, I'm sorry. It is
Okay.
OS 7295/2002.
ಅಲ್ಲ ನೀವು then your lordship is looking at the memo.
Whatever your
10/1/2014 your lordship is
no,
seeing.
11/1/2017.
ಅದು 10/1 ಅದು. ಅದರ ಅಲ್ದೇನೆ ಒಂದು ನೋಡಿ just help the court please. That is 10/1/2014 that his lordship is seeing.
ಅದಕ್ಕೆ ಒಂದು convenience compilation ಇದ್ರೆ
ಒಂದು convenience compilation
easier to traverse
shall I-
through and finish it off.
Shall I put everything together?
Yes, everything, whatever you want,
ಆಗ್ಬೋದು.
relying on.
Oh, yes.
If you put it in
ಆಯ್ತು ಹಾಗೆ ಮಾಡ್ತೀನಿ.
in one spiral.
Sure, I will do
Will
that.
be very helpful instead of
No,
going
definitely, definitely.
going
I will
here
I
and
will
there.
put everything together in one
That
place.
will be better. Whatever you have to say, ಅದನ್ನು ಅದೇ ತರ ಹಾಕಿದ್ರೆ ಒಳ್ಳೆ.
ಆಯ್ತು.
Lord, I have hardly 2 minutes to say. because
2 minutes.
ಅಷ್ಟೇ. It's 4,000 rupees a minute that this High Court costs public exchequer.
All right, tell
to
me.
do that. My lord, if one goes by the pleading, it's a simple review petition. Review petition of a matter which has been disposed for non-prosecution. All this that has been said is trying to settle a spider web of matters running between a former Cinestar and two real estate agent brothers. That's all. This court is not to decide on all that. It's to decide only on a CRP. The question is whether the dismissal on non-prosecution reinstatement is lawful or not. That's all it is. Why are we going around the world? And every point
I'll have
raised
it
here has been raised before the trial court and rejected. There's no appeal against that. The trial court in its miscellaneous give them a chance to lead evidence, to cross-examine. They refuse to do that. And they conduct a trial here in the High Court. Is this court expected to settle all the plethora of litigation between two parties, my lord? Or restrict to what has been pleaded in a CRP before the?
No, if what the senior counsel says, that miscellaneous memo is filed that they are not going to prosecute and you want to prosecute and all that.
My lord, I will show this honorable court a memo filed by them before the court agitating this matter. It has been rejected. Why have they not appealed? If a trial court can't do its job and High Court has to do trial.
So not on that, only on the veracity of the miscellaneous application, 850
I
of
will show
2007.
that.
It's all right.
I'll make a convenience
Convenience compilation.
My lord, may just
give me
read
3-4
that one
days, my
memo,
lord.
my lord, and then take a call.
3-4 days your lordship.
Yeah,
will give
page
me.
number.
Sharma sir.
My lord, page number
You-
115.
ಯಾವ್ದ್ರಲ್ಲಿ?
In the CRP, in the objections, my lord. Can I just pass this one?
No, no.
I'll put
Instead of
everything
piecemeal,
I'll do it.
you do that, Sharma sir. You do that and
Done.
yes. You also file a convenience compilation if you
I'll do
want.
it.
I'll take it on Thursday. Next Thursday, sir. It's all right, next Thursday.
ಆಗ್ಬೋದು.
My lord, 20th to 25, I'm disabled. I've
19th.
Event in my, so anytime before or after that,
It's all right, 20, then we'll take it on 27th, Friday.
deeply obliged.
27.
Yes, 27th. Is there any interim order here?
Yes, yes.
Interim order subsisting, we'll continue to the next.
Obliged.
22.
I am for the petition. Two 2015 matter, my lord. Lord. The petitioner is filed against the order of the learned district judge in dismissing the, my lord, the application filed by the appeal filed by the petitioners. Where, my lord, their PNDC was their application for succession certificate was dismissed. But the petitioners, first petitioner is the wife of one Muniraju, second petitioner is son, And third petitioner is the mother of the Muniraju.
Hmm.
The first respondent, my lord, one Lingarajamma.
Hmm.
She claims to be a second wife, my lord.
Second wife of Muniraj.
Muniraju, according to us.
Hmm.
Their case is, my lord, that my marriage is not at all marriage. That's how their case.
ಸೆಕೆಂಡ್ ವೈಫ್ ಅಂತ ಕೇಳಿಲ್ಲ.
Yeah, according to, my lord.
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್
According to him.
According.
All right.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಅಲ್ಲ, ಈಗ-
ಸ್ಟ್ರೇಂಜರ್ ಅಂತ ಹೇಳ್ತಾರೆ ನಮ್ಗೆ.
Pleadings.
ನಾನೇ ವೈಫ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
See, what has happened now?
Now, my petition for succession certificate was dismissed. Lord, I have produced, my lord, my marriage certificate.
No, no, that is first appeal ಅಲ್ಲಿ dismiss ಆಗಿರೋದು.
ಹೌದು. Appeal dismiss ಆಗಿದೆ.
Where the order of the trial court?
Trial court, my lord, I have produced along with my petition. my lord. I may pass on, my lord, the compilation I have made.
ಕೊಡಿ. P&SC 1 of 2006.
Yes. But that's what is dismissed, my lord, wherein, my lord, it's the trial court, my lord, had discussed, my lord, the evidence of two sets of evidence.
What happened to this?
Now, I have taken, my lord, it in appeal before district judge.
This is
That also dismissed, my lord.
all right.
Now I am before this.
Concurrent finding.
Yes.
All right. Yes.
The district court, my lord, the appellate court, my lord, has sent, my lord, both the parties
Hmm.
to given liberty to challenge, file a suit, appropriate suit, claiming, my lord, the status as to who is the wife, first wife. etc.
Correct.
That, against that, my lord, we are here.
Oh, against that finding you have come here. Is
Yes.
it? What is wrong with that?
No, my lord, my
Your
submission.
status itself is not determined.
My submission, my lord. The exhibits P7 to 25, my lord, letters written by deceased Muniraju to the wife, my lord, the first petitioner hearing.
Letters, sir.
Yes, inland letters has not been
Inland
considered.
letters,
Yes,
all right.
where a statement has been made as to their relationship. And section 32, now present 26 of Evidence Act, subclass 5 and 6, where it says, my lord, if a statement made by a deceased person as to his relationship, blood, adoption or marriage, is a relevant fact.
Relevant fact to determine something
Yes.
somewhere.
Here also, that's what I am underlying. My submission, my lord, that the letters has not been considered by both the courts. They have been they have been ignored.
What letters? Where are the letters?
They have produced. Second volume, second section, kindly see.
What was Muniraju?
Muniraju was a lineman in KB, my lord.
ಮೀಟರ್ ರೀಡರ್.
Meter reader.
Lineman.
Meter reader.
Yes. Hmm.
Lord, the
ಈಗೇನ್ ಕಂಪ್ಯಾಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಬೇಕಾ?
ಇಲ್ಲ ನಮಗಲ್ಲ, ನಮಗೀಗ ನಮಗೆ ಕಂಪಾಷನ್ ಕೇಳಿದ್ವಿ ನಾವು. ಅಟ್ಲೀಸ್ಟ್ ನಮಗೀಗ ಸೆಕೆಂಡ್ ವೈಫ್ ಹರ್ ಕ್ಲೈಂಟ್ ದೇರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ನೌ ನೋ ಮೋರ್, ಮೈ ಲಾರ್ಡ್. ವಿ ವಾಂಟ್ ಅಟ್ಲೀಸ್ಟ್ ಪೆನ್ಷನ್ ಅಂಡ್ ಲೆಟ್ ದೆಮ್ ಟೇಕ್ ಪೆನ್ಷನ್.
Who is no more now?
Second wife. The marriage, the person's marriage.
Lingarajamma.
Yes. Her marriage was in the year 92.
No, Lingarajamma is no more.
No more.
No, when pending before this onward.
Yes.
All right.
Now
ಈಗ
she is no more.
Children?
Children
ಇದಾರ?
Her marriage was in the year 92 as per their marriage card. My first petitioner's marriage was in the year 1987. A son was born in the year 1988. And in that regard, there are several correspondence, inland letters made at a point, before the litigation starts.
Now, who is the legally wedded wife?
According to first wife.
Not according to you.
First wife.
It should be determined by a suit. Correct ಆಗಿದೆ.
ಅವ್ರ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಬರ್ಲೇ ಇಲ್ಲ.
My submission
ನಾನೇ ವೈಫ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸ್ಟ್ರೇಂಜರ್ ಅಂತ ಬಂದಿದೆ. ಸೆಕೆಂಡ್ ವೈಫ್ ಅಂತ ಎಲ್ಲಿ ಕೇಳಿ
ಲಿಂಗರಾಜಮ್ಮ is stranger ಅಂತ.
ಸ್ಟ್ರೇಂಜರ್ ಅಂತ ಬಂದಿದೆ. ಅವ್ರ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲೇ ಇದೆ.
ಇರ್ಲಿ. Stranger, according to us, it's stranger. Once if my client claims, my lord, he is a wedded. LIC. There are two policies, my lord. First policy is in my first petition's name. Second policy is, my lord, first respondent's name. That is equally goes for both. Marriage certificate.
Let all the issues be determined by the civil court.
Yes.
You will all be bound by what decision the civil court would take. Appropriate order. ಇದು ಎಷ್ಟು?
That's why my submission.
10 ವರ್ಷದಿಂದ ಇದಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಇದು?
I recently, before COVID, I entered, my lord, hangouts. No, my submission, my one submission. Now there is first respondent is no longer, is no there. My lord, pension we will get. My lord, I will show, my lord, her marriage is first in the year 1987.
No, if the legal heirs of Ningarajamma agree to settle, I have no
Kindly see,
problem.
even on record, my
I have
lord.
no problem.
No,
We
kindly
will,
see,
we
they are
will
not
close,
agreeing
we will
for-
close it here.
They are not.
But there is nothing wrong with the order passed by the court directing you to approach the civil court for determination. There is nothing wrong.
Succession. My lord,
ಇನ್ನು
section
ನೀವು ಯಾರು
370
ಅಂತಾನೆ ತೀರ್ಮಾನ ಆಗಿಲ್ಲ.
Section 373, my lord, subclause 3 may kindly see, kindly for a while.
ಕೊಡಿ. Of what?
Indian Succession Act.
ಕೊಡಿ.
Procedure provides under 373. To 373. 373.
ಲೆಟರ್ ಬರ್ದಿದ್ದನ್ನ
Consider that if that is a relevant, my lord, then both the courts have failed. I'll show, my lord, the law also, my lord, citations.
lineman writing letters.
Yes, my lord, meter reader.
Meter, sorry.
His Kannada handwriting is very good, my lord, very romantic letters.
Obviously.
Yes.
Obviously.
Yes. Very romantic.
Correct.
Since from 1988. And the child, he informs the birth of child, etc. also. That is discussed. His education, everything. That cannot be ignored.
Let the court consider.
Subclause 3 for a while.
Now, see, in so far as other things are all right, if you are willing to settle with some compromise, I have no problem.
They will not get pension, my lord, now. She is no.
Now, family pension ಅಂತೂ ಬರಲ್ಲ.
ಬರಲ್ಲ ಅವರಿಗೆ. ನಾವು ತಗೊಳ್ತೀವಿ. ಅವ್ರ ಜಾಬ್
ನೀವೇನ್ ತಗೊಂತೀರಾ?
ಮತ್ತೆ I am showing that she is the first wife. On record, I will show, my lord. If my statement made in the letters is relevant, then, my lord, I am having some citations. Then, my lord, both the courts are wrong. Concurrently wrong.
Employers records is very clear.
LIC ಇದಲ್ಲ, ನೀವು KB.
ನಮ್ದು LIC ಇದೆ. ನಮ್ದು LIC ಬಾಂಡ್ ಇದೆ. ನಮ್ದು prior in point of
records, who is the
nominees,
ಪ್ರಕಾರ ಒಂದು ನಿಮಿಷ. ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ
Service records, respondent number 1 and her children's name is mentioned.
ಅಷ್ಟೇ ಅಲ್ಲ, ಥ್ರೂಔಟ್ ದಿ ಲೈಫ್ ಟೈಮ್ ಆಫ್
service
ಎಂಪ್ಲಾಯ್ ಅಲ್ಲೇನ್ ಚೇಂಜ್ ಏನ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲ, ಅದು ಇನ್ಸರ್ಷನ್ ಲಾಸ್ಟ್ ಅದು ತೋರಿಸ್ತೀನಿ. ನಾಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್. ನೋ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್.
ರೊಮ್ಯಾಂಟಿಕ್ ಲೆಟರ್ಸ್ ಅಷ್ಟೇ.
No, kindly appreciate, my lord. These letters, my lord, are placed very important for this reason, my lord. Those statements in those letters, my lord, made, my lord, a person.
Only one thing, if writing letters like this could determine the fate of any person.
Definitely.
To become a legally wedded wife.
Definitely, I will show him.
There cannot be anything more dangerous.
I will show him, law is clear, I will show him. Section 32.
Unless that is determined before a court of law.
Then, my lord, my country like it, we'll go there. We'll go there, let's shoot file. ಇಲ್ಲ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೀನಿ, ಈಗ she is the first wife, my lord. I will show the records, my lord.
ಆವಾಗಲೇ ಮುಗಿಸಬಹುದಿತ್ತು.
ಅಲ್ಲ, she is the first wife, my lord. I will show the records.
10 years
one
for
sentence
this you have kept.
My lord, one day one
order
letter
of the court is to go before.
ಒಂದೇ ಒಂದು ಲೆಟರ್ ಓದ್ಬಿಡ್ತೀನಿ ಸರ್, ತಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ.
Record ಅಲ್ಲ, pleadings ಓದ್ಬಿಡಿ.
Pleadings, this is evidence I have read.
Pleadings
To show that, my lord, to show that she is the first wife, I have given so much of evidence. ಒಂದೇ ಒಂದು ಲೆಟರ್ ತಮಗೆ ಓದ್ಬಿಡ್ತೀನಿ, ತಮಗೆ ಅನ್ಸಿದ್ರೆ ಇಲ್ಲ ನಾನು I'll go quit.
ಎಲ್ಲಿದೆ ಅದು?
Kindly see exhibit P7 or P12.
P12.
Yes.
ಏನ್ ಅದರಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 22
ಅಂತ ಹೇಳ್ತಾರ?
Yes, my lord. Yes.
ಹೌದಾ?
ಮದುವೆ ಎಲ್ಲ ಕಡೆ ಮದುವೆ ಇರುತ್ತೆ.
ಒಂದು ನಿಮಿಷ.
Her marriage was, not respondent's marriage date was
page
22 of my small volume, my lord. Two volumes have given.
ಇದಾ?
ಇನ್ನೊಂದು ಸಣ್ಣದು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದರಲ್ಲಿ page 22.
22.
Yes. ಚಿರಂಜೀವಿ ಅನಿತಾ ರಾಜ್ಗೆ ಸಿರ್ಸಿಯಿಂದ ಮಾಡುವ ವಂದನೆಗಳು.
ಸಿರ್ಸಿಯಿಂದ
he was working there.
All right.
10/4/91ರಿಂದ 26/90ರವರೆಗೆ 2.5 ತಿಂಗಳು KEB ಟ್ರೈನಿಂಗ್ ಕೆಳಗಿಳಿಸಿ ಕಾರಣ ನಾನು 10 ಜನಗಳೊಡನೆ ಟ್ರೈನಿಂಗ್ ದೆಹಲಿಗೆ ಹೋಗಿ ಟ್ರೈನಿಂಗ್ ಮುಗಿಸಿ ದಿನಾಂಕ 19/6/91 ಮಂಗಳವಾರ ಕರ್ನಾಟಕಕ್ಕೆ ಬಂದೆ. ನಾನು ಸಿರ್ಸಿಯಲ್ಲಿ ಇದ್ದ ಕಾರಣ ನಿನಗೆ ಕಾಗದ ಉತ್ತರ ಕೊಡಲು ಸಾಧ್ಯವಾಗಲಿಲ್ಲ. ಆಪರೇಟರ್ಗಳು ಊರುಗಳಿಗೆ ಹತ್ತಿರದ ತಾಲೂಕುಗಳಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಡಿ ಅಂತ KEB ಆರ್ಡರ್ಗಳನ್ನು ಕಳೆದ 10ನೇ ತಾರೀಕು ಆರ್ಡರ್ ಮಾಡಿರುವುದರಿಂದ ಈಗಾಗಲೇ 30 ಜನ ಎಕ್ಸೆಪ್ಟ್ ಕಡೆಯಿಂದ ಬೆಂಗಳೂರು ಮೈಸೂರು ಕಡೆಗೆ ಬಂದಿರುತ್ತಾರೆ. ನನಗೆ ಹೆಚ್ಚಿನ ಗ್ರೇಡ್ ಸಿಗುವುದರ ಕಾರಣ ನಾನು ಇಲ್ಲಿಯವರೆಗೆ ಉಳಿದೆ. ಈಗ ಹೆಚ್ಚಿನ ಗ್ರೇಡ್ ಕೊಟ್ಟು ಸಿರ್ಸಿಯಿಂದ ಹುಬ್ಬಳ್ಳಿಗೆ ಜುಲೈ ತಿಂಗಳು ಮಾಡುತ್ತಿರುವರು. ಹುಬ್ಬಳ್ಳಿಗೆ ಬಂದ ಒಂದು ವಾರದಲ್ಲಿ ಮೀಟರ್ ರೀಡರ್ ಗ್ರೇಡ್ ಮತ್ತೆ ಕೊಟ್ಟು ಚಿತ್ರದುರ್ಗಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಡುತ್ತೇವೆ ಎಂದು ಬೆಂಗಳೂರಿನಿಂದ ಸಿರ್ಸಿ ನನ್ನ ಆರ್ಡರ್ ಹಾಕಿರುವರು. ಆದ್ದರಿಂದ ಜುಲೈ ತಿಂಗಳ ಕೊನೆಗೆ ವಾರದಲ್ಲಿ ಅಥವಾ ಆಗಸ್ಟ್ ಮೊದಲನೇ ವಾರದಲ್ಲಿ ಆಲತನಕ್ಕೆ ಅಂದ್ರೆ ಅದರ್ಸಿ ವಿಲೇಜ್ ಬಂದು ಮಾದೇಶ್ವರನ ಬೆಟ್ಟಕ್ಕೆ ಹೋಗಿ ಹುಡುಗನ ತಲೆಯನ್ನು ಮುಡಿ
ಆಯ್ತಾಯ್ತು ಬಿಡಿ.
this is one letter. Other romantic letters I don't.
Other?
There are so many other letters where Lord. Page number 15 may kindly see.
15.
Yes.
ಇದ್ರದ್ದೇ?
Yes. Kindly see. ಶ್ರೀಯುತ ಮಾವನವರಿಗೆ that is dated Lord 18/5/1989. ಶ್ರೀಯುತ ಮಾವನವರಿಗೆ ಅತ್ತೆಯವರಿಗೆ ಹಾಗೂ ಬಾಳಿನ ಸಂಗಾತಿ
ಆಯ್ತಾಯ್ತು ಬಿಡಿ.
ತುಂಬಾ ಇದೆ.
ಕತ್ತಲೆಯಲ್ಲಿದ್ದ ನನ್ನ ಬಾಳಿಗೆ ಬೆಳಕು ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ, if this statements Lord section 32 subclass 5 of the evidence act says it is a relevant fact. There Lord I am having some judgment Supreme Court which says
not
the
this court
relation can be proved by this.
This court will not, it should be proved
Yes.
by this. Yes. Before a competent court of law.
Yes.
Not in a P&SC proceeding where that is the aftermath of that determination. You are putting the
It is a
cart
summary
before the
proceedings.
horse.
Lord, it is summary proceedings.
ಅಷ್ಟೇ ಅಲ್ಲಿ ಹೋಗಿ.
Eyes.
You can read all your romantic letters there.
It is an interesting case which I have come across.
Interesting case.
Both
Such cases are
she is a very
interesting.
poor lady, my lord.
ಯಾರು?
This lady. Coolie was doing coolie. She was beaten up, tortured. She wanted to commit suicide for 2-3 times. There
For
was
what reason?
harassment. For harassment.
For what reason?
She was a drunkard, my lord. Drunkard.
For what reason?
I don't know, my lord.
Who
She-
was a drunkard?
That Muniraju. He had 3 affairs, my lord. Apart from this, she is first wife, second, my lord, and one more Lakshmi is there. These are all born by the records.
ಇದು ಅವಾಗ್ಲೇ ಬರ್ದಿರೋದಿರ್ಬೇಕು ಲೆಟರ್ ಎಲ್ಲ. ಆ ಸ್ಟೇಟ್ ಅಲ್ಲೇ.
ಇಲ್ಲ. It is a marriage, my lord. Marriage is there, my lord. Marriage. 87 marriage, my lord. 88 son was born. 92 their marriage.
All right. Yes. Not before, not
liberty,
before.
liberty may be given.
Liberty will be given.
Please.
The learned counsel for the petition. The challenge in the case at hand is concurrent finding of 2 courts. Both the courts have concurrently held that the petitioners will have to determine that they are the legally wedded wife and children of one late L. Muniraju,
Yes.
who was working as a meter reader in the then Karnataka Electricity Board. The courts have held, both the courts have held that unless a competent civil court determines that they are the legally wedded wife and children, no benefit can flow in a P&SC proceeding. I do not find any warrant to interfere in those orders, as it is for the competent civil court to decide upon the issue. At this juncture, the learned counsel for the petitioner submits that he would withdraw the petition and avail of filing of a suit before the competent court to the determination that is directed to be that is determination as directed by both the courts. Reserving such liberty, the petition stands disposed.
Now, till such time, Lord, the discharge other benefits should not be disbursed, my lord.
ಯಾವಾಗ ಹೋಗಿದ್ದೀವರು?
ಇವ್ರದ್ದು ಅಲ್ಲೇ ಪೆಂಡಿಂಗ್ ಇದೆ. 2004, my lord.
2004
He died. 2006
ಇವ್ರಿಗೂ ಹೋಗಿಲ್ವಾ ಅದು?
ಇಲ್ಲ ಹೋಗಿದೆ. Because of a counter claim.
ನಮ್ದು ಕ್ಲೈಮ್ ನಾಟ್ ಕೌಂಟ್ ದೇರ್ ಇಸ್ ದೇರ್ ಕೌಂಟರ್ ಕ್ಲೈಮ್.
In the suit ಹಾಕಿ ಫಸ್ಟ್ ನೀವು.
ಅಲ್ಲ ಅಲ್ಲಿವರೆಗೆ ಇಲ್ಲ ಮತ್ತೆ ಅವ್ರು ಮತ್ತೆ ಬೇರೆ ತರ ಪ್ರೆಸಿಪಿಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಇವ್ರಿಗೆ ಸಿಗಲ್ಲ, ಅವ್ರಿಗೆ ಸಿಗಲ್ಲ.
ಇಲ್ಲೇನು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ 10 ವರ್ಷದಿಂದ ಇಲ್ಲಿಲ್ಲ.
Even this first respondent was also directed to approach for civil court.
ಇಲ್ಲಿ ಎಲ್ಲರೂ
both the courts, both the parties. Therefore ಇಬ್ಬರಿಗೂ ಅನುಕೂಲ ಆಗಂಗೆ ನಾಳೆ
ಅಲ್ಲಿ ಬರ್ದಿರೋದೇ parties to the list.
Yes.
No problem. Yes.
No, till such time they should not proceed.
10 ವರ್ಷದಿಂದ ಇಲ್ಲದೆ ಇರೋದೇ.
ಇದು ಇನ್ನೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಇನ್ನೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. Otherwise, Lord, tomorrow they take.
ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. All the benefits that would flow from the retirement of late S. L. Muniraju would be subject to the result of the order, subject to the orders passed by the civil court.
Yes, please.
Where in Nana?
In the event if they approach.
Yes. We will go. Within 1 month we will go. Within 1 month.
In the event the petitioner would.
No, I will go.
In the event the petitioner would avail of the remedy of filing a civil suit.
Within 1 month we will go.
ಅದೇನ್ ಬೇಡ. ಹೋಗಿ.
Otherwise ನಾಳೆನೇ ಹೋಗ್ಲಿಲ್ಲ ಅನ್ಕೊಂಡು ಮತ್ತೆ ಅವ್ರು ಮಾಡ್ತಾರೆ.
ನಾಳೆ ಹೋಗಕ್ಕೆ ಹೇಳಿದಿನ ನಾನು.
ಅಲ್ಲ ಅವ್ರು ಮತ್ತೆ ಹಂಗ ಹೋಗಬಾರ್ದು. ಅದಕ್ಕೆ in the event ಅಲ್ಲ ಅದು. Within 1 month, within 4 weeks I will go, my lord.
ಅಲ್ಲ ಹೀಗೆ ತಳ್ತಾ
Kindly say, my lord. Within 4 weeks I will go, my lord. Kindly it may be taken.
ಸಾಕದೆ.
Within 1 month.
ನೀವು 4 weeks, 4 hours, ಯಾವ ಬೇಕಾದ್ರೂ
Within 4 weeks will go, my lord, maybe record it. Otherwise, ಇದು ಅದು ತುಂಬಾ ಹಂಗೆ ಇವ್ರಿಗೂ ಸ್ವಲ್ಪ ಇದಿರಲಿ, ಬೈಂಡಿಂಗ್ ಇರಲಿ.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನೀವು ಹಾಕಿ.
ಸರಿ. Bless.
ಸೂಪರ್ಫ್ಲೂಯಸ್ ಡೈರೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತಾ ಹೋಗಕ್ಕಾಗಲ್ಲ. ಎಸ್.
Bless.
ನೆಕ್ಸ್ಟ್
23.
2000 rupees or 2500 rupees, ಅದೇನಲ್ವಾ?
ಅಷ್ಟೇ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸಿಗ್ಲಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ. ಐ ಹ್ಯಾವ್ ದ ಒರಿಜಿನಲ್ ಟಿಪ್ಸ್.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಈಗ?
My lords,
ಅಲ್ಲ ಏನಾಗಿದೆ?
this is the issue, my lord, just to refresh my lord.
ರಿಫ್ರೆಶ್ ಏನಿಲ್ಲ ಗೊತ್ತು. 2000 or 2500 rupees.
Correct. Preliminary issue is framed with regard to the maintainability of the suit, because if 2000, if it is 2000 rupees, rent tax is applicable. And if it is 2500, rent tax is not applicable, suit is maintainable.
Suit is maintainable.
Correct. My lords, now the trial court has framed the issue and treated it as a preliminary issue.
issue.
Yes. Last occasion I argued that an evidence has to be led. And if my lords place the judgment of the Rajasthan High Court, which is already on record, which says that when there is a disputed question of fact, then evidence has to be, opportunity to lead evidence has to be granted. That is para number 5.
ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಕ್ವಶನ್ಸ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಇಲ್ಲ, ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಿರೋದಷ್ಟೇ.
No, my lords, not, my lords, kindly see the.
2500.
My lords, I'll just draw my lords' attention to page 32.
Now, if it is 2000 and less.
Correct.
It is before the authority.
Yes. Yes.
If it is 2000 and more. It is before the civil court.
Correct.
The civil court frames an issue, preliminary issue with regard to entertainability of the petition.
Correct.
It holds that it is entertainable as 2500 is what was being paid at the time of institution of the suit, correct?
No, what the trial court records of finding is that as per the plaintiff governments, the lease is for, my lords, that is the reason why I draw my lords.
Plaintiff government.
Yes, page 32, my lords.
Yes.
That goes to root of the matter. Page 32.
Yes.
My lords got it? Page 32. That is first, second, third, fourth, fifth line, sixth line. Plaintiff also learned that defendant number 1 has gone abroad, full stop. My lords got it?
Right.
Agreed rent, kindly mark this, as per the terms of lease is 2000. Defendant number 1 has paid the rent to the plaintiff till 2015 only. And preceding that month, for the past few years, defendant number 1 with to pay to the plaintiff monthly rent at rupees 2500. Again, my lord, this is very important. As per the promise, defendant is also liable to pay the electricity bill as well as the building tax up to date. However, since January 2016, defendant number 1 has stopped paying rent in light of demand being made through the defendant number 2. Now the question here is that this fact is denied by the defendant in a written statement. Now the fact remains is as per the lease deed is 2000. Admitted.
2500 ಯಾವಾಗಿಂದ ಆಗುತ್ತೆ?
ಕೊಡ್ಲೇ ಇಲ್ಲ ನಾನು. The what the plaintiff say, I have stopped paying the rent after January 2000, December 2015 is the last rent, 2000. Then my lord, he improves the case saying that as preceding that month of past few years, defendant number 1 with to pay to the plaintiff monthly rate rupees 2500, which is not paid.
Let it be tried before the suit.
Correct. I have no difficulty. Let it be tried. Now my difficulty is that this fact is denied by me. Now issue is framed. I should be been granted an opportunity to lead an evidence.
This is the preliminary issue with regard to entertainability of the suit. No problem. You prove other points there.
No, my lords, with regard to maintainability of the suit, my lords, my argument is closed down now because in the light of this finding. Now again, I cannot reopen it.
Maintainability is over. I will confirm it now.
My lord, that's the reason, because I have not been provided with an opportunity to lead an evidence. That's what the Rajasthan High Court says that. Last time I have placed on record.
I have seen
Order 14, Rule 1, Order 14, Rule 2.
ಏನದು? Rent Act.
Receipts. Same thing, same issues.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
2500.
ಇನ್ನೇನು ಉಂಟಾ?
My lords, receipt which is not a part of record. That is the reason why let him placed on record before the trial court. The evidence has to be led. It's a suit, my lords. He has to place all this material on record. I don't know what that receipt is. ಯಾವ ರಿಸಿಪ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರದ್ದು ರಿಸಿಪ್ಟ್ ಅವರೇ ಬರ್ಕೋಬಹುದಲ್ಲ? My lords, kindly see.
Yes.
The trial court, while deciding the preliminary issue, has not permitted the parties to lead an evidence.
Now, what is the suit for?
Suit is for ejectment.
Correct?
Correct.
All right.
Ejectment. Now I have, in my written statement, I pleaded that suit is
Court
not
will-
maintainable in
court
the light
will
of.
decide.
My lords, kindly see, kindly appreciate this.
Yes, sir.
Just, please, I take my lords to 1 minute.
1
Lords,
minute,
what
yes.
it says is that, as per order 14 rule 2 subclause 2, court could try an issue of jurisdiction as a preliminary issue and dispose of the case on such issue. Meaning thereby, kindly mark this, the court is required to give an opportunity to the parties to lead the evidence for trying the said issue of jurisdiction for deciding the preliminary issue. This aspect has not been dealt by the trial court. No opportunity has been granted to us to lead an evidence. The trial court, kindly see the impugned order. The trial court just proceeds on the averments made in the plaint. The issue will be framed based on the allegation made by the plaintiff, including written statement. Unless there is a pleadings of by the both the parties, the issue is not been framed. Issue will not be framed at all. Now, based on my pleadings, the issue has been framed. Now, question of jurisdiction in the instant case on hand is pure mixed question of law and fact. When there is
Mixture question? Yes.
my lords, kindly mark. There is also a similar decision, another judgment, that is Madhya Pradesh High Court also takes a similar view. Now, if my lords have a look at the impugned order, what the learned trial judge says is that, now plaintiff government says that he has paid 2,500 and I have denied tenancy. That is the reason why I am rejecting, the issue is gone against me. My lords, all that I am requesting by my lords is grant me an opportunity to lead an evidence. My lords may fix the time frame to lead an evidence. Within 1 day, I will conclude my evidence. Nothing more.
Two factors. One is whether it is 2,500 or 2,000 rupees. Second factor is he denies his relationship. For these two.
That is a matter.
Matter.
Denies relationship andre adu the other issues. We are on the preliminary issue.
Yes. Now, so far as 2,500 or 2,000 rupees, my lords, so far as facts are concerned, he does not deny, nor he puts a question in his my cross exam during my evidence.
ಈಗ preliminary issue ಮೇಲೆ evidence ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಅದರ ಮೇಲೆ ಆಗಲಿಲ್ಲ, ಮೇನ್ ಮೇಲೆ ಅದು
ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, because my doors are
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡಬಹುದಿತ್ತು.
ಒಟ್ಟಿಗೆ ಮಾಡಬಹುದು. If that is the finding, my lords, I have no difficulty. Let me, my lords, let the said issue be tried along with other issues.
So we will hold it now.
Great.
The petitioner is before this court calling in question an order dated 27 September 2019 in OS 347 of 2016, whereby the concerned court, after formulating a preliminary issue, holds that the suit is maintainable and the court has jurisdiction to try the suit. Heard so and so. The facts in brief germane are as follows. The first respondent, plaintiff, institutes a suit for possession and direction to possession, an ejectment suit, a suit for ejectment of the petitioner tenant in the premises. In the said suit, a written statement is filed by the petitioner denying the averments and also takes up the issue with regard to the entertainability of the suit before the concerned court, as according to the petitioner, the rent that he was paying to the landlord was 2,000 rupees. If it is 2,000 rupees, the suit would not lie before the concerned court, but under the Karnataka Rent Act, it would lie before the, what authority is that? Lie before the authority. Huh? Lie before whom, sir?
Just a little.
Lie before so and so. Nodi, ಹೇಳ್ತೀನಿ ನಾನು. The concerned court, on the submissions made by the petitioners and the respondents, formulates a preliminary issue with regard to entertainability of the suit qua jurisdiction on the score of jurisdiction. The concerned court then holds that in terms of the rent claimed by the plaintiff, it exceeds 2,500 as the plaintiff had accepted the fact that the tenant would pay rupees 2,500 from December 2015. And they,
Preceding 2015. 15 ವರೆಗೆ agreement ಇತ್ತು.
preceding 2015, and therefore holds that the rent would be 2,500 and the suit would be maintainable. This is what has driven the tenant before this court. The learned counsel B.S. Sachin, appearing for the petitioner, would vehemently contend that there is ambiguity in the amount of rent to be paid, as it is 2,000 or 2,500 that would have to be thrashed out only by way of evidence. The jurisdiction in certain cases, the learned counsel would submit, would become a mixed question of law and fact, and therefore the court ought not to have gone on by the plea of the plaintiff that the suit is entertainable, as the rent that was agreed to be paid was beyond 2,000 rupees. The learned counsel would submit that if one opportunity is rendered, he would complete the evidence with regard to the preliminary issue and leave the court to try other issues at a later point in time. Per contra, the learned counsel appearing for the plaintiff would vehemently contend that he has in his hand all the rent receipts which would clearly depict that the amount of rent that is paid by the petitioner to the respondent is 2,500 and not 2,000. Therefore, the suit in OS 347 of 2016 for the relief that it is filed was maintainable. He would seek dismissal of the petition. I have given my anxious concerns. The afore narrated facts are a matter of record. The issue at this juncture lies in a narrow compass as to what is to be determined is whether the preliminary issue so framed has been dealt with in accordance with law by the concerned court. The lengthy order that is passed by the concerned court would leave one in doubt as to whether the court considers the rent of rupees 2,500 or 2,000 per month. The reason so rendered by the concerned court is, insofar as it is germane, is as follows: para 12 to 14. The court notices that the plaintiff in his plaint clearly states that the agreed rent as per lease is 2,000 per month. And the defendant has paid that rent to him till 2015 December. And the preceding month, for a past few years, the defendant number 1 used to pay the plaintiff monthly rent at rupees 2,500. Therefore, on perusal of the averments, the court comes to conclude that the plaint is clear that after December 2015, the rent payable by the defendant number 1 to the premises is at 2,500 rupees. But the lease deed, even according to the concerned court, nowhere mentions that 2,500 rupees was the rent that was agreed to be paid, but it was 2,000. Therefore, the obfuscation still exists as to whether the rent was at rupees 2,000 or 2,500. The court then frames a preliminary issue under Order 14, Rule 2 of the CPC to answer whether the suit was maintainable. The court then goes on to answer that it is maintainable. A perusal at the order would indicate that the preliminary issue so filed still is shrouded with obfuscation. The apex court in the Rajasthan High Court?
Rajasthan High Court, that is in
the learned counsel for the petitioner
Amatar Agarwal
seeks to place reliance upon judgment rendered by the High Court of Rajasthan 1982 na
ಇದು 2014
so and so to buttress his
2013
submission that when there is there is a dispute with regard to jurisdiction, it would become a mixed question of law and fact, and the evidence should be permitted to be led. Even otherwise, the apex court in a later judgment in 2022, 7 SCC page 644, while answering a question with regard to Order 14, Rule 2, where the court frames a preliminary issue, and the issue being with regard to jurisdiction, the apex court has held that if it becomes a mixed question of law and fact, evidence should be led. The court paragraph 21 and 23 of that judgment. In the light of the judgment of the apex court, if the elucidation of law by the apex court is pitted to the facts narrated herein above and the order of the concerned court, what would unmistakably emerge is the unsustainability of the order passed by the concerned court on the preliminary issue. In that light, I deem it appropriate to obliterate the order and direct and permit the petitioners or the parties to the list to lead evidence with regard to whether the rent was 2,000 or 2,500 with the support of adequate documents. Since the issues of the year 2016, I direct the parties to appear before the concerned court on 2 weeks bit on 27 June 2025, and the concerned court shall endeavor to conclude the proceedings qua the preliminary issue within 2 weeks thereafter, and regulate its procedure, regulate its procedure thereafter. Ordered accordingly.
It's competent authority intiದೆ, controller. As per the
Controller,
rent.
correct. Rent controller. Next.
24.
Last date of hearing, my lords, this one was directed to the parties to secure instructions from the, if they have any
Even
compromise.
the trial court advocate also, today also I found out, my lord, they're still trying to talk on terms.
This court on 5/6/2025 had passed the following order. Counsels for the parties would submit that they would require some more time in the light of the said order. List the matter on 4th July. Interim order subsisting will continue to the next date. Third July.
25 to 26. 3rd July.
I appear for petitioner, my lords. I have produced the, that's a filed memo along with.
25%.
My lords,
Deposit ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ. I filed a memo, my lord, along with acknowledgement. That's on 5/6/2025.
Stay ಇದೆಯಾ?
A stay is there.
Learned
They was
counsel,
subject to
Learned counsel files a memo
already filed.
of deposit. Learned counsel submits, the memo has been filed of deposit of 25% of the amount. The submission is placed on record. Interim order subsisting will continue till the next date of hearing. List the matter in by the admission. Yes. List the matter on 3rd July.
2728.
Appear for petitioner.
27, the council is met with an accident. ಅದು ಗೊತ್ತಿಲ್ಲ. Anyway, he said the council has met with an accident. Adjourn it. ನೀವು ಕಲ್ಯಾಣ ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ದೀರಾ?
Respondent.
27 ಅಲ್ಲ?
28.
28 ಅಲ್ಲ?
My lord, suit for declaration, my lord. Averments of the plaintiff make out that there are two deeds, my lord. One is the absolute sale deed, another is reconveyance deed. On the basis of which, my lord, the suit has been filed for seeking the relief of declaration that the sale deed as the mortgage deed, my lord.
Order 7 Rule 11 is rejected.
And my lord.
What ground was it?
My lord, for barred by law.
Why?
58C, proviso to 58C, my lord. TP Act. If the condition for reconveyance has been embodied in the same document.
ಅದೇ ಮರುಕ್ರಯ ಪತ್ರ.
Marukraya Patra is a different document, my lord.
Then?
In the sale deed, there is no condition for reconveyance.
Where is the sale deed?
Sale deed is at page.
Shuddha Kraya Patra, Annexure F.
Page 70, 72.
It's outright sale, my lord.
It is 23/9/2020.
Yes.
Hmm.
They claim that there is another document, that is Marukraya Prata, executed on the same deed, which is
Where is that?
unregistered.
That is an unregistered.
Unregistered.
Unregistered. My lord, the question whether what statement made in the plain, whether it is true or false, my lord, would not fall under, my lord.
Whether it discloses cause of action or not.
It discloses cause of action. My lord, they don't even dispute in the application. They say it is fraudulently obtained. In the application affidavit supporting.
Fraud ಅಂತ allege ಮಾಡಿದ್ಮೇಲೆ ಅದು evidence.
My lord, the relief sought is mandatory injunction to execute as per the Marukraya Patra, my lord.
Page. Where do I get that?
Page 37. Prior B may be seen. Direct the defendant to receive the amount of rupees 37,50,000 by issuance of mandatory injunction to execute registered discharge date.
By way
Prior
of
B.
cancellation of sale deed in favor of the plaintiffs. Which sale deed are they talking of?
That is one at Annexure F.
This definitely becomes a matter of evidence.
My lord, the coordinate bench, my lord. The question herein, my lord, at page 3. Page 3. The court frames two questions, my lord. The first question is whether the two documents in question could be read together, and if so, whether the said documents spell out a mortgage. The same circumstances, my lord, there was another deed of reconveyance. The court answering this, my lord, at para 8, page 4, my lord. Even otherwise and without prejudice to what has been held above, and assuming for a moment that it is permissible in law to read both documents in question together as one document in order to find out whether the transaction is a mortgage or not, the best general test is to find out whether there does or does not exist a power in the original purchasers to recover the amount fixed in the document as the price of such repurchase. If there is no such power existing in the original purchaser as per the recitals contained in the document of reconveyance, the transaction cannot be treated as mortgage in as much as the essential right to creditor to receive the money from the debtor as not existing. Thereby, there will be a no relationship of creditor and the debtor, which is one of the essential features of a mortgage. On reading both the documents in question, it is clear that no right has been given.
We'll take it on Thursday. Yes. Let's stay in Ilvala. This is the matter of Thursday. But what is the status of the suit now?
It is for evidence, my lord. The plaintiffs are not appearing before the court.
List on next Thursday. Yes.
29.
Where is the release deed?
Release date, man.
Page.
Right, page number 49, man. Annexure F.
Suit for?
Suit for partition and separate possession and declaration to declare the release deed as null and void.
So there is a release deed.
Release deed in page number annexure F, my lord. Page number 49, my lord.
Now on the strength of the release deed, you filed an application under Order 7 Rule 11.
Yes, my lord. Before executing the release deed, my lord, payments were made to all the persons through bank, my lord.
Where the release?
Yes, my lord. Before prior to executing the release deed, my lord, payments were made. The amount was transferred directly to their account. And after lapse of thereafter, my lord, they executed the release deed on 29/4/2015. Thereafter, after lapse of 5 years, my lord, 2 persons filed suit, but 1 person has withdrawn the suit, my lord. That is dismissed. Your lordship can return to the.
So only one.
Only 1 person is disputing the. Page annexure A, my lord. dismissed as per order dated 9/4/24, H. Bhavani Subbaya. You know, only person is Srimati H.N. Chaya, now is the contesting person, my lord.
There are only two plaintiffs.
Yes, my lord. Two plaintiffs, only one plaintiff has already,
Adhe,
the suit is
correct.
dismissed.
This Bhavani Subbaya has withdrawn.
To substantiate that payment, my lord, I have produced it along with the memo, my lord, bank statement, my lord. Page number 2, along with memo I have filed, my lord. Statement of account, bank statement, Chaya.
The plaint averments would mention about the release deed.
Yes, my lord.
Yes.
No, my lord, the short question for consideration is, my lord, Order 7, Rule 11D. My lord, the only contention taken is the delay. The suit ought to have been filed within 3 years, but they have approached the court after 5 years.
Where is the
Whether-
order now? It is dismissed.
No, my lord, the application was dismissed.
Correct, application is dismissed.
Rightly dismissed. And my lord, they approached this honorable court. This honorable court granted the stay.
Oh, the suit is stayed now.
Stay.
Proceedings are stayed.
The short point is, my lord, it is covered by decision of the Supreme Court and this honorable court.
Where
When
limitation?
the delay, limitation is there, the mixed question of law and fact.
The only ground is limitation.
Only ground is limitation, nothing.
Where is your application?
Application is, my lord. Impugned order.
Page number, annexure D, my lord.
Page
Page number
40.
39, my lord. 39, affidavit is 30,
40.
page number 40. My lord, I submitted that the plain,
Don't-
para 2, my lord. It is submitted that
ಅಲ್ಲ
the
ನಿಮ್ಮ
plain,
application ಅಷ್ಟೇ barred by limitation ಅಂತ.
That's the only ground.
the reasoning in the affidavit is, my lord, all these things have been stated, my lord.
And the
Para two
ground
of
in the
the
CRP
affidavit.
is also the limitation, nothing else.
You have not executed release deeds?
No, my lord, that is a disputed. They, my lord, the circumstances under which the release deed was taken.
Who was schizophrenic? Who was suffering from schizophrenia?
This is for the first defendant.
First defendant.
I will read it.
She has withdrawn the suit now.
No, this is not withdrawn. Subsequently, she become the party because of the,
Oh, sir, ಹೇಳಿ.
because of the illness, she has withdrawn. Subsequently, she become the party.
No, my lord, she said that she has withdrawn and they said thereafter filed an application, she has become a party and.
Back to the suit?
Yes, back to the suit. No, my lord, any
Very
rate, my lord, this
limitation ಆದ್ರೆ
application is not maintainable.
ಬರೀ ಲಿಮಿಟೇಷನ್ ಆದ್ರೆ ಕಷ್ಟ.
ಬರೀ limitation, ಏನೂ ಇಲ್ಲ.
ಎಸ್ ಸೋಮಶೇಖರ್
My lord,
ನಿಮಗೂ
there is
ಗೊತ್ತು.
no cause of action for filing the suit itself, my lord.
No.
My lord,
Lord, I have
by
Where is
reading
entry
the,
order granted?
I have given two judgments of the Supreme Court. My lord,
Unknown
wherein the
judgment
court
is
has
delay.
very, my lord, clearly said that, limitation is
So,
concerned.
suit is, interim order is granted on 31/8/24. Till then what had happened?
We have
4 ವರ್ಷ ಆಯ್ತಲ್ಲ?
we
4
have
ವರ್ಷ.
filed, we have.
ಇಲ್ಲಲ್ಲ.
ಅಲ್ಲಿ
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡೋವರೆಗೂ ಸೂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
Suit, my lord, evidence, so far as the plaintiff's evidence is over. And defendant's evidence has to start at the stage, my lord, the stay of further proceedings also.
That's by the coordinate bench. ಬರೀ ಲಿಮಿಟೇಷನ್.
ಅಲ್ಲ, ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಇದ್ರ ಮೇಲೆ.
ಕೊಡಿ.
ಅಲ್ಲ, produce it at-
ಕೊಡಿ.
can't lie to them.
ಯಾವ್ದ್ರ ಮೇಲೆ?
ಅಂಡೆ kindly.
ಅಲ್ಲ ಯಾವ್ದ್ರ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ?
ಇದ್ರ ಮೇಲೆನೆ.
ಇದ್ರ ಮೇಲೆ ಅಂದ್ರೆ ಯಾವ್ದ್ರ ಮೇಲೆ?
Release date ಮೇಲೆನೆ.
ಕೊಡಿ.
Limitation.
With regard to, I will produce it on Monday, my lord.
But your pleading is not that.
But averments are there in the affidavit, my lord. But actually, that is the averments, para 2 of the affidavit, my lord. That is the main reason.
ನಾಳೆ tomorrow.
My lord, Monday, my lord.
ಏನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಹುಡುಕ ಕಷ್ಟ ದಿನ ಬೇಕು.
ಅಲ್ಲ, ಅದು-
Tomorrow, yes.
Please.
Next.
30.
Well, an interim order to continue.
Well, that will continue.
ನಾಳೆ ನಾಳೆ
ನಾಳೆ?
tomorrow, my lord.
Tomorrow. ಎಷ್ಟಾಗೋ tomorrow? ಇಲ್ಲ, tomorrow.
The defendant's revision petition.
No representation.
Sorry, my lord. The application under 7-11 is dismissed. And I am before the court. Suit
Again,
is-
limitation.
The question is not limitation alone. Suit is filed for specific performance. The agreement was cancelled on 11/4/2019. The agreement is dated 18/3/2016. He sends a reply on 29/4/2019. Suit is filed on 22/10/21. Acquisition.
Reply is sent on 29/4,
2019.
3 years after the notice.
Yes, please. That's one contention. Number two is, this, before the filing of the suit, lands were acquired for National Highway on 25/8/2021. As on the date of the suit, lands were acquired. And therefore, the suit was not maintainable. This is the contention that was raised. But once when the agreement is cancelled, he should have sought for a declaration whether the agreement is subsisting or not. Now, having not sought for a declaration, suit for specific performance is not maintainable. But the judgment of the Supreme Court also, on the ground that you don't seek for a declaration, suit is not maintainable. What is it? Sorry. Paragraph 24 words. Now, there is no declaration. Once the agreement is cancelled, he should have obviously sought for a declaration.
Yes, sir.
Also a suit for declaration.
2 points. It's a registered agreement of sale. Registered agreement of sale has to be cancelled by way of a registered instrument.
ಈಗ ಹೆಂಗ್ cancel ಆಗಿದೆ?
It is, they saying, issuing notice saying that agreement is cancelled.
Where is that notice?
My lord, that notice they have not placed in page 44. My lord, may kindly look at, they have stated page 44 of the plaint. I have stated clearly, my lord. Page number 44, first line, my lord. When the matter stood that the defendants have issued a notice through their counsel on 11/4/2019.
How much did you pay? 1,23 lakhs. Huh?
Not 1,25 lakhs, my lord, after the cancellation of what they issued a calling upon to issue demand notice cancel,
No, you
they
tell me
issued
the
further consideration.
Date of cancellation.
My lord, according to them, my lord, is 11/4/2019. A cancellation.
11/4/2019.
My lord, for subsequent to that, my lord, very same para page 10, very same para number 10, may kindly look at, my lord. Further consideration received on 9/11/2019, 5 lakhs.
9/11/46.
Yes, and 2021, this, my lord, continuously they have, every year they have received a amount. My lord, the total consideration after cancellation, this is a consideration paid by way of check. On 20, that the last payment made was on 29/3/2021. Your lordship may kindly look at.
Yes.
And your lordship may kindly look at page 45, para 12. The refusal to execute the sale deed, my lord, on 7/10/2021, middle of the
Yes.
page 12, I stated immediately after coming to know about the same on 7/10/2021, plaintiff has approached the defendant and demanded the defendant to execute the registered sale deed in terms of the agreement of sale by receiving balance sale consideration amount. By that time, defendants have flatly refused to execute the registered sale deed in respect of the scheduled property, having no other alternative. My lord, Article 54 of the Limitation Act is very clear. Either if the time is fixed from the date of time, in case, my lord, from the date of refusal, if time is not fixed. Here, my lord, subsequent to notice, consideration received by way of fight until 2021, I filed a suit in immediately, my lord. From the date of 7/10/2021, very next 1 month, within 15 days, I have filed a suit from 7/10/2021, date of refusal. The suit filed on 21/10.
Where is the refusal?
My lord, refusal, my lord, I have stated page 45 para 12.
Para 12 ಹೇಳಿದಿರಾ?
Yes, my lord.
Document that ಏನಿಲ್ಲ ಅಲ್ಲ?
My lord, it is a contract after that, my lord. The after payment, my lord, last payment made on 29/3/21.
That is there.
Thereafter. My lord.
Those
That is
payments are
time-
not
my lord,
made.
Another ground, my lord, they have taken readiness and willingness. Readiness and willingness, my lord, is concerned. Page, my lord, may kindly look at, I have specifically taken a pleading in my written plaint, my lord, the para 6, page 41. The plaintiff submits that from the date of execution of agreement of sale, plaintiff is always ready and willing to perform his part of contract. He is ready to pay the balance sale consideration amount. And limitation, my lord, is concerned, the date of agreement, my lord, is in 2016. The notice was issued on 2011 for 2019. Pursuant to that, 3 payments they received, therefore limitation will not apply. From the date of last payment, within 3 years, I filed a suit.
Notice issue ಮಾಡಿದ್ದು ಯಾವತ್ತು?
My lord, 11/4/2019. Reply given on 19/4/2019. Subsequent payment made on 9/11/2019, 4/6/2020 and 29/3/2020.
But subsequent payments are not made on
It
this.
is a registered sale agreement.
But I may make it very clear. Those payments are not being made.
Not being
Well,
made.
No, they are not
check
made.
payments.
No, these payments are not made in lieu of the transactions that have been arisen.
It's a
That's,
matter of
that's a
credit.
matter of evidence.
That's a matter of evidence. That's a different aspect. Number one. Number two is lands are acquired.
That
There is
also,
an
my lord.
acquisition of the land and it's acquired for highway authorities. And suit
When
is
was
not,
it acquired?
right, it's acquired prior to the filing of the suit on 25/8/2021.
All right.
2021. And if it is acquired, right, highway authorities, there is no such land that could be given.
That the
The only
court will,
question is
court will
compensation.
consider while determining the suit for specific
Right,
performance.
if the suit for specific performance is to be determined also, but that question may not be available at all because lands are not available.
That's up to you. We are on the preliminary issue whether the Order 7 Rule 11 applications ought to have been rejected or not.
Right, that was one of the ground that was raised.
Cancellation of agreement to sell is what you project.
Yes. Of
Where is
course.
the cancellation of agreement?
Cancellation is by
Unilateral
notice.
cancellation?
Not unilateral cancellation.
what?
No, I have not said unilateral cancellation.
Where is the, now this is a registered
But may I
agreement to
make a
sell.
submission?
Can, you tell me, can a registered agreement to sell be cancelled by, unilaterally cancelled by a stroke of pen by
The
you?
lords are on that.
Yes.
I have issued the notice. In the notice, I have said, please come forward and execute a cancellation document.
Then after that, why did you accept checks?
We have not accepted any.
What is
amount.
this?
But these are pleadings in his plaint.
Correct.
Except to that extent, that is all what he said.
Order 7 Rule 11 ge plain pleadings ashte, not your defense.
Very well, not even that. If that is to be considered, he should say whether this amount is paid towards additional balance.
That is his saying, sir.
That's his saying.
Requested to pay further advance sale considered accordingly, I have paid the same for what purpose?
It is all
Any
what
other
he has
transaction between you except this?
But there are other transactions also. Yeah, other
E
transactions.
agreement to sell.
That's right. Other than this, there are other transactions.
Anything else, sir?
But my submission is
Yes,
this. If my lords are rejecting my CRP,
undoubted.
my lords may only give a direction to the trial court to dispose it of expeditiously.
That's
all one.
2021 dalva. That we will direct. The petitioner is before this court calling in question an order dated 24/6/2024 by which the application filed by him under Order 7 Rule 11 of the CPC comes to be rejected on, we'll continue at 2:30. I'll dictate, continue the dictation at 2:30. Nivira then Badapura.
My lord, may I make a submission, my lord? One matter that was a successive petition, my lord, a criminal petition, 482 matter, my lord. There is a settlement between the husband and wife in 498A case, and the matter is already settled.
ಯಾವಾಗ ಬೇಕು?
ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಸ್ವಾಮಿ.
Sorry.
The trial court is, the matter is listed in trial court tomorrow, my lord.
Parties are present.
The husband is present, my lord.
Where is the complainant?
A complainant is not come, my lord.
Get the complainant.
My lord,
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಕಂಪ್ಲೇನೆಂಟ್ ಬರಬೇಕು.
learned counsel for the petitioner takes this court through the memorandum of facts that is filed before the concerned court, wherein the defendant petitioner had clearly indicated that on the same cause of action, OS 350 of 2017 had been preferred, and the same is dismissed for its non-prosecution. On the same cause of action and the same prayer, the subsequent suit is now preferred.
Only cause of action they have stated different, same prayer.
On the same prayer, the present suit is preferred. In that light, the rejection of the application of the petitioner prima facie is erroneous. Therefore, there shall be interim order of stay of further proceedings in OS 535 of 2023 till the next date of hearing. Emergent notice to the respondent, written of petitioner is at liberty to serve shall serve on the counsel who represents the respondent in the trial proceedings. List the matter on 10th July. Yes. Next. Notice.
Suit for partition suit, my lord. There is a specific government in the plaint that there has been a registered partition in the year 2000. The plaint government itself disclosed that there was a partition.
711 rejected alva.
Yes, my lord.
Notice. Yes.
Lord, there was the governments are very clear.
That we'll see. Yes. Next. Partition suit level. Next.
For the petitioner.
Ejectment suit.
Ejectment suit comes to be decreed, my lords. In November 2022, rental agreement has been entered upon, my lords. Just shy of 4 months, my lords, they issue a notice.
Yes,
for
there
termination.
is.
But 5/8/2022 is the date when the possession has been taken. 5/8/2022. No lease amount or the security deposit has been paid. So my lords, 24/11/2022, they paid the security deposit. Then the written agreement has been executed. Take into consideration about the possession and the agreement, my lord, 11 months. My lords, on 9/2/2023, my lords, 106 notice has been issued, terminating. He admitted the lease agreement, admitted the possession, admitted the relationship. So the court has dealt in the right way, my lords, and given 3 months time. My lords, the second point is, my lords, is
ಇವರು 2026 academic year ವರೆಗೂ ಬೇಕು.
ಅಲ್ಲ ಇನ್ನೊಂದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಇವರು, unfortunately, my lords, is an habitual offender in such a way, my lords, wherever he takes the possession, the landlords has to file a petition. Lords, I produced exhibit P7.
That is a statement which is making.
Right, exhibit P7, I produced the document, my lords.
Checkered history.
No, the only aspect which I'll seek from my lords is, my lords, I understand I have to vacate the premises, my lords.
1,80,000 is the rent due, my lord, as of now. Even he has not paid the rent regularly.
Yes. How much time you want?
Until next year academic.
No.
At least 6 months time may be given, my lords. I'll clear the rent also by then. And,
Let him show his bona fide by
First
clearing
clear
the
the
arrears,
rent.
my lords.
Until the suit.
Until ilve ಇಲ್ಲ. First clear the rent. ಎಷ್ಟಿದೆ rent arrears?
1,60,000 rupees.
1,60,000.
ಹೌದು. From 13 months, my lords. 15,000 is one rent.
I'll pay that, my lords,
When?
and some time may be given, my lords. At least.
Your stay and clearance will be coterminous.
Filed the execution, he comes before the execution court and says CRP is pending, so grant me time, we are getting the stay order. Neither I can execute the order, my lords. No stay has been granted.
There's no stay in this.
There's no stay.
Reasonable time, my lords. 6 months time may be given. I'll clear the rent and
First
I'll
rent
vacate the premises.
1,60,000. ಒಂದು ವಾರ ಕೊಡ್ಲಾ?
1 month's time. 1 month's time, my lords. Business is having losses, my lords.
Business?
He's running business, my lords. He's
What business?
a car reselling agency he has.
Car reselling.
But due to
I'll
some.
give you time till 20th.
Please.
Clear the arrears, then I will permit you to stay for some time.
Please.
Show your bona fides first.
Please.
The petitioner is before this court against concurrent findings of two courts.
ಅಲ್ಲ ಒಂದೇ.
ಒಂದೇನಾ? Against the order passed by the concerned court in SC 453 of 2023, whereby the petitioner is directed to deliver vacant possession of the property within 3 months from the date of the order, within 2 months from the date of the order. The prayer in the petition, inter-alia, is that he should be permitted to stay in the premises till the academic year of the petitioner's children would get over in the year 2026. The said submission is on the face of it untenable. The learned counsel for the respondent submits that arrears of rent as on today is at 1,60,000. Therefore, if the petitioner wants to continue in the premises for some reasonable time, he must demonstrate bona fides by clearing every pie of rent by the next date of hearing. List the matter on 20th. When do you want?
My lords, end of this month, my lords.
27th.
Please.
My lord, 26th is the execution court, my lord. 25th it may be posted, my lord.
It's
So if he
25th.
doesn't pay, I can.
If you don't pay by then, we'll dismiss this.
Please.
Great.
Yes, next. I'll mail her someone on that.
Petitioner madam, short accommodation.
Notice ಆಗಿದೆಯಲ್ಲ. Yes.
Caveat ಹಾಕಿದ್ದ.
Caveat ಹಾಕಿದೆ. Learned counsel for the petitioner seeks a week's time. List the matter on 20th, on 19th. Yes. Next.
36, my lord, this is the property belongs to female Hindu. On her demise, my lord, the same devolve, my lord, under section 15(1)(a) to her children.
711 rejected.
ಹೌದು, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, the petition the plaintiff is the great granddaughter of that my lord one Muddamma. She filed the suit during the lifetime of her father. The same is not maintainable. That is my ground, my lord. And the father himself has been filed the written statement, categorically admitted before the cutoff date, my lord. The entire
Who is the
suit had
contesting respondent?
only one respondent,
ಯಾರನ್ನು ಮಾಡಿದ್ದಾರೆ?
plaintiff only.
Plaintiff ಅಷ್ಟೇ. Defendant number 11.
ಹೌದು.
Emergent notice to the respondent. Petitioner shall serve on the counsel who represented the respondent in the trial proceedings. List on 26th. Notice. Yes. Caveat ಇದೆ. Yes, Prakash sir. Rejected,
Rejected.
Rejected.
Yes.
ಅಲ್ಲೋ ಆದ್ರೆ ಬೇರೆ ಕಡೆ ಹೋಗ್ಬೇಕು. ಅಲ್ಲೋ ಆದ್ರೆ ರೆಮಿಡಿ ಬೇರೆ ಅಲ್ವಾ?
But 2015 suit, 24, my lord, application was made. My lord, the ground is cause of action, no cause of action. My lord, what happened is?
It's all right. None, there is no representation by of the petitioner. List after 4 weeks. Yes, next. Heard the learned counsel with the caveator. List after 4 weeks. Next.
My lords, I am representing in writ petition for petitioners. In CRP, I am respondents. Both petitions filed on different applications, orders. ನಾವು ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿವಿ which came to be rejected by the trial court, hence we filed this writ petition.
ಅವರು 711
ಅವರು 7 rule 11 ಹಾಕ್ತಾರೆ, ಅದು ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ, ಅದ್ರ ಮೇಲೆ ಬರ್ತದೆ. ಅದು ಕ್ವಶನ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ರೈಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಸೊ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೇಳ್ ದಟ್ ಆ ಪ್ರಶ್ನೆ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ವಿ ಫೈಲ್ಡ್ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ and declaration regarding the properties allotted in the
What did you file? Order 6 rule 17.
House one.
Where is the order rejecting that?
My lord, page number annexure A at page number 18, my lords.
What did you want to amend?
My lords, before going to this order, may kindly peruse the plaint at page number 26, my lords.
I'm there.
My lords, in this case, it is a family matter, my lords. There was a partition taken place in the year 2000. In the said partition, whatever the properties fallen to the share of plaintiffs.
Amendment ಏನ್
ಅಲ್ಲ,
ಹಾಕ್ತಾರೆ?
ಅದನ್ನ ಹೇಳ್ಬೇಕಾದ್ರೆ ಇದು ಬೇಕಾಗುತ್ತೆ. ಯಾಕೆಂತಂದ್ರೆ ನಾವು ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿರ್ತಕ್ಕಂಥದ್ದು ಓನರ್ಶಿಪ್ ಅನ್ನ ಏನು ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಆ ಪ್ರಾಪರ್ಟೀಸ್ ಗೆ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿದೀವಿ. Whatever the properties left out in the said partition, we have seek partition with respect to those properties only.
You wanted to bring in those properties also.
ಇಲ್ಲ, already ತಂದ್ಬಿಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ. So ಅದಕ್ಕೆ 2 prayers I have made. May kindly peruse. Prayer A is declaratory relief regarding the properties allotted to my family. So second prayer is ಯಾವ ಪ್ರಾಪರ್ಟೀಸ್ ಕೈ ಬಿಟ್ಟಿದ್ರು ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಆ ಪ್ರಾಪರ್ಟೀಸ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಶೇರ್ ಕೊಡಿ ಅಂತ ಕೇಳಿರುವಂತ ಸ್ವಾಮಿ. ಸೊ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದಿಸ್ ಪಿಟಿಷನ್ 2 documents have been created by the defendants ಒಂದು ಗಿಫ್ಟ್ ಎರಡು ಗಿಫ್ಟ್ ಡೀಡ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ಆಸ್ಪೆಕ್ಟ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ಅಮೆಂಡ್ ದ ಪ್ರೇಯರ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಸಮ್ ಪ್ಲೀಡಿಂಗ್ಸ್. So which came to be rejected.
What is the stage of the suit?
ಈಗ ಸ್ಟೇಜ್ ಆಫ್ ದಿ ಸೂಟ್ ಇದು ವಿಡ್ರಾವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. With liberty to file a fresh suit with all pleadings. IA number 14.
ಇದೇನು ಉಳಿಯುತ್ತೆ ಅದು ಹಾಕಿದ್ರೆ?
ಸ್ವಾಮಿ
how will this survive if you filed
ಅಲ್ಲ
withdrawal of the
ಅದಕ್ಕೆ
suit?
that is kept for pending for consideration. ನಾವು even 7 Rule 11 ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಅವಾಗೂ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. But instead of that court has passed.
7 Rule 11 ಯಾರು ಇಲ್ವಲ್ಲ, ನೀವು ಯಾರಿಗೆ?
Correspond 5 in both.
5, yes. Withdrawal ಯಾವ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತದು?
1/7 ಇದೆ ಸರ್. 17
ಕ್ಯಾಲೆಂಡರ್ ಆ ಕಡೆ
ಇಲ್ಲ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಇದೆ.
ಸರಿ.
17
ಈಗ
17.
we'll
So
take,
ಹಾಗಾಗಿ
we'll take it, we'll take this on 3/7.
ಸರಿ ನಾವು we are
ಅಲ್ಲಿ
ready
withdraw
to
ಆದ್ರೆ ಇದೇನ್ ಅಲ್ಲಿ withdraw ಆಗ್ಬಿಟ್ರೆ ಇದೇನ್
ಅಲ್ಲ if this honorable court granted direct the trial court to pass an order on my
let
application.
the trial court pass the orders.
ಅಲ್ಲ ನಾವು ಕೇಳ್ಕೊಂಡ್ವಿ ಸ್ವಾಮಿ ಆದ್ರೂ
ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner in writ petition ಯಾವ್ದಿದು?
6350.
6350 of 2025 submits that the plaintiffs have filed as an application seeking to withdraw the suit and file a fresh suit, a comprehensive suit on all the cause, on the same cause of action. The memo, the application is yet to be considered in the submission of the council, and the next date before the concerned court is 1st July. In that light, the concerned court
ಇಲ್ಲಿ ಬಂದಿದೆ ಇವರು CRP ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ. In that light, list this matter on 2nd and 3rd.
CRP 299 undertake to file wakalat for R5.
Learned counsel so and so undertakes to enter appearance for R5 in CRP 299 of 2025.
Please.
Yes, list on same day. Next. Notice. Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
ಏನು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ತಾನೆ?
ಅನೌನ್ಸ್ಮೆಂಟ್ ಅಲ್ಲ, ಕ್ಲೈಮಿಂಗ್ ಇಂಡಿಜೆಂಟ್ ಪರ್ಸನ್ ಮೈಲಾರ್ಡ್.
ಇಂಡಿಜೆಂಟ್ ಪರ್ಸನ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 and 7 ಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿ, ಅದರ್ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ, ದೇ ಹ್ಯಾವ್ ಟು ಅಸರ್ಟೈನ್ ವೆದರ್
ಯಾರ್ಯಾರಿಗೆ ನೋಟಿಸ್ ಬೇಕೀಗ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 and 7.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್
ಗವರ್ನಮೆಂಟ್ 6 and 7.
Learned AGA? Learned HCGP is directed to accept notice for respondent 6 and 7.
Others ಗೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ
ಮೆಮೊ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
Yes.
They have to ascertain Millard.
The learned HCGP to secure instructions and make submissions with regard to the prayer of the petitioner. In son died.
Son died due to electrocution. Suit ಅಲ್ಲಿ compensation.
List on 26th.
Please.
Yes, next. Notice.
For the application.
Notice.
Stay ಬೇಕಾಗಿದೆ. 16th it is posted. Actually, the matter is fully covered under the provisions of PTCL Act. So kindly see page 31.
What is the suit for?
Suit for declaration that they are the absolute owners. The sale was effected.
Are the grantees?
Original father was the guarantee. Page 31, kindly see.
Yes.
It is respectfully submitted.
The petitioner is the defendant in OS 462 of 2020. The suit is instituted by the respondent plaintiffs claiming to be the legal heirs of the original grantee and have sought the relief of declaration in the said suit. The the defendant therein files an application under Order 7 Rule 11 seeking rejection of the plaint on the score that the civil court has no jurisdiction to consider the purport of the PTCL Act. The concerned court ought to have answered the application in favor of the petitioner, albeit prima facie, as admittedly the civil court has no jurisdiction to interpret the provisions of the Karnataka Scheduled Caste and Scheduled Tribes within bracket Prohibition of Transfer of Certain Lands Act 1978. In that light, the further proceedings in OS 462 of 2020 shall remain stayed.
Notice to respondent 8 to 11 may be dispensed with where the co-respondents.
Learned counsel for the petitioner files a memo seeking dispensation of a service of issuance of notice upon respondents.
8 to 11.
8 to 11. Memo is taken on record. Dispensation, service is dispensed at the risk of the petitioner. Emergent notice to the remaining respondents. Next. Notice.
Kindly, my lords, after 12.5 years, the suit which was filed, my lord. For the
Suit for?
Specific performance, my lord.
Specific performance.
Yes, my lord. This is a land which was.
Agreement.
Agreement, my lord.
Date, page.
Kindly, my lord.
ಯಾಕೆ ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ ಮರ್ತ್ ಬಿಟ್ರ (16/3/2011).
Yes, my lord.
Where is the prior in the suit?
Prior in the suit, my lords, kindly.
Performance of contract agreement. What is the time in the agreement?
The time is, my lords, 11 months, which was for performance of the.
First notice issue ಮಾಡಿದ್ದು ಯಾವತ್ತು?
That is in the year 2023, my lords.
Till then, no communication?
No communication, my lords. Even they did not even show any readiness.
What was the amount paid?
18 lakhs, my lords.
80 lakhs.
18 lakhs, 18.
The petitioner, the defendant, in OS 934 of 2023 has is before the court seeking stay of further proceedings in OS 2023 for his application under under Order 7 Rule 11 being turned down. The learned counsel for the petitioner submits that the suit is for specific performance of a registered sale agreement dated 16/3/2011, and for the first time the notice is issued seeking execution of the sale deed only on 22/6/2023, which would clearly be 12 years and 3 months after the execution of the agreement to sell. The plaint averments is clear to that effect. There is nothing more than what is submitted by the counsel for the petitioner here. In that light, there shall be an interim order of stay of further proceedings in OS 934 of 2023 till the next date of hearing. Petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement in the next 1 week, lest on 3rd July. 3rd July.
43 is also same. Huh? 43 also same, my lord.
43 also same.
Same.
Yeah. Yes.
Great.
The trial court has no pecuniary jurisdiction for adjudication of the suit, my lords.
Why?
Because I have produced the valuation slip at page number 38. May kindly peruse. Valuation of a suit is 1,000 rupees. If it comes within 5 lakh, if it is more than 5 lakh, then the trial court is having jurisdiction to adjudicate the matter. As per section 17 of Karnataka Civil Code.
1,000 rupees.
1,000 rupees declare ಮಾಡಿದ್ದಾರೆ. Only civil courts, civil judge has jurisdiction to adjudicate this matter. The senior division, Swami. If it is more than 5 lakh, it should be.
Anyway, list the emergent notice to the respondents. Returnable by the 3rd of July. Petitioner is at liberty to serve on the counsel who represented the respondent in the trial proceedings. List on 3rd. There shall be an interim order of stay of further proceedings in the impugned further proceedings in OS zones. Next.
It's the ground for 7 Rule 11 is that the suit is barred by limitation, my lords. But there is also another point that I wish to point out this honorable court. My lords, what happens is that we have granted a housing loan to the borrower, my lords.
Housing loan,
Indeed, my lords. Housing loan is granted. We are a defendant in this suit, my lords. It's a defendant's petition.
Of course, defendant Order 7 Rule 11.
Please, my lords. My lords, what happens is we prefer this.
HDFC.
Please, my lords. What happens is that we take surfacey measures in 2018, my lords, against our borrower who was defaulted, and we affix a
Notice.
notice. My lords,
No stay, yes.
lords, may I
1
please-
and 2, 1, 2 and 3 emergent notice. Different 1 and 2 ಯಾಕೆ ಬೇಕು?
Formal parties.
Plaintiff ತಾನೆ ಬೇಕಾಗಿರೋದು.
Please,
The
yes, formal parties.
notice to 2 and 3 is not necessary at this
I just
juncture.
bring one fact, my lords.
One
attention.
emergent notice to the plaintiff, apart from taking out emergent notice, the plaintiff first respondent. Apart from taking out steps, the petitioner shall also serve on the counsel who represented the plaintiff in OS 1252 of 2023. List on third.
May I just bring something to it?
No, stay in this, yes.
Great.
Pay for a week's time, my lords. Personal inconvenience to senior, my lords. Kindly have it next week, my lords.
We'll vacate the interim order.
No, my lords. Next week, my lords.
Finally list the matter on 19th. In the event submissions are not made, the interim order would stand automatically vacated.
Interim order may be extended.
Subject to the aforesaid, interim order stands extended.
Copies has been served to the other side as per order date.
Suit for?
Suit, this is suit, no, small cause suit.
Oh, serial number?
Ejectment, 47. Ejectment suit. In that suit, I have filed an IA for summoning the witness. The IA has been allowed by the trial court. Thereafter, after service of the summons to the witness did not turn up. Thereafter, the court has declined to issue bailable warrant and.
You are the tenant?
Yes, my lord.
Heard the learned counsel appearing for the petitioner. There is no representation on behalf of the caveator. List the matter on 3rd July. Till such time, further proceedings in SC, na?
Also,
SC 856 of 2018.
They are not filed caveat.
ಇಲ್ಲಿ ಯಾವ್ದು ಮತ್ತೆ ಹಾಕಿರೋದು? 47, sorry, sir. Yes, yes. ಅದೇನ್ ಬೇಡ ಮೇಡಮ್. Emergent notice returnable by 27th. Till such time, further proceedings shall remain stayed. Next.
I appear for petitioner. My lord,
For respondent.
order 7 to 11, A and B, my lord. There is no cause of action and so far as limitation. My lord, the suit for declaration and injunction filed, my lord, on the basis of the sale deed dated 30th March 1972.
1972?
Yes. Kindly see the plaint, my lord. Annexure.
Where is the plaint?
Annexure.
Annexure D,
D,
page
my lord.
20. D alva?
D. Para number 3 and 6 is sufficient, my lord. 3, my lord. The para number 3, page number 28, my lord. The plaintiff submits that the Kempanna purchased the aforesaid property under the registered sale deed dated 30th March 1972 from on Chaudappa, the father of the defendant, for valuable consideration. Since the date of purchase, he was in possession and enjoyment of the land in question as absolute owner till his death on 8/3/1996. My lord, even the plaintiff was minor. He had to file the suit on or before 8/3/1999, my lord. It is also barred. Number 2, my lord. So far as declaratory relief is concerned, there is no cause of action. Kindly the para cause of action.
Yes, sir.
ಇನ್ನೊಂದಿದೆ ಸರ್.
Come
Page
to
number 30.
Para 11, 12, 13. Page 34, 35.
34, ma'am. For cause of action. Cause of action for the suit arose on 6/8/2018 when the defendant made illegal attempts for the first time to interfere and thereafter in the month of November 2018 when he made illegal attempts once again to interfere with the possession of the plaintiff on the basis of an order passed with Tashida, Hoskote Taluk dated 6/9/2018 and recently on 6/6/2019 when the defendant made illegal attempts to remove the eucalyptus plants existing in the land in question, and the cause of action is still subsisting and it is continuous, my lord. Kindly, page number, my lord, very important. Page number 30. ಅಲ್ಲಿ 30 ಅಲ್ಲಿ fourth line, my lord. As such on 4/7/2018, they made a representation requesting the Tashidar Hoskote Taluk for transfer of Kata and entries in the name of plaintiff on the basis of registered sale deed dated 30th March 1972. The plaintiff, the sale deed was dated, is dated 30th March 1972, my lord. The suit is filed in 2019, my lord. So far as the cause of action, there is no cause of action, my lord. It is clever drafting, my lord.
Limitation.
Limitation as well as cause of action, my lord. I have taken the cause of action.
Cause of action is there. Limitation, particularly in this case, mixed question.
I am latest judgment, my lord.
Yes, sir. Could
Latest judgment, Supreme Court judgment. Sir. What? Madam. Para number, madam. Para 27, madam. Submission that limitation is mixed question of law and fact.
Sir, you can't read the finding in isolation. Come to para 23. 23, 24, 25, Amal 27.
20, madam, fact. Yes. Fact. Only difference in this case, said it. This case will, my lord. Only difference. Kindly. Fact, my lord.
Yes.
Para number 5. Para number 6, my lord. The plaintiff category states that the plaintiff Shri Hitesh P. Sangvi is the son of deceased Pramod Keshudas Sangvi, who died at his residence on 21st October 2014. He was survived by his wife, his 3 daughters, defendant number 1, 2, 3, and the grandson, defendant number 4, son of defendant number 2. The plaintiff further categorically in equivocal terms states that the deceased took his last breath on 21st October 2014. Then in the first week of November 2014, defendant number 1, 2, and 3 revealed to the plaintiff that the deceased had executed a will and a codicil as referred to above, and he was taken by surprise. The plaintiff further stated that the cause of action for the suit had arises on 3 occasions. First, on 4/2/2014, when the will executed by his father was registered. Again on 20th September 2014, when the codicil was registered, and then finally on 21st October 2014, when his father died. The dispute per se in the suit is inter se. The family members, that is the son and daughter of the deceased Pramod Keshudas Singh, in connection with his will and codicil, and for the purpose of seeking the relief claimed in the plaint, that is for declaration of will and the codicil to be null and void. And the plaintiff contended that the cause of action for such suit arose first on 4/2/2014, secondly on 29/2014, and lastly on 21st October 2014. In the above background, defendant number 2 moved the application purported to be under Order 7/11 of CPC for the rejection of the plaint on the allegation that plaintiff had not made any averment with regard to the suit to be within the limitation, and it is the primary duty of the plaintiff to show that the suit was instituted within the prescribed period of limitation. In the absence of such pleadings, the plaintiff is liable to be rejected under Order 7/11. A similar application was filed by defendant number 3 again under
Yes, sir, I have seen.
My lord, in this case, my lord, Also, the main prayer is, my lord, declaration, to declare that the plaintiff was the owner of the property. On the strength of the sale deed, registered sale deed dated 30th March 1972. In the cause of action, cleverly, the date of sale deed is not mentioned. However, the para number 3 and para 6 of the plaint, my lord, says the sale deed was executed in the year 1972. They have approached the revenue authorities for transfer of kata in the year 2018, my lord. Moreover, in this judgment, my lord, in this judgment, para number 27 is clearly applicable to our case, my lord. Para number 27 of this judgment, my lord. The submission that limitation is a mixed question of law and fact, and that it cannot be decided without allowing the party to.
Sir, in a given case,
Please.
limitation can be a pure question of law. In all cases, it does not become mixed question of law and fact.
Please.
All right, that is
ಇಲ್ಲಿ ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ.
that is settled principle of
ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ಅಲ್ಲಿ ಹೇಳಿ ಬಿಡಿ. That is settled principle of law.
Clear.
ಆದ್ರೆ you can't paint that concept into every case.
This case, last
ಅದು
line.
ನಿಮ್ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಇದಕ್ಕೆ ಬರಲ್ಲ, ಅಪ್ಲಿಕಬಲ್ ಆಗಲ್ಲ ಅದು.
ಬರುತ್ತೆ, ಇದಕ್ಕೆ ಬರುತ್ತೆ. ಯಾಕೆ ಹೇಳ್ತೇನೆ? Last line, last line. I mean, the above issue is purely on issue. It was expressly barred by limitation for which no evidence was.
Barred by limitation. ಕೆಲವು ಕೇಸಸ್ ಅಲ್ಲಿ yes, if it is on the face of it barred by limitation. No, that's not here. Cause of action, see only on 3. Cause of action barred by law, insufficiency of things.
Supreme Court, Honorable
Supreme Court ನಾನು ಹೇಳ್ತಾರೆ.
not touched with even the cause of action in this case, my lord. Only purely limitation, my lord. Illi it was expressly barred by limitation for which no evidence was required to be adduced by the parties.
Yes, sir.
The abuse. ಇನ್ನೊಂದು
ಜಡ್ಮೆಂಟ್ ಒಂದು ಸಾಕು.
ಒಂದು submission, kindly annexure, my lord, the cross examination of PW.
Sir, order 7 rule 11 only the plaint, not your defense, nor the contents in the application order 7 rule 11, whether it discloses cause of action barred by law. Yes, sir.
The contention what they have raised in the application filed under order 7 rule 11. Suppose if I have challenged this sale deed of 1972.
That is not the challenge there.
If that is not the challenge and I am claiming
for
right,
declaration.
for that there is no bar at all.
Whether it is entitled to declaration on the basis of that or not is a matter, subject matter of the suit.
No,
you can't get the plaint rejected on the ground.
Recently they filed application seeking permission to cross-examine. Recently, that is on 9/6/2025.
22 suit ಆಯ್ತು.
ಹೌದು ಸರ್.
19 suit ರೀನಂಬರ್ ಆಗಿ ಅಲ್ಲಿ ಸೀನಿಯರ್ ಡಿವಿಷನ್
2019 suit.
ಹೌದು. 2022 numbers renumber.
Cross-examination ಮಾಡಲಿಲ್ಲ.
Anything else, sir?
ನೋಡಿ, the citation, the judgment possible.
Citation will consider. There are many citations after that.
The judgment produced by the plaintiff defendant before this trial court, my lord.
Defendant ನೀವು.
Oh, ನಾನು ಫೈಲ್ ಮಾಡಿ. Ramesh Shetty, Venkatanna and others, ಅದು my lord, ಅದರಲ್ಲಿ it is clear, my lord.
ಅದರಲ್ಲಿ ನೀವು ಹೇಳಿದ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ the Supreme Court says clever drafting in a plaint should be nipped in the bud.
Yes.
Alva?
Yes. But there is no, they have to show the cause of action to declare the
2022 judgment.
Yes, my lord. 23.
Justice M.R. Shah.
Please. They have to show the cause of action for to declare that the plaintiff was the owner of the property, my lord.
Anything else?
The plaintiff is totally on the basis of the sale deed, my lord. Sale deed is
suit is at an advanced stage.
Cross-examination.
Stage of cross-examination of PW.
No interference. Nothing wrong with the order.
But there is no cause of action, not only limitation.
Full cause of action.
The cause of action column para, my lord, there is no mention of
order 7 rule 11 ಹಾಕಿರೋ ಅಪ್ಲಿಕೆಂಟ್ ಗೆಲ್ಲ cause of action ಇಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ಬೇಕು. But ಇದರಲ್ಲಿ ಇದೆ. The other 2 cases where I stayed, they are questions of jurisdiction.
Yes.
Civil court has no jurisdiction, so that is the right thing to stay the suit, not this. It is mixed question, clear. And suit is for declaration. Declaration and permanent
Permanent
injunction.
The,
Declaration, permanent injunction ಗೆ ಬರೋದೇ ಇಲ್ಲ.
the finding of the Honorable Supreme Court, my lord, have produced a judgment. The
Sir, those are
judgment
all facts of each case, sir.
Same, one
Same,
and same.
no
Yes,
same.
my lord. My lord, that,
Nothing
in
same.
that case, there is will, it is a sale deed, that's all. In that case, my lord, the
Sir,
observation.
facts emerge peculiar to each case, always. Law sometimes, yes.
That judgment is purely covered by.
Ashana, the petitioner is before this court calling in question an order dated 25th March 2025, which rejects the application of the petitioner filed under Order 7, Rule 11A and D of the CPC in IA number 3, seeking rejection of the plaint. Heard so and so. The petitioner is the defendant, the respondent, plaintiff. A suit comes to be instituted by the respondent in OS 873 of 2019, seeking relief of declaration, and permanent injunction against the respondent. The proceedings go on. Written statement is filed, issues are framed on 23/3/2021, and the trial is now fast progressing. The learned counsel for the respondent submits that it is at the stage of cross-examination of the defendant, witnesses of PW1, At that stage, the petitioner comes up with an application, petitioner defendant comes up with an application in IA 3 of 2024, seeking rejection of the plaint on the score that it does not divulge any cause of action and is hopelessly barred by limitation. On both these scores, the matter is contested qua the application under Order 7, Rule 11. The concerned court passes an order rejecting the application on the score that the cause of action did arise to the plaintiffs in the year 2018, when there was disturbance with the peaceful possession of the plaintiff by the defendant. And thereon, therefore, the suit filed in the year 2019 was well within limitation. Insofar as the plea of cause of action is concerned, the concerned court clearly holds that cause of action, the plaint averments clearly depict cause of action. The concerned clearly depicts cause of action. The rejection of the application filed under Order 7, Rule 11 is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that the averments in the plaint would clearly indicate that there is no cause of action for the plaintiff to file the suit, as the sale deed upon which the plaintiffs would derive their right is of the year 1972. And since 1972, there has been no, after 1972, there is no litigation that is projected by these by the plaintiffs to derive cause of action to file the suit in the year 2019. He would contend that on both the counts of loss of cause of action and delay, on limitation, the plaint ought to have been rejected. Its non-rejection is erroneous and contrary to the judgments of the apex court. He would seek to place reliance upon the judgment of the apex court in Nikhila Divyang Mehta and the other Raghuvanshi.
Adu Ramisetti.
And in Ramisetti Venkatanna, so and so. MR Shartan, yes, sir.
Similar.
All to buttress his submission that if the plaint averments would not disclose cause of action or it is hopelessly barred by limitation, the court should entertain the application under Section Order 7, Rule 11 and reject the plaint. Per contra, the learned counsel G.S. Srikattakauda, appearing for the KVTR plaintiff, would submit that the suit is now 6 years old. The stage is at the cross-examination of PW1. At this stage, after completely participating in the suit, the application is preferred under Order 7, Rule 11 on the score that the plaint averments would not divulge any cause of action. he would submit that submit that it's too late in the day for the petitioner to contend that the plaint should be rejected for want of cause of action. Even on the merit of the matter, the counsel would contend cause of action is clearly indicated in the plaint itself, as for the first time disturbance with the peaceful possession is made by the defendants in the year 2018, and the suit is registered in the year instituted in the year 2019. Therefore, there is neither want of cause of action nor the suit barred by limitation. I have given my sounds. The aforenarrated facts are a matter of record. A suit in OS 873 of 2019, renumbered as 1175 of 2022, is instituted by the respondent plaintiff seeking relief of declaration and permanent injunction. The cause of action and the reason for filing the suit is what is narrated in paragraph 11 and 12 of the 11 to 13 of the plaint. It reads as follows, page 33 to 35. It is trite law that for an application to be considered under Order 7, Rule 11, what is required to be considered by the concerned court is the plaint averments and not the defense setup, nor the contents of the application filed under Order 7, Rule 11. If the plaint averments would disclose cause of action, it would suffice for entertainment of the suit. The perusal at the paragraphs quoted herein above clearly indicates the cause of action in the year 2018 for instituting the suit, as the suit is for declaration and permanent injunction. The relief that is sought is on the basis of the documents that are filed before the concerned court under Order 7, Rule 14, which was a permissible exercise at the time of institution of the suit. Therefore, finding no merit in the petition, therefore, there is no warrant of interference to the order passed by the concerned court. Insofar as the judgments relied on by the learned counsel appearing for the petitioner, there can be no qualm about the principles so laid down by the apex court in the aforesaid judgments. The judgments would not lead the petitioner anywhere, as they are distinguishable with the facts obtaining in the case at hand without much ado. In that light, finding no merit in the petition stands rejected.
The petition may be permitted to urge this ground before the court.
ಯಾವ ground, sir?
This
Order 7, Rule 11 na?
no, my lord,
This
order may not come in the way of the final.
ಇನ್ನೊಂದು application ಹಾಕ್ತೀರಾ?
Final judgment.
Final judgment ಇದಕ್ಕೆ ಏನು ಸಂಬಂಧ?
This order, they
The
can.
observations made in the course of the order is only for the purpose of consideration of the case of the petitioner, the application in Order 7, Rule 11, and would not influence or bind further proceedings before the concerned court. Saka?
Yes, 2019 suit.
Correct, sir.
Direction may be.
ಅದು ಮುಂಚೆನೆ ಹೇಳಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್
ಲೇಟ್ ಮಾಡ್ತಾ ಇರೋದು.
ಇಲ್ಲ, ನಾವು ಮಾಡಿಲ್ಲ.
ಅವರೇ ಲೇಟ್ ಮಾಡ್ತಾ ಇರೋದು. ನಾವೇನ್ ರೆಡಿ ಇದೀವಿ ಯಾವಾಗ?
Please.
ಎಸ್. ಹೌದಾ?
Suit for partition.
ಮತ್ತೆ ಕೊಟ್ಟ ಇವತ್ತು. ಎಂಟ್ರಿ ಮಾಡ್ರ ಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಸೆಕ್ಷನ್ ಅದು ಬರೀ ಮೇಡಮ್. ಸೀಲ್ ನಂಬರ್ 47. Then
Please. Suit for partition filed by the plaintiff alleging her half share in the suit A and B schedule.
Partition suit,
Partition suit.
Order 7 Rule 11 rejected,
Rejected.
No.
No, 2 minutes, Your Lordship.
Yes, sir.
21 years, after lapse of 21 years, they have come up with this frivolous suit.
Partition is a continuing cause of action.
Yes. They are contending that State Amendment Act is applicable and not the Central Act.
Amendment bagena?
Amendment ಬಗ್ಗೆ. 9/9/2005 Central Act is applicable anta nam contention. They contend that Karnataka State Amendment Act of 1990 is applicable, which is commenced from 37/1994 anta. What is their contention? And their honorable trial court has accepted their version and have rejected my application for rejection.
Covered by this honorable court judgment, my lord.
I am relying upon the coordinate court of this,
Coordinate bench, sir.
coordinate bench of this honorable court, citation,
Coordinate court of this bench, Chandra.
coordinate bench of this honorable.
Yes.
Please.
I'm not, this is covered by.
Partition 711, very difficult.
No, it is aptly applicable.
Lord, the relevant portion is at para 14, my lord.
Same argument, rejected.
Let me submit other citations for your
Kodi,
lordship's
sir.
consideration.
Kodi.
Kindly. Latest judgment of coordinate bench of
Vinita
this
Sharma,
honorable
ಆಯ್ತು
court.
ಆಮೇಲೆ ಇನ್ಯಾವುದಿದೆ ಸರ್?
Serial number 4174.
ಯಾವ್ದಿದು?
Last page, para number 21H.
174.
I may be permitted to read. The Karnataka amendment, may I please your lordship? The Karnataka amendment in terms of section 6A has to be restricted to only those cases where suits were filed between 30/7/1994 and 8/9/2005 and are concluded on or before 2005 amendment. After considering the ratio laid down by the apex court in Vinita Sharma's case,
The court was answering an RSA.
Maybe.
Here, court is answering a CRP. Law, of course, maybe.
True.
But rejection of a plaint answering an RSA stand on different footing.
The proposition of law is settled. Your
Proposition of
lordship.
law is a different thing. Their consideration is on different footing.
The law applicable to both the case on hands are very similar. This suit is of the year 2020-23.
No, the horizons of consideration vary between an RSA and a CRP.
The applicability
See,
of law is
ultimately-
very same.
Law is, I'm not telling about, if it is barred by law, yes, CRP is a different thing. Now here, on the basis of evidence, the coordinate bench discusses everything and.
No.
holds-
I'm only highlighting the para number 21H of the this coordinate bench of this honorable court. 21H, which is aptly applicable.
Lord, same, my lord, followed by the same.
Kudiyat, will answer it. Needs an answer, yes.
The relevant portion is at
Para 9.
9, my lord.
CRP ಬರೋದೆ, Order 7 Rule 11 ಬರೋದೇ ಇಲ್ಲ.
Let me convince your lordship. It is aptly applicable and the law is very clear. 9/9/2005 ಬಂದಿದ ತಕ್ಷಣ ಸೆಂಟ್ರಲ್ ಆಕ್ಟ್ ಬಂದಿದ ತಕ್ಷಣ ಸ್ಟೇಟ್ ಆಕ್ಟ್ has no application.
You can urge this there and the suit, not in rejection of a plaint.
No.
Plaint governments clearly make.
ಅಲ್ಲ,
If it is
2012
totally barred by
ಮುಂಚೆನೆ
law.
ಎಲ್ಲ
ಇಲ್ಲ, ಇದೆಲ್ಲ.
transaction ಆಗೋಗಿದೆ. Admitted.
ಎರಡು coordinate bench judgment on CRP itself.
Apex court judgment, your honor,
ಯಾವ್ದು
you should
apex court
appreciate
judgment?
apex court judgment in Vinita Sharma's case as
ಅದಾದ್ಮೇಲೆ ಸರ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬರ್ದಿರೋದು ಇದೆಲ್ಲ. Those are all for the, on the merits of the suit, not on rejection of a plaint.
even
Partition ವಿಷಯದಲ್ಲಿ
admittedly the sale transaction to the defendant was 2012-2004.
Ultimately, you may succeed in the suit. That's a different thing. But doesn't
But
mean the
what is
plaint.
the use contending?
No, use ಅಲ್ಲ. That doesn't mean plaint should be rejected.
ಟ್ರಯಲ್ ಇದು ಮೇಂಟೈನಬಿಲಿಟಿ ಇದ್ರೆ ಮಾತ್ರ ಟ್ರಯಲ್ ಕಂಡಕ್ಟ್ ಆಗ್ಬೇಕು, ಅದರ್ವೈಸ್ ಇಟ್ ಇಸ್ ಅ ವೇಸ್ಟ್ ಆಫ್ ಪ್ರೀಶಿಯಸ್ ಟೈಮ್ ಆಫ್ ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್.
Oh, don't worry about that, sir. Yes.
No, your lordship. As per your lordship's version, we might succeed in the suit on this ground. But what is the ground on continuing the suit? It is liable for rejection.
You might succeed on that. That is the ground to continue this.
Let me engage the services of senior counsel.
Okay, this is wrong. You have made the Herculean effort. It's not that.
No.
I'm not saying you can't convince. That is wrong. In fact,
Considering the division
in fact,
bench.
you have done an excellent job.
Let
The
me
law is
complete
voted
this
against you
reading
in
of
March.
this paragraph at least, my
You
lordship,
need
please.
not get a senior counsel for this.
Let me complete the reading of this paragraph and try to convince your
Yes,
lordship,
yes,
please.
yes.
The Karnataka amendment in terms of section 6A has to be restricted to only those cases where suits were filed between 30/7/1994 and 8/9/2005 and are concluded on or before 2005 amendment, that is central amendment. After considering the ratio laid down by the apex court in Vinita Sharma's case Supra and the ratio laid down by the division bench of Honorable High Court of Karnataka in Padmavati versus Jayama Supra, it can be safely concluded that for the cases covered under Hindu Section Amendment Act of 1990 from
Counsel.
37.
Has the court anywhere said that the suit itself was not maintainable in this?
The applicability of Karnataka state amendment has been restricted to certain dates.
That is discussed in both these cases also. But this was earlier to Vinita Sharma.
No. This is subsequent to Vinita Sharma.
Sir, suit, judgment coordinate bench 24 though, suit ಯಾವ ವರ್ಷದ್ದು? FDP proceedings of 32 of
Second appeal
2005.
2010 and second appeal 2010. I do agree with your lordship, but the applicability of law is very clear. That is what my submission is.
We'll answer it, yes. We'll post it on Wednesday. You do some more research and come if you want.
Please.
I will also do some research.
Please, Your Lordship.
Yes. Whether this should become applicable to CRP, Order 7, Rule 11, where nothing of your defense can be seen.
My defense, I am not urging my defense. Only the plaint governments and plaint related documents I am relying upon. That's all.
We'll see. Yes.
Please.
The next Thursday.
Thursday,
Next
19th.
Thursday. 19th. Now don't get a senior counsel.
Please.
You made sincere effort, you continue that effort.
For the review petitions, my lord. This review petition.
Delhi, Pawan Chandra Shetty.
2021.
Senior is held up in the other.
Allah, matter is already covered by the decision of the coordinate bench of this court. I have already produced it. In fact, this order, my lord, which I am seeking review, has been passed based on an erroneous presumption.
Stay ಮಾಡಿದ್ದೀರಾ?
That the
Stay ಮಾಡಿದ್ದೀರಾ?
stay ಮಾಡಿದ್ದೀರಾ? 2021 ನಾವು ಮೂವೇ ಮಾಡಿತ್ತಿಲ್ಲ, ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿ, ಸ್ವಲ್ಪ ಫ್ರೀ ಆಗಿದ್ದೀರಾ ತಾವು?
ಗೊತ್ತಾಯ್ತು, ಫ್ರೀ.
On the basis of a letter.
I hope so and guess.
On the basis of an alleged letter of clarification dated 23/2018, my lord has got.
That is why I have entertained the review.
Yes, madam. Now kindly see the judgments which have.
Justice Suraj Govindraj.
All issues have been clarified.
Yes,
it is
madam.
automatic.
Automatic.
The operation by operation of law, it is automatic. The director of municipal.
follow ಮಾಡಬೇಕಾಗಿರೋದು automatic.
No, sorry. It is not meant.
Yes.
The exemption granted under the act is automatic, and it is for the government has got power under section 323 of the Municipalities Act. This is a mischievous letter addressed by the director of municipal administration. He has no authority in
It
law.
appears so. Now, you tell me one thing.
Yes, madam.
You are an educational institution.
Yes, madam.
You are not an educational institution which is giving free education. 1 minute, Purti.
Yes.
You are not an education. Now, ನಿಮ್ ತರ ಸುಮಾರು ಇದ್ದಾರೆ.
Correct.
All over the state, all over the country.
Correct.
There are big schools charging hefty fees.
Yes, madam.
No problem. In the name of education,
Yes.
you don't pay municipal taxes.
Correct.
Because you say the buildings are exempt
Yes, madam.
from taxes.
I agree.
There are many people who have on the lands constructed buildings and given them for rent to run educational institutions.
Correct.
Now they are collecting rent from the educational institution, but don't pay municipal taxes because they are run as educational institutions.
That is answered by Justice Coordinate Bench of this.
Is it not a loot?
That is correct.
Is it not a loot of public money?
No,
Tell me.
my lord, what has happened is
You
all,
free education kodi, municipal taxes exemption kedi.
all
If you are charging fees from every public, you better well pay taxes, sir.
no, my lord, in fact, this was
You can't.
circular as I have produced
We'll
the circular
see,
of the government.
We'll deal with it.
Kindly see the circular which I have produced along with my review petition.
Time has come to deal with it.
ಅಲ್ಲಲ್ಲ ಮಾಡಿ ಡೀಲ್ ಮಾಡಿ ನಾನು ಬೇಡ ಅಂತಲ್ಲ ಆಲ್ ಪ್ರೊಫೆಷನ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಆಲ್ ನೊಬೆಲ್ ಪ್ರೊಫೆಷನ್
Noble-
ನಾಟ್ ಓನ್ಲಿ ವಿತ್ ಎಜುಕೇಶನ್
Noble profession.
ನಾಟ್ ಓನ್ಲಿ ಎಜುಕೇಶನ್ ಈವನ್ ಹಾಸ್ಪಿಟಲ್
ಪ್ರೀ
ಇಂಡಸ್ಟ್ರಿ
ನರ್ಸರಿ ಇಂದ 12th ವರೆಗೂ ಎಷ್ಟು ಫೀಸ್ ಚಾರ್ಜ್ ಮಾಡ್ತೀರಾ ಅಂತ ಗೊತ್ತು. ನಿಮ್ದು ಇಲ್ಲದೆ ಇರ್ಬೋದು.
ಎಲ್ಲ ಊರಲ್ಲಿ ಎಲ್ಲ ಬೆಂಗಳೂರು ಕಾರ್ಪೊರೇಷನ್
ಎಲ್ಲರೂ ಇರ್ಲಿ ಸರ್. ಇದರಲ್ಲಿ you are not running the education institution.
we are yes
ಅಲ್ಲ, you are
All the
owner of the
petitioners.
property.
all the petitioners we are running
One
the
minute,
education sir.
land belongs to you.
ಲ್ಯಾಂಡ್ ಅಲ್ಲ ಹೌದು ನಮ್ದು ಟ್ರಸ್ಟ್ ಇದೆ ಟ್ರಸ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸಂಪ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಗೆ ಮೊದಲಿಂದ Now kindly see, this is the
See,
same
this-
answer.
This is how taxes are taken up.
Allah, kindly turn to, for a minute, paragraph 8 of the judgment of the coordinate bench.
I have seen
Identical question has
Seen
arisen.
that. I have seen that. I have seen
And
that.
it
I
is
have
for-
myself held in some cases that tax is not applicable. In, see, 23rd December 2021 Indus Trust case. I have followed that, but it should be.
It should be-
see, it should be clear that if the educational institution is run by the owner of the land, then yes, land alli kattadu, where huge rent, lakhs together rent on a month you get, no tax.
And what is important, the coordinate bench has held. What is
We'll
important
see.
to be considered is the
We'll
purpose for which the
concentrate.
land and building are put to, and not who the owner is. Predominant purpose building aste, not for the persons. So I can construct the building today. I can let out the rent. I can claim exemption. That has to be left to the wisdom of the legislature. ಅವರು ಇರಬೇಕೆಲ್ಲ.
Wisdom is the problem.
Wisdom is the problem.
Wisdom should dawn ಈಗ.
Dawn. So therefore, it is for the legislator to look into that aspect of the matter. In fact, the constitutional validity of this act came up for consideration in 89. 89 ಅಲ್ಲಿ circular has been issued by the government itself, stating that there should be no collection of a condition ಏನು ಇಲ್ಲ, it is totally exempt ಅಂತ ಅವರೇ ಕಳಿಸಿದ್ದಾರೆ. I have produced that annexure B. So the letter your lordship have placed reliance runs contrary to the government circular itself.
Next week, any date, madam?
Finally, I am giving one date. ಮತ್ತೆ if Constance Shetty does not come.
Next.
Yes.
Then I will allow the petition. Yes. List the matter on 19th as a last chance.
20th.
20th, all right. 20th as a last chance. If no submissions are made, the order under review would be recalled.
I am also for imposing taxes. I know what is going on in Bangalore, especially in metropolitan cities. For 1 lakh, 2 lakh rupees,
You
even for
should-
pre-KG
The
nursery.
state should come up with something where you bifurcate. Rural education, rural students, yes, all right.
Yes, yes.
Where educational institutions are run for bona fide purpose.
These are all commercial.
Educational institutions are run for commercial, education has become a commercial thing.
Everything has become commercial now. All noble education
Okay, you
like
should-
education, health,
Annual
including
wisdom
ours.
dawn on you, we don't understand.
Much. And moreover, many educational institutions are run by the legislators themselves. Bigger educational
ಯಾವ್ದು ನೀವು
institution.
ಫಿಲ್ಮಿ ಸ್ಟೈಲ್ ಹೇಳ್ಬೇಡಿ ಬಿಡಿ ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಎಲ್ಲ ಇದೆ, ಸುಮಾರು ಜನ ಇದ್ದಾರೆ ಅಲ್ಲೇ. Therefore, they are not amending because it affects them.
We'll see.
Interim order
We'll
will
pass
continue.
some order here. Interim order subsisting will continue to the next date of hearing.
ಅದೇ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೋದು ಅಷ್ಟೇ, ಲೆಜಿಸ್ಲೇಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಅಂತ.
ಅದು ನೋಡಿ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಂತ ನೋಡ. ಆರ್ಡರ್ಸ್ ಮುಗಿಸ್ಬಿಡೋಣ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಇದೆಯಾ? 3:30. ಆ 3:30 ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀವಿ. ಒಂದು ಪಾಸ್ ಓವರ್ ಜಗದೀಶ್ ನಿಮಗೆ ವೇಟ್ ಮಾಡ್ಕೊಂಡು. ಅದಕ್ಕೆ 3:30 ಬರ್ತಾರೆ ಅವ್ರು ಇರಿ ಅಂತ ಹೇಳಿ.
ನಾನೇ ಕರ್ಕೊಂಡ್
ನೀವೇ ಕರ್ಕೊಂಬಂದ್ರ? ಯಾಕೆ ಅವ್ರ ಕೋಟ್ ಬಿಡಕ್ ರೆಡಿ
some other court matters I requested him. ಬನ್ನಿ ನೀವು ಇಲ್ಲಾಂದ್ರೆ ತಗೊಳಲ್ಲ.
ಇಲ್ಲ ಜಗದೀಶ್ ಸರ್, ಇಫ್ ಯು ಆರ್ ಕಾಲ್ಡ್ ದೇರ್ ನೋ ಪ್ರಾಬ್ಲಮ್. 304B, the father is 83 years old. I have granted stay. The other is the sister-in-law. Sister-in-law resides elsewhere, and there is no question of instigating the death.
Except asking for 5 lakh rupees.
Huh?
5 ಲಕ್ಷ ಕೇಳಿದ್ರು ಅಂತ ಒಂದು ಅಲಿಗೇಷನ್ ಬಿಟ್ಟು.
ಇವ್ರು ಕೇಳಿದ್ರು ಅಂತ 5 ಲಕ್ಷ. But against the husband, there are allegations.
Even husband, against husband also, my lord. I have
ನೀವು
undertaken before
husband
this
ಗೆ
honorable.
ಹೇಳ್ಬೇಡಿ sir.
No, husband is not before this honorable court. my lord. I have undertaken before this honorable court. Husband is ready to face the trial. Even by reading of entire complaint and the statements of the relatives, my lord, so there is no allegation against the husband regarding the demand of dowry.
But it's not, see, it's not a plain case of 498A.
Yes, my lord.
It's a death of a lady.
Lady and the.
And who was with her is the husband
Yes.
and his father-in-law. Father-in-law ಎದ್ದೇಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಅತ್ತೆ ಮೇಲೆ
They themselves.
ಅತ್ತೆ ಇಲ್ವಲ್ಲ?
ಅತ್ತೆ ಇಲ್ಲ.
ಅತ್ತೆ is not before the court. ಮತ್ತೆ ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
ಅವರು. No more. No more. my lord.
No more.
And the separation of death note, my lord, and it is very much available. And the contention of my contention was from
That
the day
is-
one.
Let the evidence against the husband anyway is not before the court. ಈ 83 ವರ್ಷದವ್ರಿಗೆ ಯಾಕೆ ಟ್ರಯಲ್? We close it. Jai bhai. Dictate ಮಾಡಿ. ಅವರು
And my lords, I'm placing the judgments of the honorable appellate court, which.
304B da.
304B.
Close ಮಾಡಿ.
Role against her is not the 304B, it's only about. Can be
ಅಲ್ಲ
closed.
ಇವ್ರ ಮೇಲೆ 304B ಇಲ್ಲವೂ ಇಲ್ಲ. See, against the father ಎಲ್ಲಿದೆ 304B?
They have filed for.
Charge sheet,
Charge sheet for
charge sheet.
304B at page number, my lords, in
Sheet ಅಲ್ಲೂ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. 5 ಲಕ್ಷ ಹೆಚ್ಚುವರೆಯಾಗಿ ಕೇಳಿದ್ರು ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
Page
ಅದು
30.
ಯಾವಾಗ ಏನು? Page 30?
Page 26, my lord. 26 of petition. Column 4. Column number 5, my lords.
Who is the accused number 2?
Accused number 2 is the father of accused number 1, my lords.
One is husband.
One is husband.
2 father. 3?
3 is sister of.
That is second petitioner.
Second petitioner.
She has consumed poison.
Carbamate. Poison. And the accused number 1, 2, they shifted her to the hospital, my lords. ಇವರೇ ಕರ್ಕೊಂಡು ಹೋಗೋದು. Conduct, my lords.
ಅದು ಏನು ಸ್ಟ್ಯಾಂಪ್ ಆಫ್ ಇನ್ನೋಸೆನ್ಸ್?
ಹೊಡೆದು ಬಿಟ್ಟು ಬಿಟ್ಟೋಗಿ.
ಅಲ್ಲ ಮತ್ತೆ ಏನೇನೋ ಆಗಿದೆ ಈಗ.
ಅಲ್ಲ ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ, my lords.
Today stamp of innocence is very dangerous.
Yes, ma'am.
The petitioner is petitioners. Petition ಎಲ್ಲಿ ನಿಮ್ದು?
Page 4.
ಮೇಡಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಪೇಪರ್ಸ್ ಇದೆ. The petitioners are before this court calling in question proceedings in SC 742 of 2023 registered for offences punishable under section 304B 498A read with 34 and section 3 and 4, the 34 of the IPC and section 3 and 4 of the Dowry Prohibition Act. The heard so and so. Respondent complainant served.
Third, my lord.
ಯಾವಾಗ madam? Long back. 16/7/20. Heard the learned counsel Sunil Kumar appearing for the petitioner and the learned additional SPP B.N. Jagdish representing the respondent state. The complainant, though served on 16/7/2023, has remained unrepresented despite passage of 2 years. Facts in brief germane are as follows. The accused number 1, the husband of CW1,
No, my lords, husband of deceased.
the husband, the accused number 1, the husband of the deceased gets married. What's her name, sir?
Shaila Budihal.
Huh?
Shaila Budihal, Srimati Shaila Budihal.
Gets married to one so and so, so and so, on 21/12/2018. The relationship between the two appears to have turned sour, and on various grievances, the wife of the accused number 1 commits suicide on 7/3/2023.
26 to 2020.
26 to
2021.
26 to 2021. The commission of suicide of the wife of accused number 1 leads towards registration of a complaint. By who registers the complaint? By the brother by her brother. The complaint then becomes a crime in crime number
17.
Crime number 17 of 2021 for offences punishable under section 304B 498A read with 34 of the IPC. At the time of registration of the crime, the offences under the Dowry Prohibition Act were not alleged. The police conduct investigation, and conduct of investigation leads to filing of the charge sheet against all the accused, accused 1 to 3, for offences punishable under section 304B, 498A, 3 and 4 of the Dowry Prohibition Act, read with 34 of the IPC Act. Filing of the charge sheet is what drives the petitioners, the father-in-law and the sister-in-law of the deceased before this court. They are accused 2 and 3. The husband, accused number 1, is not before the court. The learned counsel appearing for the petitioner would vehemently contend that the father of the accused number 1 is now 84 years old, and at the time of the incident was 79 years old. There is no allegation against him that he has either tortured for demand of dowry or otherwise. The second petitioner is accused number 3, the sister-in-law. The learned counsel for the petitioner submits that the sister-in-law did not even reside with the couple. She is residing elsewhere with her family. The only allegation against the sister-in-law is as vaguely put that she had at one point in time demanded 5 lakhs. Barring this, he would submit that there is nothing that would touch upon the ingredients of either 304B, 498A, or even the provisions of the Dowry Prohibition Act. He would seek quashment of the proceedings qua these petitioners. The learned per contra, the learned additional SPP, while taking this court through the contents of the charge sheet, would submit there are at least sprinkling allegations against the petitioners herein. The police, after investigation, have filed a charge sheet, and therefore this court at this juncture, in exercise of its jurisdiction under section 482 of the CRPC, should not interfere, and it is for the petitioners to come out clean in a full-blown trial. I have given my anxious considerations. The afore narrated facts are not in dispute. The relationship between the parties to the list are as narrated. The accused number 1 husband is not before the court. He gets married to the sister of the complainant on 21/12/2018. It transpires the relationship between the two turns sour. Turning sour leads the sister of the complainant to commit suicide. The reason, the allegation now falls at the doors of the members of the family and the husband. The husband is not before the court. The members of the family who are before the court are the father-in-law and the sister-in-law. Since the entire issue triggered from registration of the complaint, I deem it appropriate to notice the complaint, page 19 to 1920. The complaint is registered on 27/2/2021. The incident happens on 26/2/2021. The allegation in the complaint is for demand of dowry or torture that has been meted out by the husband and the members of the family. The police conduct investigation. The investigation leads to filing of a final report, i.e. the charge sheet. The summary of the charge sheet as obtaining in column number 17 is as follows. A perusal at the summary of the charge sheet would indicate certain offences against the husband and not even a semblance of offence against the petitioners herein for it to become an offence under section 304B, which deals with dowry death, 498A, which deals with cruelty on demand of dowry, or 3 and 4 with regard to Dowry Prohibition Act. The narration is omnibus against all other, or against the other two, while particular acts are alleged against the husband in demand of dowry or torture meted out to the wife. The wife commits suicide, leaving behind a death note. The death note, the learned counsel for the petitioner submits. Learned counsel for the petitioner submits that the investigating officer did not take note of the death note, which would have absolved all the accused in the crime. Be that as it may, the afore narrated complaint or the summary of the charge sheet or even the statements rendered during the course of investigation would nowhere point at the offense against these petitioners, i.e. the father-in-law and the sister-in-law. It is an admitted fact that the sister-in-law did reside somewhere, and the demand vaguely alleged by the complainant against the sister-in-law is demand of 5 lakhs. At what point in time, when, where, and what is the torture meted out on that ground is not even narrated anywhere. In that light, permitting further proceedings against the petitioners, the father-in-law and the sister-in-law would run foul of the judgments rendered by the apex court.
2022 6 SCC 599 one judgment.
That is Kashkan Kaushar.
2014 14 SCC 401.
2014
Krishna Reddy Millers.
ಯಾಕೆ 10 ವರ್ಷ ಹಿಂದೆ ಎಲ್ಲ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
2023 Millers Charan Singh.
ಅದು ಒಳ್ಳೇದಾಯ್ತು.
No Millers. Latest.
Latest.
304.
23 latest.
23.
The learned counsel for the petitioner submits that would run foul of the judgments rendered by the apex court so and so. While the aforecourt, the aforequoted judgments are an amalgam of consideration of the cases of offense punishable under section 304B and 498A of the IPC. Insofar as the offense under 498A, as that is also the one that is alleged in the charge sheet, the apex court in 2025 SSC online SC page 1301 in Ghanshyam Soni versus State of Uttar Pradesh has clearly held that drawing every person into the web of crime of the family should be nipped, and the apex court clearly holds that this court exercising jurisdiction under 482 of the CRPC must necessarily go into the details of the complaint and obliterate the crime if it becomes so necessary. Quote para 10 to 12 in that. Yes. In that light, and finding that there is no allegation that would touch upon the ingredients of either 304B, 498A or Dowry Prohibition Act against these two petitioners, permitting further proceedings would become an abuse of the process of the law and result in miscarriage of justice.
Much of course.
We should know that instead of going back, you'd go front.
ಯಾವುದಕ್ಕೆ?
Judgment.
All other judgments. This 2014 is while discharging the 304B Millers, the Supreme Court has laid down the law.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅದು ನಿಮ್ಗೆ ಕೋಟ್ ಮಾಡಿ ಆಮೇಲೆ ನಮ್ದು ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. Ghanshyam Soni is the latest.
And 14 is 14 is on 304B Millers.
Ghanshyam Soni is 9th June, sir. Yes. 9th June ನಾನು ಅದೇ ಹೇಳಿದ್ದು. ನೋಡ್ತಾ ಇದ್ದೀರಾ ಸರ್? ಎಸ್. Orders now. In terms of
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಇವರ
ಮೆಮೊ ಹಾಕಿದಿರಲ್ಲಮ್ಮ. ಏನಿದೆ ಎಷ್ಟೊಂದಿದೆ ವಿಡ್ರಾ, ಅದು ವಿಡ್ರಾಲ್ ಅಂತಿದೆ. ನಾಟ್ ಪ್ರೆಸ್ ಮಾಡಿ ರೀಪ್ರೆಸ್ ಮಾಡಿ. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
There is, because IA number 2 consolidates what was filed in IA number 1 only. Therefore, we sought to withdraw the IA number 1. The IAs are in support.
SBI da order 7/11.
Yes, Your Lordship.
Rejected.
No, it is the suit is rejected.
Okay.
Yes, sorry, plaint is rejected. I'm sorry.
Plaint is
the order
rejected.
is, my application is allowed.
Allowed.
My application is allowed. Their plaint is rejected.
Yeah.
7/11 application is allowed. They say cause of action illa anta ಹೇಳ್ತಾರೆ.
SBI ಗಲ್ವಾ?
SBI
cause of action ಇರಲ್ಲ ಬಿಡಿ.
ಅವರು ಹೇಳಿ cause of action ಇಲ್ಲ
ಅಂತ. ಬಾರೋರ್ ಇವರು?
ಬಾರೋರ್ ಕಾರ್ ಲೋನ್ ತಗೊಂಡಿದ್ದಾರೆ, ಲಾಸ್ಟ್ ಕಾರ್ ಲೋನ್ ಕಟ್ಟಿಲ್ಲ, ಡಿಫಾಲ್ಟ್ ಇದೆ. ವರ್ಚುವಲಿ my lords, if your lordships may kindly look at the suit or the written statement filed, virtually it is one thesis ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ.
Governed by what, sir?
Please, my lords.
Governed by what? Hire purchase agreement.
Hire purchase agreement.
Not surface proceedings,
Not surfacing.
Small causes only they have filed, your lordship.
small
The
cost.
entire amount has been paid. A statement of accounts only I can show. All the installments have been paid. If they do show default, your lordship, then I will step back. The entire principal amount is paid along with interest.
That is a demonstrable question, my lords, when in a 7 to 11 application, not that I am for a moment wanting to say that they have paid, and still, if my plaint government were to indicate that it has been.
What is the amount of loans, sir?
7.6 lakhs, your lordship, is the loan. Statement of accounts noted in the end, 10.6 lakhs has been paid. Principal amount along with interest has been paid. Out there statement of accounts noted.
Recovery/refund of money ಹಾಕಿಲ್ವಾ ನೀವೇನು? ಅದೊಂದು ಹಾಕಿ ಸರಿ ಹೋಗುತ್ತೆ.
My lords, we can demonstrate what my learned friend wants to say. The other side, loan ಇಷ್ಟು ತಗೊಂಡಿರೋದು ಇಷ್ಟಿದೆ, ಇವರು 9 ಲಕ್ಷ. What should happen to the interest part ಅಲ್ಲಿ ಅಲ್ಲಿ ಹೇಳೋದಿಲ್ಲ.
ಆಯ್ತು, ಎಷ್ಟು ಬಾಕಿ ಇತ್ತು?
ಬಾಕಿ no, my lords, I should confess, may kindly be have it tomorrow. I'm just running from Kotal to ಇವಾಗ ಒಂದು ಮ್ಯಾಟರ್ ಇತ್ತು.
ಫೈಲ್ ಇಲ್ವಾ?
ಫೈಲ್ ಅಲ್ಲೇ ಅದರ ಜೊತೆ ಬಿಟ್ಟು ಬಂದ್ಬಿಡಿ.
ನೀವು ಅಲ್ಲೇ ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅದ್ರ ಆ ಕಂಪೈಲೇಷನ್ ಜೊತೆ ಇತ್ತು.
All right.
I'm sorry.
Next week.
A date may be given, your lordship, because it was part dictated actually by the coordinate bench.
Should I send it there?
No, your lordship. I'm just saying that a date may be fixed, your lordship.
19th.
Yes.
19th is a date.
Yes, yes. I'm sorry, I did not hear.
No, I got confused whether I said Thursday or 19th.
No.
Yes.
Great.
Two weeks.
I am for petition. Rest 2 weeks.
Fresh 2 weeks. No grants. Where is files? ಅವರು ಸೀನಿಯರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾ ಕೇಳಲಿಲ್ಲ ಅವ್ರು. ನೀವು ಅವ್ರ ತರಾನೇ ಬಂದಿಲ್ಲ ನಿಂತ್ಕೊಂಡ್ರೆ. Where are the files?
ಕೌನ್ಸಿಲ್ ಹುಷಾರಿಲ್ಲ, ಅವರು ದೇವನಹಳ್ಳಿಯಲ್ಲಿ ಇದ್ದಾರೆ, ಅದಕ್ಕಾಗಿ
Not wells. Grants time. ಯಾರು ಮೂವ್ ಮಾಡಿರೋದು? ನೀವೇ ಮೂವ್ ಮಾಡಿ.
ಅಲ್ಲ ಎಲ್ಲ ಕೌನ್ಸಿಲ್ ಮಾಡಿ.
List after 4 weeks.
Now, these two CRPs arises under section 83(9) of the Work Act. The applications filed by the respondent have been allowed, and the bylaw
Suit is plaint is rejected. Plaint rejected.
Sorry, my lord.
ಏನಾಗಿದೆ?
The bylaws have been now set aside, and direction has been issued to the board to frame a fresh bylaw and hold an election. The bylaw, the contention of the petitioner, the respondent is that he has not been heard, is the only ground taken before the tribunal.
Set aside.
Idralli, he is not belongs to that jurisdiction of the Nalbandwadi Masjid. He is a member of another masjid. That
For respond number 1, my lord, I file objections, my lord. I take notice for respond number 1, that private party.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲೇ my lord, see number 55 ಅಲ್ಲಿ.
R1 ಕೇವೇಟ್ ಹಾಕಿದ್ದೀರಾ?
ಕೇವೇಟ್ ಹಾಕಿದ್ದೀನಿ my lord, but
ಮತ್ತೆ ನೋಟಿಸ್ ತಗೊಳ್ಳೋದು.
ವಕಾಲತ್ ಬಂದಿಲ್ಲ my lord ನಂಗೆ. ಇವತ್ತು I have instruction today.
The learned counsel N. Kumar undertakes to enter appearance for the first respondent in both these cases. Registry to print the name of N. Kumar is appearing. Copy the
matter respond 1 and 2, my lord.
JY 55.1 ಅಲ್ಲಿ 1 and 2. Copy ಉಂಟಾ?
Copy ಇದೆ, my lord.
My lord, I have
ನೀವು
not
ಯಾರಿಗೆ?
for the board, my lord. Respond number
R4. What's the name, madam?
PU, representing PU, my lord.
PU?
PU Usman.
PU Usman ಅರ್ಧ ಕಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? ಇರೋದೇ ಇಷ್ಟು. PU ಅಂದ್ಬಿಟ್ರೆ. Yes. Learned counsel. Other already name is shown. Yes.
This for the board, my lord. I'm not being served the copy in.
Copy ಕೊಡಿ sir. Copy ಕೊಡಿ sir.
Old your lordship it has to be heard only at the time of final hearing. So far as now the.
We'll post it for final hearing.
Only thing is that now the bylaws have been set aside at the instance of one person saying that he has not been heard.
Your lord, he was not an interested person, he is not a resident of that area, and all that, your lordship has to be considered.
We'll
Now,
see.
lord, by virtue of the setting aside the lord bylaws, now therefore lord, the interim order is required. Let them lord bylaws.
ಆಯ್ತು 3 ತಿಂಗಳಾಗಿದೆಯಲ್ಲ, ಎಸ್ 6 ತಿಂಗಳಾಗಿದೆ. List on get ready on 19th I'll take it. Ask Usman. Yes.
Yes.
Post immediately after service of notice upon the respondent.
Permitted to serve on the council of.
Learned counsel for the petitioner shall serve on the counsel who represented the respondent in the trial proceedings. Serve ಮಾಡ್ ಬಂದ್ಬಿಡಿ. ಆಯ್ತು ಹಂಗಾರೆ ಅದು ಫಸ್ಟ್ ಒನ್ ಬೇಡ, ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಆನ್ 19th. Post immediately after service of notice upon respondents 1 to 3.
My lord, with due respect, I have served the respondent's counsel who is appearing before the
Early.
trial court. My lord, kindly take this memo on record.
You
And service may be
take the
complete,
files
my lord.
onto this hand.
Yes, sorry.
Now do it. Yes.
I have served the learned counsel appearing for the plaintiffs before the trial court. He in fact sent an email to me during the vacations, my lord. I have served the papers.
No problem. We'll take it on 19th. If they don't come, we'll pass it. Yes.
Much obliged.
List on 19th.
There appears to be some office objection on my wakalat. I shall rectify it. Kindly have it on 19th.
Yes, Varadarajan sir.
Before that minutes.
Enter ಮಾಡಿದ್ಯಾ?
Intermatter ಕೇಳಿದ್ದೀನಿ. What I am saying is
I will
this.
file objection.
Minutes. Now the court directed the BBMP engineer to file a report. That report is before the court.
We'll
The
see.
BBMP has clearly
Let it,
said.
not in
he
this,
has constructed.
not in this stage. List the matter, list the matter on Tuesday.
Please.
Tuesday.
Tuesday.
A 6th crime respondent unclaimed ಅಂತ ಬಂದಿದೆ. Notice may be entered sufficient.
1 minute. Insofar as the service of notice upon 6th respondent, the Shara indicates that the notice is unclaimed, therefore registry to print the name of 6th respondent and show him as served. Yes, list on Tuesday. Next.
We have been served on the other side.
ಯಾವ್ದಿದು?
The written statement has been allowed, and only within 6 days that order has been recalled. Your lordship directed us to file the amended written statement. Yesterday the matter was before the trial court.
Stay ಮಾಡಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ stay ಮಾಡಲಿಲ್ಲ. Go and file the written statement and amend the written statement ಅಂತ ತಾವು direction.
ಏನ್?
I'm sorry.
ನೀವು ಕೋರ್ಟ್ ಇರ್ಲಿಲ್ವಾ?
ಇದೆ.
ಮತ್ತೆ? Yes. Your name?
Kaushik.
Kaushik.
Please.
Correct. Counsel Kaushik undertakes to enter appearance for the respondent. 1 week, 2 weeks?
Disposed of eviction suit, my lord. They have been.
Eviction tenant?
Landlord.
Landlord? Or landlord?
Dispute between the landlord and tenant.
Correct.
They don't agree.
Landlord tenant ಅಂದ್ಮೇಲೆ dispute. Yes. List on 19th in preliminary hearing.
Disposed of now itself.
ಇವತ್ತೇನಾ? ಅವತ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ 16th ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
Then list on 16th ಇದೆಯಾ?
ಹೌದು ಅವರು
16th
I don't know about the orders passed by this and hence I want time to 16th ಅಂತ ಅವರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು.
ಡೋಂಟ್ ನೋ ಏನು ಇದೆಯಲ್ಲ ಇಲ್ವಾ? ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ ಅದು? ನಿಮಗೆ ಡೋಂಟ್ ನೋ, ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ.
ಅಪ್ಲೋಡ್ ಆಗಿದೆ.
ಯಾರು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅಂದಿದ್ದು?
They file a wrong memo. They say, they don't say that the matter has been stayed. They come and say that I was allowed to file the amended statement. There was no such order.
No, he did not, doesn't know what the order is.
Correct.
Yes.
Sorry, it is a mistake.
Stay ಅವತ್ತೇ ಕೊಟ್ಟಿದ್ದೇನೆ. Yes. Because it was recalled in 6 days, I have done that. Otherwise, we'll close the petition and send it Monday. Monday we'll dispose it. Monday in preliminary hearing. Notice.
For petition, my lord, this matter, my lord, notice has been served, my lord. 20
Notice
days delay.
ಆಗಿದೆಯಾ?
20 days delay is there, my lord, your lordship.
Control ಮಾಡೋಣ.
It's a recovery of 45,000 suit decreed small causes court, and he has paid amount, partial payment has been made in.
ಇನ್ನೆಷ್ಟು
Time of
ಕೊಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ?
execution of the, my lord, execution proceedings, my lord, warrant has been issued, my lord. At
Correct,
time of
sir.
execution of-
ಎಷ್ಟಿದೆ ಮಿಕ್ಕಿದ್ದು?
My lord,
45,000 ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
in one matter, my lord, 25,000 we have paid, my lord, first
Fine.
matter.
Decreed
Second
for
matter,
72,100.
72,000?
100 ನಲ್ಲಿ ಅವರು 25,000 they have paid, my lord.
ಇನ್ನು ಮಿಕ್ಕಿದ ಯಾವ
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ 50,000 ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇನ್ನೊಂದ್ರಲ್ಲಿ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎರಡು ಇದೆ ಸ್ವಾಮಿ. ಎರಡರಲ್ಲೂ ಟೋಟಲ್ 75,000 ಕೊಟ್ಟಿದ್ದೀವಿ. 1 lakh.
ಟೋಟಲ್ ಎಷ್ಟು ಹೇಳಿ ಸರ್ ಇಬ್ರು?
Approximately 50% we have already.
ಇಬ್ರು ಹೇಳಿದ್ರೆ ಡಬಲ್ ಆಗುತ್ತೆ ನಿಮಗೇನೆ ವೆಯ್ಟ್.
ಕೇಸ್ 72,200.
ಒಂದ್ ಕೇಸಲ್ಲಿ
72,200 ಡಿಕ್ರಿಟಲ್ ಅಮೌಂಟ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 61,800.
ಟೋಟಲ್ ಎಷ್ಟಾಯ್ತು?
ಟೋಟಲ್ 70
139.
1,30,000.
They have paid 70,000 my lord. ಎರಡು ಕೇಸಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ 25 ಕೊಟ್ಟಿದ್ದಾರೆ, ಒಂದ್ರಲ್ಲಿ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
75 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 65 ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಎಂಟ್ರಿ ಮಾಡರ್ ಮೇಲೆ ಕೈಲಿ ಗ್ರಾಂಟೆಡ್ ಮಲ್ಲ.
ಫಸ್ಟ್ ಕೊಡಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಸ್ವಲ್ಪ ಬ್ರೀದಿಂಗ್ ಟೈಮ್ ಕೊಟ್ರೆ ನಾವು
ಬ್ರೀದಿಂಗ್ ಟೈಮ್
ಅಲ್ಲಿವರೆಗೂ ಎಂಟ್ರಿ ಮಾಡೋದು.
ಅಲ್ಲ ಬ್ರೀದಿಂಗ್ ಟೈಮ್ ಎಷ್ಟು?
4 weeks ಮಲ್ಲ. 4 weeks.
4 weeks. ಆಯ್ತು, ಅವ್ರಿಗೂ ದುಡ್ಡು ಬೇಕು ತಾನೆ. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 3rd July, 10th July. On the undertaking,
undertaking
on the submission of the learned counsel for the petitioner that he would clear the entire amount by the next date. In that light, proceedings before the concerned court in execution shall remain stayed. In the event the petitioner would not pay the entire amount, i.e. the remaining amount 68,000, remaining amount, the interim order would be vacated. ಇನ್ನೊಂದ್ಸರಿ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕಳ್ಸೋದಲ್ಲ, ಇಲ್ಲೇ ಕೊಟ್ಬಿಡಿ. ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ಕೊಡ್ಲೇಬೇಕಲ್ಲ.
ಹ್ಯಾಬಿಚುಯಲ್ ಇದೆ. 80 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. ಒಂದಕ್ಕೂ ಮುನಿ ಲ್ಯಾಂಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ನಮ್ದಲ್ಲೇ 2 ಹಾಕಿದ್ದಾರೆ.
80 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ.
ನಮ್ಮೇಲೇನೆ 2 ಹಾಕಿದ್ದಾರೆ. ಹೌದು. ಒಂದು ಕೇಸ್ಗೂ
ಅಂತ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ರಿಪೋರ್ಟ್ ತೆಗೆಸ್ಕೊಂಡಿದ್ದಾರೆ. ಈಗ he has signed the pronote and he has taken the amount for now running the computer center.
ಕಂಪ್ಯೂಟರ್ ಸೆಂಟರ್.
ಹೌದು.
ಆಯ್ತು ಸರಿ, ಮಿಕ್ಕಿದ್ ಕೊಟ್ಬಿಡಿ. ಎರಡು ಅಷ್ಟೇ 60-61 ಸೇಮ್. Delay condoned. IA for the reasons indicated in the affidavit accompanying the application and being satisfied with the same, as also the fact that respondent has no objection, and delay condoned.
61 allo enter ಮಾಡಿ.
Same order in 61.
Petitioner, my lord.
First time ಬರ್ತಾ ಇರೋದಾ ನೋಟಿಸ್? Notice returnable by 3rd. 63 same order.
Yeah, ask for a stay, Your Honor, because already executed.
Delay 82 days delay ಇದೆ.
So that's because we were ex parte, Your Honor. We didn't even know.
Ex parte?
Yes, Your Honor. It was ex parte. We
Let
didn't
me
know
see.
case.
If it's ex parte, I'll grant you.
Yes, Your Honor. It was ex parte.
How do you demonstrate? Oh, ex parte.
Yes, Your Honor. Only 2 times notice was sent directly. No steps were taken.
The petitioner is before this court calling in question an order dated 4th November 2024 in SC 15176 of 2023. The order indicates that the petitioner defendant was placed ex parte. In that light, there shall be an interim order of stay till the next date of hearing, 3rd July. Emergent notice to the respondent. Petitioner shall serve on the counsel who represented the respondent in the trial proceedings. Serve ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ interim order vacate ಮಾಡ್ತೀವಿ. 144 days.
My lord, in this case,
yes,
my lord, for the petitioners. Yes, my lord, in the first writ petition, my lord.
Review ಯಾಕೆ?
My lord, in the both the petitions have been, there is an order in my absence, my lord. I am the complainant, where from my shop, the person who is working in my shop has stolen the gold and pledged with these 2 entities, my lord. So there was 2 orders, my lord. In fact, I have challenged only 1 order. With regard to the other one, my lord, there is one more review petition has been filed.
Finance ಅಲೋ ಮಾಡದೆ ಬಿಟ್ಬಿಟ್ಟೆ ಆಮೇಲೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಏನ್ ಹೇಳಿ ಇಲ್ಲಿ ಹೇಳಿರ್ತೀರಾ, ಕವರ್ಡ್ ಅನ್ಬಿಡ್ತೀರಾ, ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಆಫ್.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ದಿ ಪರ್ಸನ್ ಹೂ ಇಸ್ ವರ್ಕಿಂಗ್ ವಿತ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ಸ್ ಆಫೀಸ್ 10 years ಇಂದ ಅವ್ರು ಇನ್ವೆಂಟರಿನೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ದೇ ಆರ್ ಗಿವಿಂಗ್ ಇನ್ ದಿ FIR ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 10 years ಇಂದ ನಾವು ಇನ್ವೆಂಟರಿನೇ ಮಾಡಿಲ್ಲ ಅಂತಾರೆ. ಸಡನ್ಲಿ ದಿ ಪರ್ಸನ್ ಹೂ ಹಸ್ ಪ್ಲೆಡ್ಜ್ಡ್ ದಿ ಗೋಲ್ಡ್ ಆರ್ನಮೆಂಟ್ಸ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ದಿ ವರ್ಕಿಂಗ್ ಇನ್ ದಟ್ ಪ್ಲೇಸ್. He is a different person and he is doing the business with the Muthoot Finance is last 4 years.
Why so many cases against you? You receive only stolen gold, is it?
Same person has gone and pledged more than half a kilo.
6-7 ಕೇಸ್ ಇರುತ್ತೆ. ಇಲ್ಲೊಂದೇ ಇಲ್ಲ, ಧಾರವಾಡದಲ್ಲಿ ಇದ್ರೆ ಅಲ್ಲೊಂದು 6-7 ಕೇಸ್ ದಿನಕ್ಕೆ. ಮನ್ನಾಪುರಂ, ಮುತ್ತೂಟ್ ಬರೀ ಇದೇನೆ. Why police are behind you? That's because you receive stolen gold.
It has been take over from
ಇದು ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇತ್ತಲ್ಲ, ನೀವು ಅಫೇರ್ ಆಗ್ತದೆ ಅಟಿಕಾ ಗೋಲ್ಡ್.
That's where
The allegation is that ಎಲ್ಲಾದ್ರಲ್ಲೂ allegation ಅದೇನೆ. You don't verify, is it?
No, we will verify, we will take.
Verify the credentials of persons who get it.
Yes, my lord. We will take all
In
the
fact, my lord, their
necessary-
brochure clearly
all
says how the ownership has to be proved. Except on affidavit they have taken, and based on that they have lent the loan.
KYC.
But similar order is passed in the other petition.
My lord, he
And
is taking
notice
and
may be issued in
giving
that,
the
and both
loan.
can be
Hearing the
heard
loan
on one
for
day,
last
my lord.
4 years.
ಇಲ್ಲ ಏನು ಮಾಡಿರಲ್ಲ KYC ಅದು
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ.
ಅದು ನಿಮ್ದು MKYC ಮನ್ನಾಪುರಂ KYC.
ಇಲ್ಲ ಈ as per the ಇದ್ರ ಪ್ರಕಾರನೇ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್
Anyway, when do you appear, Anand?
My lord, in 198 of 2025, my lord, it is against the Manappuram. Kindly notice may be issued in that, and the date may be fixed for hearing on both.
Emergent ನೀವೇ ತಗೊಂತೀರಾ ಅದಕ್ಕೆ?
ಇಲ್ಲ ನಾನಿಲ್ಲ ಸ್ವಾಮಿ.
ನೀವು ಮುತ್ತೂಟ್ ಮಾತ್ರನಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಮನ್ನಾಪುರಂ ಅವ್ರು ಯಾರೋ ಬರ್ತಾರಲ್ಲ ಮೇಡಮ್? Tall man.
My lord, in the writ petition, Mr.
Whoever petitioner to serve on the council who represented Mannapuram in the writ proceedings.
Purna Prasad, my lord.
List on 26th. Purna Prasad. Yes, Purna Prasad. Yes.
I'll serve a copy, my lord.
Yes, next. Impleading R7 to 15.
Petitioner ಎಲ್ಲ ಅಲೋ ಆಗಿದೆ. Matter has to be heard.
ಅಲೋ ಆಗಿದೆಯಾ?
Last week.
Cost rate amendment ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀವಿ.
The learned counsel for the petitioner submits that the impleading application is allowed and cost title also has been amended. Registry to responsibly list the matters in this stage. List the matter in B group.
Interim order to continue.
Interim order subsisting will continue till the next date of hearing. Yes, next.
Matter pertaining to acquisition lot of 2000.
Not small petition.
Huh?
Senior is not in this.
Wait, ಹೇಳಿ.
Lord, award is passed after Lord 16 years now. Lord, I am running a rubber industry there. Lord, they have
What
also
industry?
held rubber industry.
Rubber.
Rubber. Lord. They have held, Lord. Now, my Lord, they are now taking position. Though I am running industry. And my Lord, they inspected also. I am questioning my Lord award also now. Because 18, Lord, award is passed after
KDB na?
16
KDB na
years.
BD na?
16 years, Lord.
KDB.
KDB.
28-1 ಯಾವಾಗ?
28-1 no, 19/8, Lord, 2006. Final notification, Lord, 30, Lord, 8/1/2010. Award is passed on, Lord, kindly see on 18/8/22 award notice. 16 years, Lord.
You are still in possession?
Yes, Lord, I am running industry, Lord.
Rubber.
Rubber industry.
Rubber.
Rubber, Lord.
Lord, senior is not available. Kindly.
Latest
post
form
it
will
on
granted, Lord, as on today, whatever it is.
any date after 2 weeks.
Huh?
After 2 weeks.
After 2 weeks. Yes, sir.
They have also filed their objection.
Heard the learned senior counsel, MS Bhagwat, appearing for the petitioner. The learned senior counsel submits that the petitioner is running a rubber industry in the subject land. The subject land becomes a subject matter of acquisition at the hands of the KIADB by issuance of a preliminary notification under 28-1 in the year 2006.
19/8/2006.
On 19/8/2006. And it transpires, the final notification is issued after 4 years in the year 2010. The award is said to be passed now in the year 2022, and the respondent is wanting to take possession of the property after passage of the award. The learned senior counsel submits that the industry is still the industry is still running, and the petitioner is in possession of the property. If that be so, status quo, the property be maintained till the next date of hearing. List the matter on 3rd July.
Application may be allowed, Lord.
Have application.
To pass the award.
Amendment.
Amendment is fine.
To amendment, objection.
Senior.
Amendment then. For
Amendment.
the reasons indicated in the affidavit accompanying the application being satisfied with the same. The application seeking amendment of the prior to raise a challenge to the award that is passed during the subsistence of the subject petition stands allowed. Yes. Petitioner to file amended prayer matrana grounds idiyala. Amended
also
petition in the
Double
next,
hand prayer, both.
in the next 10 days after serving an advance copy upon the counsel for the respondent objections, if any, by the next date.
Page. Page 54, please, my lord. I filed my objections to the KIDV stating that the compensation to be not to be released in respect of the private respondents is concerned. Why? Because I am having a claim over the subject land. Now, please, my lord, the
Claim and
land
parti-
acquisition officer, page 17, annex A.
Partition suit idya.
Partition suit is there. There is an interim order also. Kindly, my lord, for a moment, page
Injunction.
17.
What interim order?
Interim order of not to alienate is there.
Yes, Purti. Learned AGA is directed to accept notice for the respondent.
Two, my lord, or not?
Respondents, 1 and 2 ಎರಡು ನೀವೇನಾ? SLAO KDB ಇದು. ಯಾರು KDB ಇಲ್ವಾ? ಬೆಳಗ್ಗೆ ಮಾತ್ರ ಇರ್ತಾರೆ. ಕುಮಾರ್ ಇದೀರಾ? Counsel N. Kumar accepts notice for the second respondent AGA. First AGA ತಾನೇ? GA. HCGP. HCGP for the first respondent. The
3 and 4.
3 and 4 emergent notice returnable by the 4th of July. Till the next date of hearing, the respondents shall not release the amount of compensation to any of the claimants.
Also sought for to mark lien in respect of the
Respect of what? Compensation pay ಆಗಿದೆಯಾ ಈಗ?
one property it is already been released.
ಎಷ್ಟು?
Sumaru 4 crore 88 lakhs.
Which bank is that?
Kotak Bank.
Page
Or
number 15, ma'am.
Party ಇದಾರ ಇಲ್ಲಿ?
Party illa,
Mata?
furnish the bank account details. With the leave of the court, I'll make them as a party.
Party ಮಾಡಿ first.
Please,
Let them sir copy me.
Copy serve ಮಾಡಿಲ್ಲ. Yes.
Lord, this.
Amend ಮಾಡಿ.
Please.
The fifth respondent, Kotak Bank, shall not, they shall mark a lien on the amount that is deposited from the hands of respondents 3 and 4.
Errad account is.
In the accounts mentioned, ಅದು ಕೊಡಿ ಯಾವ್ದು account, page ಯಾವ page ಅಲ್ಲಿ ಇದೆ?
Page 15 of the interim prayer.
ನೋಡ್ಕೊಂತೀರಾ? Interim prayer. Yes, next.
Please. Hand delivery ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡ್ಬೋದು ಯಾವಾಗ್ಲಾದ್ರೂ ಅವ್ರು. That is.
Bank time ಆಗೋಯ್ತು.
ಅಲ್ಲ.
Too early for tomorrow's clearance.
I understand, please.
Too late for today's clearance. So ಏನಿಲ್ಲ. ನಾಳೆ. Yes. Sorry madam, list ಅಲ್ಲಿ ನೋಡಿ. Settlement.
Settle ಆಗಿದೆ ಸ್ವಾಮಿ. There is a mediation agreement that has been reached at the BMC in family court.
Respondents ಅಲ್ಲಿ. Wife ಅಲ್ಲಿ.
Petitioner is present, Swami. The respondents have not been cooperating.
Not cooperating?
The petitioner is present, Swami. In the agreement they have.
ಸರಿ ಹೇಳ್ತೀರಾ petitioner present ಅಂತ.
Agreement.
Where is the complainant?
Complainant has not come.
ಎಲ್ಲಿದೆ settlement?
Settlement agreement, Swami.
Mediation ಆಗಿದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ. Paragraph 11 of the memorandum. Ink page 9. Ink page 11.
Yes, Jagdish sir. Let the wife come, will state.
Please, my lord.
The petitioner, learned counsel for the petitioner submits that the parties to the list, i.e. the husband and the wife, have settled the dispute in mediation in MC 5530 of 2024. Clause 11 of the conditions so drawn in mediation recognizes closure of the present proceedings. The emergent notice to the respondent complainant returnable by the 4th of July till such time further proceedings in CC in
3221.
CC 24
3221.
3221 of 2024 shall remain stayed.
Oblige, my lord.
Next time ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ we'll close it.
Please, my lord.
ಇರ್ಲಿ ಬಿಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ ನೋಡ. Next time close the memo.
Filing withdrawal memo, Your Honor.
Withdraw.
With liberty to file writ
Converted case ಎಲ್ಲಿದೆ? ಬಂದಿಲ್ವಾ? Sir, yes. In terms of the memo.
Much obliged.
Please, my lord, by virtue of annexure A, my lord, one notice came to be issued. Saying that we have fixed an amount for acquisition of such and such property in the year 2023. Adadmele enu illa. There is no communication, there is no notification, nothing. Now, on a daily basis, they come and try to demolish my building. Every day they come.
Daily JCB.
Daily JCB. On a daily basis, man.
Daily
Every day they
JCB.
come. We are somehow, my lord.
ಇಲ್ಲಿ ಫೋಟೋ JCB ನೇ ಇಲ್ಲ.
I'll produce, man.
JCB photo ಕೊಡಿ.
ಇದೆ. I'll produce this.
My lord, there might be an acquisition, my lord. Kindly have it on Monday, my lord, after.
No, let them not dispose this.
Don't take the JCB.
National Highway.
Anything bigger you may, but not JCB. Mangalore City Corporation.
Mangalore.
ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
Acquisition, we have not received compensation. They have not heard us.
Counsel for the petitioner submits that the subject land was subject matter of acquisition for formation of a road by the National Highway Authorities of India.
I'm still in possession.
The learned counsel submits the petitioner still in possession and is facing the threat of seeing the JCB every day. Therefore, the respondent shall not precipitate the matter till the next date of hearing. List on Thursday, next Thursday, 19th. Learned AGA to secure instructions or HCGP to.
And National Highway.
Is it National Highway or PWD na?
National Highway.
Then serve on Shobit Shetty. Learned counsel Shobit Shetty is directed to accept notice for the respondent, for second respondent, 1 HCGP, 19th.
Not to dispose this.
JCB ತರಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿದಿನ. Yes, the petitioner, if in possession on as on date, shall not be dispossessed till the next date of hearing. Yes, next.
Seeking to withdraw this petition.
Thank you, sir.
That's one indulgence.
Withdrawal indulgence.
Yes, the reason I'm withdrawing it also, that's the trial court is perceiving that status quo order means trial also should not continue. So I'm withdrawing my GMCPC injunction ಮುಗ್ದೋಗ್ತಾ ಇತ್ತು ಇಷ್ಟೊತ್ತಿಗೆ.
ನಿಮ್ನೇ ಯಾರು ಕೇಳಕ್ ಕೇಳಿದವರು?
That's my request is that that's the
ಒಂದು ವರ್ಷದಿಂದ ಸ್ಟೇ ತಗೊಂಡ್ರೆ ನೀವು ತಾನೆ.
We trying to convince the trial court to say that it's only with regard to the property, not with regard to the proceedings.
Counsel for the petitioner seeks leave of this court to withdraw the petition on the strength of a memo so handed over to the court. The memo reads as follows. In the light of the memo, the petition is disposed as withdrawn.
Great.
ಇದೇನ ಬಂದಿಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲ ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್ ಪಾಸ್ ಓವರ್. Yes, sir.
I only have few points to say, my lord.
ಎಲ್ಲಿ ಅದು ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪೈಲೇಷನ್ ಮಾಡಿದ್ರು?
That compilation, there are so many page numbers, my lord. I will refer page numbers of as of
ಪರವಾಗಿಲ್ಲ
charge sheet itself.
ಮಾಡಿ.
I made a convenience index as well.
Mayur, 5 o'clock I will take up to 5:30.
Grateful.
So that let us not make others wait. Go back to the list. 5 ಗಂಟೆಗೆ ತಗೊಂತೀವಿ. ಯಾವ್ದಿದೆ?
For the mood matter, my lord.
ಕೇವಿಯಟ್ ಇದೆ.
I have served caveat and I
ಅವ್ರಿಗೆ
have,
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ, ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ
I
complaint
have,
ಮಾಡ್ತಾ ಇದ್ರು.
I have served and I have also said that matter has been moved at 10:30, it will come after 2:30 anta. Yesterday night itself we have served.
ಅದಕ್ಕೆ he was complaining, so I have told it tomorrow.
Yesterday night I have served. Tomorrow is the hearing date before
So
the
what?
trial court.
So what? Tomorrow.
They have said they sought for police help. Already there is an order to issue.
We'll take it tomorrow. See, he had come at 2:30 saying without informing me they have done it.
No, that I will never do that. I'll never do that.
That's what he told. So I told I'll take it tomorrow. No.
Yesterday night we served it.
Let's
Some small
tomorrow
objections are
preliminary
there.
hearing.
I will-
Office objection, non-compliance ಏನು?
ಸ್ವಲ್ಪ objections ಇದೆ. ಈಗಲೇ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಕೊಡಿ.
Whatever
tomorrow.
to the maximum extent I will do it. And I have filed one downloaded copy of the order. Copy of the order.
Objections ಹಂಗೆ ಇರ್ಲಿ, ನೀವು maximum extent ಮಾಡಿ minimum damage ಆಗುತ್ತೆ.
Yes.
ಬೇಡ ಹಂಗೆ ಇರ್ಲಿ, ನಾಳೆ ಬರಲಿ. Yes.
Much.
$67.
Lord, I have sought for quashing of the acquisition proceedings as having lapsed with respect to
4 dates: preliminary, final, award, deposit.
Yes.
Dates ಕೊಡಿ ಸಾಕು.
Lord, the preliminary notification, Lord, is dated 28/11/1986. The final notification, Lord, is 26/1990. And the award, my lord, was passed for a smaller extent. 26 guntas, the two sets of two properties, my lord. Item number 1, I am submitting about item number 1. The award, my lord, was passed for only 6 guntas out of 26 guntas. That was sought to be acquired under the preliminary notification and final notification. And in the award, it has been clearly stated that we don't want the other 20 guntas. And 6 guntas, an award was passed, my lord, on.
You are the claimant in all 26 guntas or 20 guntas?
26 guntas belongs to me, out of which 6 guntas has been acquired, 20 guntas has been left out. In 1990.
ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆಯಾ?
20 guntas is with.
So now the litigation is with regard to 6 guntas.
No, my lord.
Then
that I have given up. That was
given up.
acquired, I have given up. The 20 guntas is the litigation. Subsequently, my lord, they pass another award. My lord, they pass another award on 15/6/2010. Based on the preliminary notification and final notification in
1990.
1984 is the preliminary notification, 1986 is the final notification. The award has been passed, they give up 20 guntas. Now for the remaining 20 guntas, this award has been passed.
Let him come.
My lord, this has been quashed.
We'll repeat it on Tuesday. List on Tuesday.
Wednesday, my lord.
No, Tuesday or Thursday?
Thursday.
Thursday.
Great.
Next Thursday ಹಾಕ್ಬಿಡಿ ಇಲ್ಲದೆ ಇರೋದು. Thursday ಬೇಡ, 26 ಅದು next Thursday ಹಾಕಿ. 26th, yes. Same, 26th. Same. Same.
Petitioner one.
73.
Yes, my lord, we are yet to file our rejoinder. I pray for 10 days of time, my lord.
2020 matter, madam. We'll take it
We
in
file our NOC wakalat in the last date of hearing, my lord.
All right. 26th, rejoinder if any by the next date.
One more submission. We filed wakalat for petitioner, but our name is reflected as advocate for respondent, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
The same matter, my lord.
ಉಮೇಶ್ ಮೂರ್ತಿ.
Girish Kumar R. We filed NOC wakalat on the last date of hearing.
Registry to print the name of Girish Kumar R as appearing for the petitioner and not the respondent. Yes.
Please.
Next. 26th. Yes.
74, my lord.
75.
75. The
there was a direction by this court to
Short
verify
form,
whether RTC can be changed.
Huh?
Well, the RTC has to be,
The name of the petitioner has to be restored. my
Corrected,
lords, in the
restored.
RTCs,
has
yes.
to be restored.
Yeah.
Information, it can be done.
Hmm.
Within 4 weeks, we will do.
We'll record it and close
Please,
it.
please.
The petitioner is before this court seeking the following prayer. The learned AGA on instructions would submit that if 4 weeks' time is granted, the grievance of the petitioner qua the prayer that is sought would be redressed. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the respondent state to redress the grievance of the prayer, redress the grievance of the petitioner by
My lord, serial
restoring
numbers.
the RTC as sought within respondents hyphen respond number 4 attack within an outer limit of 4 weeks from the date of receipt of the copy of the order, ordered accordingly.
Great.
Yes. Next.
It's National Highways Act, my lords. Proceedings in
Notice
sections-
ಆಗಿಲ್ವಾ?
Notice last date ಅಲ್ಲಿ ಆಗಿತ್ತು, my lords. One matter ಆಗಿತ್ತು, ಮಿಕ್ಕಿದ matters ಅಲ್ಲಿ.
Appeal is there.
My lords, ಇದರಲ್ಲಿ opportunity not given is what the ground rise. In fact, I have pressed-
Opportunity not given for what?
My lords, in fact, I have pressed the order sheet, my lord, kindly in page 31, my lords.
Lordship direct me to accept note. I have not been served with any copy.
Copy ಕೊಡಿ sir.
One
First
petition
matter
copy
only
ಕೊಟ್ಟಿದೆ, my
direction.
lords. ಇನ್ನ ಮಿಕ್ಕಿದ matters.
ಎಲ್ಲ ಪೇಪರ್ ಕಾಪೀಸ್ ಕೊಡಿ ಎಲ್ಲ
ಅಲ್ಲೂ
ಪೇಪರ್.
ಬಂದಿಲ್ಲ ಯಾವ್ದಲ್ಲೂ.
The
Copy have not received in any matter.
learned counsel Shobit
Those
Shetty,
materials.
the first ಮಾಡಿ, you will take notice in all?
Yes.
Learned counsel Shobit Shetty accepts notice for the National Highway Authorities of India in all these cases. Petitioner to serve complete set of papers, complete and requisite set of papers upon counsel says Shobit Shetty. Next week Tola,
17th. Similar matter has been placed.
which 70?
17th may be taken.
17th?
17th of this month.
17th.
In
Yes,
preliminary-
ಆಗ್ಬೋದಾ?
This matter is appealable order.
ಅದೇ ಅದನ್ನ ಅವತ್ತು ಹೇಳಿ 17th, yes, list on 17th.
Preliminary hearing, my lords.
Preliminary.
Let him serve copy to us, my lord.
ಇವಾಗ್ಲೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಎಲ್ಲ matter yes,
ಬಂತಾ? ಸರಿ. yes.
74 interim order extended.
Exactly. Interim ಮಾಡಿದ್ರೆ extend ಆಗುತ್ತೆ, don't worry about it.
74.
ಆಯ್ತು, ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು extend ಆಗೇ ಆಗುತ್ತೆ. Yes.
77 dispose, 78 adjourned. Final disposal,
Final hearing, madam.
final hearing
78 adjourned ಅಲ್ವಾ?
78.
79.
Final hearing 79.
Wait, take the, why is the advocate general? I saw the learned advocate.
Not meeting.
It's gone to court on 13.
Huh?
It's gone to court on 13, will come back.
ಬರ್ಲಿ. Yes. Sir.
79.
Yes. A long time you've seen, sir.
Yes, my lord.
79. Yes, sir.
No, what is sought to be challenged, judgment and decree,
Small causes,
is an eviction case.
eviction. That's what.
Just to briefly, I'll mention, I mean, facts.
Entry order ಇದೆಯಾ? ಇಲ್ಲ.
ಇದೆ.
ಇದೆಯಾ?
ಇಲ್ಲ ಅಲ್ಲ, ಏನಾಯ್ತು, ಇಂಟ್ರಿ ಮಾಡೋ ಹೋದ್ಮೇಲೆ ಕೂಡ they have taken possession from me. That's a long story. Started in 1984.
ನಿಮ್ಮನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಐತಾಳ್ರಿ ಇಲ್ವಾ?
ಆಯ್ತಲ್ರಿ, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ ಸದ್ದಿಸಿಂದ ಅವರು. But it's not been coming it. for quite
Then
some
what
time.
to do? I have no problem in hearing.
ಹಾ.
Then it should not be a problem. One chance ಕೊಡೋಣ.
Chance ಕೊಡ್ಬೇಕು.
Well, I'll take it next Thursday.
Please.
If he does not come, then we'll pass out.
Please. Next Thursday.
The last time ಅದೇ ಹೇಳಿದೀನಿ ಅನ್ಸುತ್ತೆ ಇಲ್ಲ.
At last time, you last year wanted time. I'm sorry. I remember an incident which happened 25, 30 years ago. Before me, Mr. Justice NDV Bhatt, my lord, very conscientious judge, and he was elevated from district judge
Yes,
to
yes.
High Court. Your lordship may be aware of it. Matter was there listed, and civil matter. He was quite good in civil matters. Two senior advocates, they were not designated at that time, Visheshwara and Mr. Tarak Ram. They were appearing. So when the matter reached, they said, we are ready, we'll argue. The court said, no, I have not read the papers. Give me 1 week's time.
So exactly happened on the last time.
Next week it came. I mean, the fun then doesn't end there. Next week it came. He had not really read the papers fully. Then he said, sorry, I want to take one more week. No. We can't give time to your lordship like that. ಸ್ವಲ್ಪ ತಮಾಷೆ ಮಾಡಿ ಆಮೇಲೆ then of course adjourn.
ಸೊ ಅದಕ್ಕೆ ಅವರಿಲ್ಲ ಅಂತ ಟೈಮ್ ಕೊಡ್ತೀನಿ.
Please.
Heard the learned senior counsel SS Ramdas appearing for the petitioner. There is no representation on behalf of the respondent. On an earlier occasion also, there was no representation on behalf of the respondent. Therefore, as a last chance, let this matter next Thursday. In the event the counsel would not be present, the matter would be heard, hearing the learned senior counsel SS Ramdas, and appropriate orders would be passed. Make statement regarding compliance. Next week. Yenidu? Petitioner.
Matter pertains to JP Nagar 9th phase. Scheme is implementation is only
Yes,
4%.
Murugesh.
But in so far as implementation of the scheme is concerned, the scheme has been held to be lapsed.
Covered,
Covered.
Solved by
Actually, but Lordship may kindly taken, there was a direction for me to file an affidavit.
Yes.
I filed an affidavit of the land.
Either it's covered Tuesday preliminary hearing.
Please.
Yes. 81.
81.
Respondent in this case.
26th, yes.
82.
Same.
83.
83 is a Kempagoda layout matter, my lords.
Well, then it's covered.
Yes, my lords, it's covered matter.
ಅದು ಯಾವತ್ತು ಸೋಮವಾರ ಹಾಕಿದೀವಿ?
Monday, my lord.
ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ.
Monday.
Yes, Monday.
Much.
84. 84.
84 lapses. I appear for Respondent Union of India, my lords.
84.
26.
26. Obliged.
Yes.
85.
Lord, the parties have received the file, my lord, to engage the new council, and my offer retirement has been filed.
ಅದು ಬರ್ಲಿ 26th ಅಷ್ಟಲ್ಲಿ ನೋಡೋಣ.
Much.
86.
Same.
87.
Is covered.
Interim order ಎಲ್ಲಿದೆ? Covered ಆ?
Covered.
7.
ಯಾವುದು?
This honorable court
No,
is.
Lord, the Honorable Supreme Court has day before yesterday has passed an order
copy.
saying that there cannot be a relaxation of a time beyond what is said in the Rule 13.
This one.
I shall,
Place that on.
please,
Placed on Tuesday.
please.
Tuesday 17th.
Okay.
Yes.
8.
Respond.
TP Vivekanand. ಹತ್ತು ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. 26th. Ajay Kumar, what is this?
Lords, they are seeking for interest, my lords. They've had allotment.
26th.
Please.
Further hearing. 89.
Steel Hypermart.
Appearing for the petitioners, my lords. Our
Tell me.
villa, they had informed us that they required some time. If it may kindly. be-
Supreme Court has directed expeditious disposal.
How
madam.
this one,
And what?
they had informed us if it
It
may
will
be
repeat
taken up on
Monday.
19th.
It will repeat on Monday. Monday, Tuesday ಇಂದ. Tuesday to Friday it will repeat. Yes.
19th date fix ಆದ್ರೆ.
ನೀವು ಯಾವತ್ತಾಗತ್ ಮಾಡಿ. Yes.
90.
The drunken drive checking matter, my lords. It was
353.
353, 307. It was heard substantially, my lords.
307.
307.
ಎಲ್ಲಿ ಧನಂಜಯ್?
Dhananjay Atandra. Similar issue, my lord. The coordinate bench of the Honorable Court has passed because the Commissioner of Police has passed a circular, my lord. The
Dhananjay will not
incident has
applicable
to.
in this case.
353 ಅಲ್ವಾ ಇದು?
353 and 307. They know 307, my lord.
Drunken driving.
Drunken drive checking, my lord. Checking ಮಾಡ್ಬೇಕಾದ್ರೆ ಇವರು ಅವ್ರ ಮೇಲೆ ಕಾರ್ ಡ್ಯಾಶ್ ಮಾಡಿದ್ರು ಅಂತ. They invoke 307. And injuries.
ಪೊಲೀಸ್ ಮೇಲೆ ಕಾರು.
ಹೌದೌದು.
ಅವ್ರ ಕೇಸಸ್ ಒಮ್ಮೆ ಡ್ರಿಂಕ್ ಅಂಡ್ ಡ್ರೈವ್ ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಆಮೇಲೆ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ, ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ ಮಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ. ಆಮೇಲೆ ಇವರು ಕಂಪ್ಲೇನೆಂಟ್
ಏನ್ ಇಂಜುರಿ ಆಗಿದೆಯಾ?
ಹೌದು, ಕಾಲ್ ಮೇಲೆ.
ಬ್ರೂಸಸ್ ಮೇಲೆ ಬ್ರೂಸಸ್
ಅದು ಇಂಜುರಿನ. ಪೊಲೀಸ್ ಬ್ರೂಸಸ್ ಅಂದ್ರೆ
they invoke the 307 ಮೇಲೆ attempt to murder.
ಅದು ಗೊತ್ತು 307 ಏನು
ಅಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಸರ್. And there was a circular to that effect. It has to be videographed.
ಅಲ್ಲ ಆಗ್ಲಿ ಕಾರ್
drunken driving has to be videographed.
While checking the
provided you stop the vehicle. you go on rampage and go on the policeman.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಸುಮ್ಮನೆ ಇದ್ರಲ್ಲಿ ಅವ್ರು ಅಷ್ಟು ದೂರದಿಂದ ಬರ್ತಾ ಇದ್ರು, ನಾವು ಸೌಜನ್ಯದಿಂದ ನಿಲ್ಸಿ ಅಂತ ಕೇಳಿದ್ವಿ. ಅವ್ರ
ಏನಂತ ನಿಲ್ಸಿ
ಸೌಜನ್ಯದಿಂದ ನಾವು ನಿಲ್ಸಿ ಅಂತ ಕೇಳಿ. ಇಟ್ ಇಸ್ ದೇರ್
ಪೊಲೀಸ್ನವರು ಸೌಜನ್ಯದಿಂದ ಕೇಳ್ತಾರ?
ಇಟ್ ಇಸ್ ದೇರ್ ಇನ್ ದಿ ಕಂಪ್ಲೇಂಟ್ ಶೀಟ್.
ಯಾವಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಯಾವಾಗ್ಲೂ ಸೌಜನ್ಯನೇ.
And no public will.
ಅಲ್ಲ, ಸೌಜನ್ಯದಿಂದ ದೌರ್ಜನ್ಯ.
That word can be used.
Yes, yes.
ಅಲ್ಲ ಅವ್ರು ಕುಡಿದಿದಾಗ ನಾವು ಸೌಜನ್ಯದಿಂದನೇ ಹೇಳ್ಬೇಕಾಗತ್ತೆ.
ಹೆಂಗ್ ಹೇಳಿದ್ರು?
ಅಲ್ಲ ಕುಡ್ದಿರೋದಕ್ಕೆ ಏನಾದ್ರು ಬೇಕಲ್ಲ?
ಕುಡಿಯೋದಕ್ಕೆ ಏನ್ ಬೇಕು?
ಅಲ್ಲ ಕುಡ್ದಿರೋದಕ್ಕೆ
ಕುಡಿದಿರೋದಕ್ಕೆ ಏನ್ ಬೇಕು? ಪೊಲೀಸ್ನವ್ರು ಕೇಳಿದ್ರೆ ಏನು?
Some material in the charge.
Material you already consumed, sir. ಅದನ್ನೇ ಕೇಳಿದ್ದು. ಕುಡಿಯಕ್ ಮೆಟೀರಿಯಲ್ ಬೇಕು, ಅದು ಆಲ್ರೆಡಿ ಕನ್ಸ್ಯೂಮ್ಡ್. Yes.
Passing the judgment of coordinated bench of this.
Oh, ಕೊಡಿ sir. 353 ಇದು. 307 ಅಲ್ವಲ್ಲ?
ರಿವಿಷನ್ ಅಲ್ಲಿ ಆಫ್ಟರ್
ಸರ್ಕ್ಯುಲರ್
ರಿವಿಷನ್.
ರಿವಿಷನ್ ಅಲ್ಲ ಇದು.
ವೈಲ್ ಡಿಸ್ಚಾರ್ಜಿಂಗ್ ಸಿಮಿಲರ್
307 ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ 326 ಆದ್ರೆ ಬರುತ್ತೆ ಅಲ್ಲಿ ಬೇಕಿದ್ರೆ ನೋಡೋಣ.
ಏನು
307 ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
324 ಎಲ್ಲಿ 4 ಇಲ್ವಲ್ಲ? ವೆಪನ್ ಇಲ್ಲ ಇಲ್ಲಿ.
ಕಾಲ್ಗೆ ಹೊಡೆದಿದ್ದಾರೆ ವೆಪನ್ ಟೈರ್.
ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲಿದೆ?
ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್
ಹಾಕಿಲ್ಲ, ಏನು ಹಾಕಿಲ್ಲ ಅವರು.
Page 53. There are two wound certificates.
ಮತ್ತೆ ಯಾವ ಕರೀದಿರಾ? Tuesday 3:30. Yes, we will repeat.
Yes,
yes. Next.
91.
Before the petitioners, my lords, the pertain to secondary evidence, my lords.
ಅವ್ರು ಅವತ್ತಿನ ಬರಲೇ ಇಲ್ಲ.
They came twice, my lord. Thereafter lordship passed an order to post the matter in the stage of admission, but again it's coming in the further hearing, my lords. If a lordship sees the order.
No, at further hearing ಆಗ್ಬೇಕು, because it was reserved, recalled and all
Twice
that.
they came and thereafter matter didn't reach.
ಆಯ್ತು, ಮಂಡೇ ಇರ್ಲಿ, ಹಂಗೆ ಇರ್ಲಿ. ಡಿಸ್ಪೋಸ್ ಆಗೋವರೆಗೂ ಇಲ್ಲೇ ಇರುತ್ತೆ, ನೀವು ಮೂವ್ ಮಾಡಬೇಡಿ. ಇಟ್ ವಿಲ್ ಬಿ ಇನ್ ದಿಸ್ ಸ್ಟೇಜ್. ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಒಂದಿನ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀವಿ. Tuesday to Friday.
92.
Yes, Mohammed Azharuddin.
Let their absence may be recorded, my lords, because from continuously they have
The
not been coming.
respondents counsel, idರಲ್ಲಿ 91 ಅಲ್ಲಿ madam, respondents counsel has been continuously absent. In the event he would not be present on the next date, the matter would be heard. The counsel for the petition would be heard and orders would be passed. Tuesday. Yes, Mohammed Azharuddin.
Interim order fixed.
Interim order.
Please, oblige.
ಅಲ್ಲಿ ಈಗಲಾದ್ರೂ ನನ್ನ ಪರವಾಗಿ ಮಾತಾಡಿ ಅಂತ.
ಜಗಳನೇ ಮಾಡ್ತಾರೆ.
Halima madam ಹಂಗೆ straight away she will tell you. Yes. Yes madam. Fourth husband.
Not to be found now.
Fourth husband is escaped. Yes.
There is an interim order, 6,000 ಕೊಡ್ಲಿಕ್ಕೆ ಇರೋದಕ್ಕೆ ಇದೆಲ್ಲ ಆಟ.
ಅಲ್ಲ, fourth husband 6,000 escape ಆಗಕ್ಕೆ ಇದ್ ಮಾಡ್ತಾ ಇರೋದ?
Arrears ಇದೆ.
ಎಷ್ಟಿದೆ?
I have no information.
This court on 9/6/2025 had passed the following order. The order was passed in the wake of counsel for the petitioner remaining continuously absent. Even today, there is no representation. Therefore, the interim order subsisting stands vacated. ನೀವು ಅದೇ ತಾನೇ ಹೇಳಿದ್ದು, interim order vacate ಮಾಡಿ.
I have prayed for dismissing with cost. Morphed photos, ಆಮೇಲೆ duplicate documents ಎಲ್ಲ ಹಾಕಿದ್ದೇನೆ. We'll be confronting him in trial court if it is sent back. 498A.
No, his allegation was that this has been repeating with every husband.
Yes. But the FIR he has put is 498A, 323, 504, 506.
I think interim order ಬರ್ತಾರೆ ಬಿಡಿ next day. He will now appear on the next date.
Doubtful ಆಗಿ.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೋಯ್ತು ಅಷ್ಟೇ. ಟ್ರಯಲ್ ನಡೀಲಿ. Yes.
93.
Latif, ನೀವಿದ್ದೀರಾ? Abraham is a complainant.
Please.
Yes.
Now, Lord, the investigation is completed and PSO is ready to file permission.
Charge sheet is ready to be filed. We'll hear it anyway.
The challenge FIR.
Abraham, ಇವತ್ತಾಗ್ಲಿಕ್ಕಿಲ್ಲ, 4 ಮುಕ್ಕಲ್ಲ. Tuesday.
Obliged.
I'll repeat it on Tuesday.
Please.
Tuesday 2:30 ಅಂತಾನೆ ತಗೊಂಡು.
Top of the list.
ಅದೇ 2:30. I'll take it at 2:30 on Tuesday. ಯಾವುದು ಹಾಕಿದೀವಲ್ಲ ಮೇಡಮ್? Okay, there are 2 other matters. I will finish that and take it. 230 ಅಂತಾನೆ ತೋರಿಸಿ. Yes. Because party in person has to come up. Yes.
Entry matter next.
Okay, continues.
94.
My lord, offences under 354D, 354C, 376 came to be dropped in the charge sheet, my lord, and 420. Subsequently, they got married. Subsequent to the FIR, my lord, subsequent to the complainant, they got married. There was certificate of registration of marriage. Subsequently, she files a complaint again indicating that it was obtained by fraud. Thereafter, this charge sheet comes to be filed, wherein they indicate that avale prachodisiruttale accused na ant heli, and 376 is dropped.
Respondent number 2.
Mike.
For respondent number 2.
ಇಲ್ಲ ಗಲೆ ಮೇಲೆ ಕಿಚ್ ಸರಿ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ.
ಕಂಡೀಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಅವರೇ ವಿಕ್ಟಿಮೇ ಪ್ರಚೋದಿಸಿರ್ತಾರೆ ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಐವ ಮುಂದೆ. ಅವ್ರು ಸರಿಯಾಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ಆಡಿಯೋ ಮತ್ತು ವಿಡಿಯೋ ಇದೆ, ವಾಟ್ಸ್ಆಪ್ ಆಡಿಯೋ ವಿಡಿಯೋ. ಬಟ್ ಅವ್ರು ವಿಡಿಯೋ ಮಾತ್ರ ನೋಡಿದ್ದಾರೆ, ಆಡಿಯೋ ಇದೆ, ಅದನ್ನ ಕೇಳಿಲ್ಲ. ಅಂದ್ರೆ
ಮ್ಯೂಟ್ ನೋಡಿದಾರಾ?
ಹೌದು. ಅದ್ರ ಬಗ್ಗೆ ಆ ವಿಚಾರವಾಗಿ ಅವರು ವಿಡಿಯೋನ ನೋಡ್ಬಿಟ್ಟು ಇವರೇ ಪ್ರಚೋದಿಸಿದ್ದಾರೆ ಅಂತ ಐವೋ ಬರ್ದಿದೆ.
ಆಡಿಯೋ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ತಾ ಇತ್ತು ಯಾರು ಪ್ರಚೋದಿಸಿದ್ದಾರೆ.
The petitioner recorded the private videos and photos of the victim and he threatened her and raped her.
My lord, seizure also has happened from her. She herself has gone and surrendered the devices 1 year after the complaint is filed, my lord. It was she herself. Seizure has happened of all electronic devices from her itself.
Oh, this matter where Atrocities Act is also.
Please, my lord, please.
Yes.
164 ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸರ್?
164 162 to 166 of our charge sheet filed by the R2.
162 to 166.
Para 3, para 6.
At page 175 of the petition, I've produced it, my lord.
Para 2, para 3, and para 4.
What happened to the UPSC?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲೇ ರಿಟರ್ನ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲೇ ಸ್ಟಡಿ
ಆದ್ಮೇಲೆ ಹೋಯ್ತು ಅದು.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಈಗಲೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
At page 178 is relevant, my lord. Para 9. After some days on 7 November 2023, one of the relatives of accused number 1 by name Ajay Tiwari had contacted me and asked for settlement. Then I told him that I want all the hard disk of my private and photos and videos, or else to marry me by court marriage as my life is spoiled. She asks for marriage, my lord. Subsequently, 9th November, she further at para 10 indicates, my lord, in the 164 statement that at the third line, then the relatives of Abhishek Mishra by name so-and-so came and picked me along with my mother and Abhishek, and on 9th November took me to marriage office, and at the place Abhishek Mishra and his father were there. They collected my documents so-and-so. They asked me to sign. Further, at the last but third line, she indicates, then I gave my thumb impression. Then we came to the house of so-and-so, and he told that court marriage is over, and they gave me marriage certificate.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ರಿಕ್ವಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಐವೋ 173(8) ಕೆಳಗಡೆ ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. There is a material evidence against the
64 statement is horrendous.
Please, my lord.
You have really tortured the lady.
My lord, no. In fact, she herself has indicated, if I may be heard, my lord, because there's substantial material in the matter.
We'll take it on.
Which indicates her conduct.
Wednesday.
Please, my lord.
But prima facie 164 statement indicates.
I'll demonstrate the 164 statement itself.
It's not that she has given the devices. You have threatened that the photographs and videos that he has will be made public.
My lord, I'll establish the timelines, my lord.
We'll see.
She herself has produced it.
Yes.
Wednesday
intermod will continue till then.
Great.
Wednesday you be here.
95.
Flop music, sorry, hits music.
Some 18th ಬೇಡ
For petitioners, please.
my lord 18th ಬೇಡ.
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ, ನೀವು 19th ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. Yes.
For petitioners, please,
A new petitioner, hits nimdu. Why did it flop?
Without having any hits, my lord, they want to be hits music. All material belongs to me.
Please note.
Copyright violation,
Copyright, clear case of copyright violation.
Milords,
63 is the allegation.
Yes, yes.
please milords. Now please
Besides, my
milords.
lord, it is something.
ಅವ್ರು ಹೇಳಿ ಅವ್ರ ಕೇಸು
ಅಲ್ಲಲ್ಲ, ಒಂದೇ ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬೇಕು.
ಅವೇನು ಹಿಟ್ಸ್ ಅಂತ ನೀವು ಇದಕ್ಕೆ ಫ್ಲಾಪ್ ಆಗಿರೋದು.
Cinema is life a little more easy.
Milords, I will, it's a very simple matter, please milords.
Yes, sir.
Which they have turned a civil matter into a criminal matter, please milords. The offences alleged, please milords, is 420, 406 and 63 of the Copyright Act, please milords. Now the allegation, please milords, is specific allegations what could constitute a crime, please milords, is at
Take some time.
Yes, sir. You have a flight to catch.
No.
Milords, is
there
that
is no, my lord, thinking of plane, my lord, is.
milords, I may be allowed, please milords.
Allah, ivattu there has been a very major air crash today. All on board have died.
Air India flight
Yes.
to London, 242 passengers. ಅದೇ ತಾನೆ?
ಅದೇ.
Please milords, the specific
Ahmedabad airport.
the specific allegations, please milords, is at page number 63, paragraph number 9 and 10, please milords. What they say, please milords, they were entitled to certain amount, please milords. The amount was not paid, and they so moto terminated the agreement. Despite termination of the agreement, please milords, we continue to, that is hits music, continue to use their copyrighted material. Hence, it's a violation of
What music is this?
music. Everything, please milords, is the catalog of music. And various rights can be exploited. Please milords, everything is detailed, please milords.
ಅಲ್ಲ ಇದೇನು ಮೂವಿ ಆಲ್ಬಮ್ ವಾಟ್ ಇಸ್ ದಿಸ್?
No, everything, all
He has a
kinds of
company,
music.
my lord, has
Database.
a lot of- ಹೌದು, data.
You have a database of
Yes,
music.
yes.
Please milords.
And what is the contract between him and you?
Please milords, the contract is, please milords, they will give the entire catalog. The contract starts, please milords, at page number 45. Annexure
MRT
6.
music.
MRT music.
Lahari.
Yes. It starts at page number 45, please milords. In this, please milords, they are supposed.
I would say, my lord, I could, my lord, just perceive, my lord, the smirk on your lordship's face. There is a saying, my lord, the ship owner runs more out of demurrage than from the fright.
Milords, the contract, please milords.
Yes.
The contract, please milords, is at page number 45, please milords. And under that, please milords, what they license to me is MRT catalog, please milords, which is a whole host of songs. And I can exploit, what exploitation can be done is under clause 6 at page number 75 of the contract, please milords. Now, please milords, what happens is one of the conditions, please milords, is if I do not pay the money in time, then they can terminate the contract, milords. And according to them, we do not pay the money, and this particular contract has been terminated. Now, please milords, what is important, please milords, this particular termination, please milords, is challenged in the Bombay High Court, please milords.
All right. Challenged in the Bombay High Court by you.
By me. They also have filed a suit, please milords, asking for damages
Against MRT.
Yes. Now, please milords, further.
MRT registers a crime for copyright violation.
Yes. Now, please milords.
Actually, your argument is civil case is converted to a crime.
No. There is more to it, please milords.
More?
There is more to it. Page number 78, please.
There is more to it. It's a matter of trial.
No, milords. Page number 78, I may just invite your lordship's attention,
Yes, sir,
please
yes.
milords. Page number 78, in this, when the particular agreement can be terminated, that is there, please milords. It says, however, hits music shall be made liable in such deviance in due to MRT's breach under this agreement. If MRT has not given their entire catalog, then there is a breach on their side and they cannot terminate. Now, please milords, there are certain emails, please milords, which is there at annexure H, please milords, page number 85 onwards.
Now, the issue is this.
Please milords.
The allegation is after the termination of the agreement.
Please milords.
Of usage of their database by you.
Please
You have gone on using it.
Please
Therefore, there is copyright violation.
Please milords.
Section 63 is alleged for that.
Please
420 will see whether it gets
Yes,
attracted or not.
I'm not on
420
that.
will not get attracted because it arises out of an agreement.
Yes.
63, yes, it may have some semblance once I hear him, prima facie. 63, because after the agreement, if you have used it, that is the allegation. And if you used it, it definitely amounts to violation of copyright.
Yes, please, my lords.
Correct?
Yes, please, my lords.
Yes.
But what I'm trying to place it before your lordships is the entire termination itself, please, my lords, is challenged in the High Court
Correct.
in Mumbai, and it's still pending.
No. Has the court at Mumbai granted you an interim protection
No,
of
please,
usage?
lords. No.
So when did this happen? When did the termination come to an end? Sorry, lease come to an end or termination happen?
Please, my lords.
Date.
Date, please.
Ashte, 2 dates. Date of lease, date of termination, date of the institution of the suit before.
10/5/2023, please, my lords.
That is termination.
Termination.
All right. When did you institute the suit?
Lord, suit is filed, please, my lords.
You should be fast. Dates.
Please, my lords.
Yes.
It's not a suit, rather, I think they went in for my lord an arbitration.
Injunction, please, my lords.
Arbitration ಆಗಿದೆಯಾ?
ಅಲ್ಲಿ ಹೋದ್ರು CMP ಹಾಕಿದ್ರು ಅಷ್ಟೇ.
ಆಯ್ತು. ಆಮೇಲೆ?
It is filed by us.
No, commercial suit, please, my lords. Commercial suit has been filed, please, my lords. In Mumbai High Court, please, my lords. Again in 2023.
Nowhere you have protective orders?
No.
How
please.
did you continue to use the database? That's a matter of trial for section 63.
My lords.
I'm on it. That's all, my lord. I have no further submissions.
ಆಗೋಯ್ತಾ?
This is all, my lord. Lord, why should I trouble the honorable court, my lord? The honorable court has already comprehended my argument.
Yes.
Lord, suit was filed, please, my lords, in November 2023, please.
ಅಲ್ಲ ಅದಾಯ್ತು. The only issue is you have gone on using 420 we will quash. 420 ಬರೋದೇ ಇಲ್ಲ ಇದಕ್ಕೆ. But 63 prima facie, yes.
My lords, may I seek instructions from my client, please, my lords, on short date may be given.
To withdraw the petition?
No, not to withdraw the petition, please, my lords. I will come back with certain instructions, please, my lords. Short date may be given.
Instructions you take. Why do you want to come back with that?
No, I'll take some material instructions, please, my lords.
ಅದೇ material ತಗೊಂಡು
Not
ಇಲ್ಲೇ
material
ಬರ್ತೀರಾ?
instructions, please, my lords. Factual instructions.
That
please,
is
my
out
lords.
of the bag.
No, please, my lords.
It is
Factual
a
instructions,
call-
please,
It is
my
a
lords.
call, it is a call Chinmay has to take as a lawyer.
No, beg your pardon, please, my lords. Factual instructions, please, my lords. Since it was
The
a
lighter
NOC
way,
matter,
sir.
please.
5 o'clock ಆಗಿದೆ ಅದಕ್ಕೆ.
Lords.
In the lighter way, it's 5 o'clock.
Yes, please, my
We'll
lords.
break the monotony ಅಷ್ಟೇ.
Yes.
Yes.
Kindly next week, any date, please.
19th.
Grateful.
ಅಷ್ಟೇ, that's the order. 420 I will quash, 63 will sustain. Let the trial go on. Jagdish sir, ನಿಮ್ದೇನ್ ಇದೆಯಾ? That's all.
ಅಷ್ಟೇ. That's all.
Because whether you have used it after the termination or not is a matter of.
I will get back.
Matter
to
of
you, please.
evidence.
Because it's a NOC matter, please, my lords. I
No
need
problem.
some-
You take your time, but prima facie that.
Please,
Investigation is told. Tomorrow, my lord, in the investigation, they might as well say, no, he had some rights, my lord. Then it's at the stage.
ಅಷ್ಟೇ 420 ಅಲ್ಲಿ ಹಾಕ್ಬೇಡಿ.
420 ಎಲ್ಲ ಬೇಡ. Police ದವ್ರು, my lord, they, lord, their best knowledge, my lord, go on adding.
Their best knowledge is only under 420. Yes.
Please,
So great.
96.
Appear for the second respondent.
96.
Interim order, please.
That will continue, sir. Don't worry about interim orders. Yes, reverse POXO.
Find objection, not served copy. What is their stand? We want to know that.
Yes, sir.
Pardon my lords. I believe a copy has been served by email. I'll take steps to serve.
No,
physical
not
copies.
served, not served. Office have put a note in the cause list.
Entire records are here.
Please, my lords. I'm in any position. I'm ready to argue, my lords.
Hmm.
But copy, I believe it's been served by email. In any
Now,
event, I'll
the
take
first
steps
time
to
I'm
serve.
coming across a case
Please, my lords.
where the accused is a lady
I must point out, my lords,
in POXO.
a 2007 report of the government of India.
No, I'm not saying they should not be.
Please, my lords.
I'm not on that at all. There cannot be reverse POXO. I'm not saying that at all.
Also to
If a man has troubled a child, a woman also can trouble a child. I'm not that.
And in
I'm
fact,
not on that. We'll consider whether that is there or not in
Please,
this.
my lords. In fact, if I can just make that one submission, that report of 2007 says 54.6% of boys and 45.6% of girls reported being sexually abused. So in India,
57% of boys are
54.6% of
boys are sexually abused than girls.
So there is more prevalence of sexual abuse of boys than girls is the official government statistic.
Let's see, we'll see.
But a fact,
Anyway,
my
whether
lord,
that would fit in here, we'll
fact,
see.
It's a
yes.
different issue, my lord.
Because
Fact, my lord,
idralli, I think it is registered after 4 years.
After 4.5 years, my lord.
Four
lord,
and,
February-
incident happens in Dubai, if I remember the
In
facts.
Bangalore, my lord.
Here is
Bangalore, na?
in Bangalore, my lord, February 2020, my lord. The complaint is filed, my lord, in June 25.
No, that you have sexually abused the boy who was less than 18 years.
13
That's
years
the
of age.
allegation.
Yes, that's the allegation, my lord, that, but complaint is not even informed. After this event, my lord, after this incident, this boy was continued to visit the house of the accused.
What was the
That
relationship?
is the message put.
Neighbors, my lord.
Neighbors.
Same apartment
Neighbor, both
complex.
are neighbors, my lord.
How old
They
is
were
the accused?
accused, my lord, 52 years. my lord.
52 years.
52
And the
years.
boy?
13 years at the time of the incident, my lord.
14 years, my lord, 14 years it
If
is.
I may also make one submission, my lords, the issue of delay in child sexual
No,
abuse
don't worry
cases,
about
I have citations which I'll explain.
Don't worry about
No,
that.
it is,
Hmm.
my lord, the reason, my lord, why this complaint is lodged is because of some monetary issue, my lord, in
Between the
them.
families.
In between the family, this was there. My lord, when they left Bangalore, my lord, in the year 2020, my lord, both were having happy relationship. My lord, this lady had wished them, they went to Dubai. They were exchanging, my lord, talks, my
Dubai,
lord,
I
texting
remember that
messages.
Dubai.
My lord, there was no allegation of anything. My lord, after 4 years, when they returned, my lord,
Back to Bangalore.
back to Kerala,
Kerala. Hmm.
there, my lord, after legal consultation, they prepared a complaint and presented. No, my lord, this allegation, my lord, that is not supported by any circumstantial evidence. My lord, law is now settled, my lord, even in a case of POCSO, my lord, the evidence of a victim must be of a sterling quality.
Correct.
My lord, what is this conduct, my lord, remaining silent is not a 13 years, my lord, that as per the photograph, he looks, my lord, more than 18 years. He is a grown-up boy. He was having relationship with other girls also.
Huh?
Yes.
No,
This is, my
my
lord,
lords,
that
tarnishing the
photographs are
character
all
of a
there.
14-year-old
Photographs, my lord,
is patently
investigation.
unfair.
Don't get touchy.
Investigation
Don't worry.
officer has collected photographs, my lord. All those photographs are produced by this accused to
Photographs
show
of this boy.
this boy with other girls.
Boy, sir.
Because, my lord, they all, my lord, they used to visit the house of this accused. My lord, she is an artist. My lord, to learn, my lord.
This
Yes,
petitioner
my lord,
is an
she was a
artist.
teacher. She was a teacher, my lord.
Artist
She
or
used to-
teacher?
Artist
my lords,
teacher, my lord, that she used to teach.
Art teacher.
Art teacher. My lord, all the children, my lord, that community, they used to visit.
Hmm.
My lord, there used to be event, my lord, every occasion.
Hmm.
My lord, in spite of it, my lord, they were having close relationship. Even the mother of this victim, my lord, was very close. Sister also, my lord, my name Bhadra. That girl also used to visit the house. And well, they were exchanging, my lord, eatables so close, my lord, that no allegation at all. My lord,
4 years the allegation comes.
after 4 years, my lord, they invent this allegation. To substantiate this, my lord, accept their complaint, my lord.
At
Now,
the,
they
at the
degree,
time
my
of
lord,
the, on the date of the, or time of the incident, the boy was 14 years, is it?
14 years, my lord.
At the time of the complaint, beyond 18.
Yes.
He was 18.
Now the
17, my
question,
lords.
17.
17.
the
If I
question,
make
my lord, that here,
Don't
the
worry.
allegation, my lord, that under the POCSO Act, my lord, there are various kind of offences, my lord, sexual assault, aggravated sexual assault.
Now, Idralli, what is
My
the
lord, which degree, my lord, what it had happened.
No,
they
what is
discussed.
what are the provisions invoked?
No, my lord, 4 and
Section
6
4
is
and 6.
involved.
4 and 6 is penetration.
Penetrate, my lord,
Please,
that
my
is what it is.
Aggravated sexual assault and sexual assault,
Please,
4
my
and
lords.
6.
Please, my lords.
This, my lord,
The allegation is boy was used for that.
Yes, my lords.
my lord, the allegation is in month of May and June
Of 2020.
of 2020. Lord, after that also, this boy used to visit the house of petitioner and they were having happy relationship. There is no such instances. Now, the date is not given, my lord, when particular date had happened. And only, my lord, in the month of May and June they assert. My lord, except oral allegation, my lord, that this is not substantiated with anything, my lord. Now the girl, this boy, my lord, is subjected for medical.
Girl ಅಂತಾನೆ ಬರುತ್ತೆ, folks.
Yes. Normally, my lord, that this boy is subjected for medical examination, no evidence, nothing, my lord, that. No, even in this manner, my lord, what is now available, if it is taken as
No,
evidence.
section 26, 1 and 4 is not complied. Medical examination, 27 medical examination is not done.
Medical examination is done, my lords.
No evidence, your lordship,
but after
that it's
4
all
years,
negative. Everything
I'll
is
get back
negative.
to you. Wait, yes,
My
madam.
lord, everything is negative. My submission, my lord, read it as it is, the complaint lodged as an evidence. What would
Even
be?
then, it would not make out an offence.
Not be, my lord, it cannot be established at all. If it is goes for a trial, my lord, that they can't improve beyond what it is. And there is no corroboration. Only, my lord, the purpose of trial is to see that the accused or the real truth to be detected. My lord, the accused is entitled for the benefit what it is, my lord, now. They can't improve beyond what the complaint stage is. Well, whether any purpose would be served by going for the stage, and my lord, I am, my lord, at the point that even if the entire allegation is taken
as true, it would not make out an offence. Clause
Make
1
out
of
an-
Bhajan Lal.
my lord, even if the trial is conducted, my lord, that it will
Chances
not
of
possibly
conviction are
reach
bleak.
the stage of conviction. My lord, this is very important, my lord, because of the delay. The conduct is very important, my lord.
Yes.
Well, ultimately, when the matter, my lord, reaches for the final stage, at the stage of appreciation, the silent conduct of mother, father, boy, my lord, for 4 years, and my lord, this is the reason, my lord, that it could be possibly, my lord, that this story could be developed because of they were unable to comply the debt that was due to this lady. There is an oblique motive in inventing this story. This we have put it in writing in the petition itself. My lord, mala fide reason is there to file this complaint. My lord, therefore, my lord, that when there is no corroborative material, my lord, mere allegation, my lord, cannot be substantiated even if the trial takes place. And my lord, it is an improbable story. They say that, my lord, we are not, my lord, on the point that reverse spoke so or the boy cannot lodge.
No, it's not.
We have not
That is-
raised,
that
we have
is-
not
see,
taken any such contention.
I am not on rhetoric.
Not on
We'll
that,
go
my
to
lord.
reality,
Yes,
whether it has
real
happened or
fact,
not.
my lord, that you will actually kindly see during investigation, my lord, the investigation officer, my lord, has collected text messages of mother and this lady.
So
My
that
lord,
that I saw it. That shows cordial relationship between everybody.
not even a single word, my lord, about anything against this accused. Cordial relationship, my lord, the date mentioned, my lord, in the month of May. My lord, month of May, my lord, that kindly see page 126, my lord. Continuously, my lord, that the boy has gone normal and he has next day again he has come. He has written in the house of this accused. And my lord, again same relationship it was. My lord, if such was the instance, my lord, he would not have come at all. The text messages are that where is this boy Bhargava, the Bharat? Then, my lord, so many instances. He is coming back. He is
The
he is
name of the
normal.
victim may not be
He
uttered.
has put a text messages, my
Name of
lord.
the victim may not be uttered.
You want to go away?
No, my lords, name of the victim may
name
not
of the
be
victim,
amended.
not
Yes,
necessary.
we never expect. The victim will say that, my lord, the text messages reached like that. That's why I use the word, the name it is.
Yes, all right.
My lord, they kindly see page 127 also. My lord, that dated 8/5/20, your lordship. My lord, these kind of text messages, my lord, in between the mother and this accused, my lord, cannot be such instance, my lord, that. And one more girl was there, my lord, with this boy, always she is to be. By name, my lord, I can refer that name also. She is not even a witness for this. Continuously, lordship, kindly see, up to August, my lord, up to August text messages, my lord.
Only one line at page 119.
119, my lord, yes.
Last paragraph.
Yes, this is the letter put by
the petitioner.
By the petitioner.
Correct.
Yes.
Last
My lord,
line.
after
Last
arrested, my lord. Yes. After arrested, my lord. No, these are all the allegations that was made against her in the complaint. She puts a question to this complainant.
Why now?
Why now it is? My lord, that this is the
Why now
incident.
after 4 years?
Yes. I do not know what this is, my lord, that all these questions, my lord, it was put in writing and sent to this complainant mother. My lord, it should be read, my lord, in the entire text of this. right from the beginning, my
I know,
lord.
that's
She
what
puts a question, my lord, that.
Text in the context.
Yes, in the context, my lord, it is. Not the word, my lord, that she, my lord, she was in police station, immediately she texted this. She asked her, when so close we were living, why this, at this stage it is, we have come up this. My lord, this is the reason, my lord, that, my lord, if really she was guilty, my lord, that she would not have put this kind of it is. My lord, probability is to be seen, your lordship.
So probabilities are preponderant. That's a different thing.
Yes.
But whether it can be proved beyond all reasonable doubt is what is.
That is for them to establish, your lordship, that, but the question here, my lord, that read it as it is. Can it reach the stage of proof beyond reasonable doubt? My lord, going for trial, my lord, is no purpose in this case. My lord, delay is not explained here, my lord. Complaint is, delay is not explained. 4 years. August, my lord, 2020, they left.
When the complaint was registered, even then he was a minor.
My lord, here the most crucial aspect for grant of bail, your lordship, this fact was said to have been disclosed in the month of February. But immediately complaint was not lodged. Even after disclosure, my lord, 4 months they took it, they came here, and in the month of June they lodged a complaint. This is another aspect it is. And my lord, the reason for it, my lord, mental disorder or abnormality was detected by psychologists because this boy was, my lord, was put in a school, my lord, where no one, my lord, was acquainted to this boy, nor the language was known. In Dubai, my lord, then in a college, my lord, in a school where he was put, he was not able to adjust to the atmosphere of the school. That may be the reason for mental maladjustment. The psychologist has reported that is one of the ground it is.
He's a reputed artist.
My lord, she has achieved, my lord, acclaim in this field. She has been recognized. But the target is that, my lord, she could not tolerate. They had come only as a tenant, my lord, in that community. My lord, 200 odd community, my lord, in that entire compound. She is living, my lord, since more than 20 years. My lord, this family came only, my lord, about 6 months back and got acquainted to the lady, and the relationship was happy. And my lord, even the complainant's husband also was close to her. They used to visit. And in spite of it, my
Complainant's
lord,
husband? Who is
yes,
the
my lord, that
other?
the father of that
Complainant is
victim.
the mother of the victim.
Father of the victim, all that. And the sister was also, always, my lord, the sister used to accompany with this boy. Well, this kind of allegation, my lord, is all formulated to see that some case is registered against the petition.
You had lent money to them, is it?
Yes, my lord. They had taken assisted, they were bankrupt, my lord, when they left India in the month of August 2020. They don't have any source at all. She had assisted. They went, my lord, after going, my lord, for 2 months, she texted messages. Thereafter, she stopped.
So your grounds are delay and improbability.
Improbability and the malified reason, my lord, because it was due of money to this lady. To avoid that, my lord, they have come up with this false story.
All right.
And it looks,
and
my lord,
4
it
and
is-
6 POCSO. Yes.
With this, my lord, I pray, my lord, that the proceeding, my lord, not to be continued. It is to be stalled, my lord.
Please, my lords. My lords, so far as the question of whether or not the proceedings ought to be quashed at this stage, everything that has been urged on behalf of the petitioner is a matter of trial. It is not something that can be looked into in the context of section 482 of the CRPC. Now, my lords, let me, for the sake of argument, move outside of it and look at the quality of the evidence before the learned trial court, whether that is sufficient to sustain a prosecution, not the question of conviction. The victim's testimony is there, and everything from the detailed description of the incident to the delay in filing of the FIR, there is detailed explanation as to why everything has happened the way it has. Now, whether or not that version is correct is again a matter of trial, number one. Number two, my lords, we are not dealing with the case of an adult victim. When it comes to a child who has been sexually abused, the Honorable Supreme Court had a occasion to consider whether delay can be a ground to acquit an accused. The Honorable Supreme Court has come back and said in matters of child sexual abuse, there are various dynamics because of which the victim can sometimes disclose the abuse several years later, because of which delay cannot be a ground to result in an acquittal of the accused, that has to be tested. Thirdly, question of improbability. Ultimately, there might only be the testimony of the victim before the honorable trial court. I'm not conceding on that. But State of Punjab versus Gurmeet Singh says a victim's testimony absence material inconsistencies can result in the conviction of an accused for the offense of rape. All of this, my lords, is a matter of trial. It has to be considered. Now, a question has been raised about a certain monetary transaction that was apparently taking place between the petitioner and the respondent number 2. That is again a matter of trial. The case being canvassed before this honorable court is everything that the accused says must be taken at gospel truth and face value, but everything that is found in the FIR must be treated as if it is the product of a 13-year-old with apparently questionable character. When the comparison is made, my lords, if I am not entitled to the benefit of doubt in this manner, she is also not entitled to the benefit of the doubt in the same manner. And if this court has to consider the testimony of somebody in her 50s versus the testimony of somebody who is below the age of 18, if weightage is given more to the 51-year-old.
That is what is shocking the court.
Please, my lords.
I
Please,
can
my lords.
understand, see, this 21-year-old, 17-year,
Please, my lords.
25, 17.
Please, my lords.
This is 50, 51.
Please, my
The
lords.
petitioner lady is 51.
Please,
And the accused minor boy is 13, 14 at the time
Please,
of
my lords.
the
And if I may
incident.
make one more submission, my lords, look at it from
And the offense is a sexual assault
Please, my
and
lords. Please, my lords.
penetrative sexual assault.
If I may just draw
4 and 6 is what is alleged.
If I may just draw my lord's attention to one aspect of the matter. I put myself in the shoes of a 13-year-old who has been through a traumatic incident of this nature. Not knowing what is the nature of the act being committed upon him, would a reasonable boy in this position immediately cry Bloody Mary to the entire world and say that this has happened to me? Or would he likely suffer from either confusion, some kind of self-doubt, some kind of blame, because of which he's suffering from other forms of mental health issues, because of which there is a delay? This issue, my lords, whether he was prohibited from making the disclosure due to these aspects, must also be considered in the context of a trial. It can't be considered in the context of a 482 proceeding. If I may kindly draw my lord's attention to 206, which is the report of the psychiatrist.
Page?
206, my lords.
Of the paper book?
Of the paper book, my lords. I'll read out, my lords, history of the presenting condition. That is the section.
That is of the child?
Of the child, my lords. Examination of the child by the mental health professional.
Child 13 years.
At that, please, my lords. This was in so far as
no, height says 178 cm.
Please, my lords.
That's 6 feet.
I'm not sure what is the date of this psychiatrist.
5'11".
Please, my lords. There is a birth certificate to show what the age is. That is again a matter of trial.
True.
If I may read out, my lords, history of presenting condition. Bharat's apologies, my lords. Father reported that. Stand corrected.
Yes.
Stand corrected. So-and-so's father reported that so-and-so has requested for psychological help following an incident of sexual abuse that was perpetrated against him in 2020. So-and-so stated that although he thought he was able to initially cope after the traumatic incident, he had been facing difficulties with labile mood, emotional eating, poor quality of sleep, self-blame, confusion, and negative emotions after certain triggers, smelled similar age women as the perpetrator paintings, which have exasperated over the past several months. This is the history of the presenting condition. When I come to the FIR, my lords, after this, in the FIR...
Now you read it page 205, right?
206, my lords.
206.
Please, my lords.
That is physical examination.
The Open Minds is a psychiatric facility, my lords.
Page
in Dubai. The address is
Dubai,
in Dubai. Please, my lords. After he went there, when he was having recurring troubles, so that is when he was taken to a mental health professional for counseling and therapy.
In which your paper objections, is it?
No, my lords. This is filed along with the petition. In my paper book, it says page 204 is the first page. Page 206 is what I read.
Dubai, they have Dilwala.
I don't think he seems to have different copy.
I seem to
give that.
This is the copy that was served on us, my lords.
There in our report. Investigation papers as well.
ಇದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ ಐಒ ಪೇಪರ್ಸ್ ಇದೆಯಲ್ಲ.
Last part, my lord, the petition.
206, yes.
203, 204, my lord. Open minds.
ಎಲ್ಲಿದೆ ಸರ್?
Last paper,
Yeah, sir,
last part of the 5 sheets. My lord.
206 ಇದೆ ಹಂಗಾಗಿ.
There is some mistake, my lord, in the pagination.
You read.
Last about 5 sheets. my lord.
Investigation papers ಇದೆಯಾ?
ಇದ್ರಲ್ಲೂ ಲಾಸ್ಟ್
From reverse side, my lord, five sheets, my lord.
All right, I'll flag it ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ.
Please, my lord.
Yes.
Please, my lord. So this is the, insofar as the condition of the boy when he went for examination is concerned, there are two things that are recorded: feelings of self-blame and confusion. Now, is it probable that a 13-year-old who has been subjected to a aggravated or a penetrative sexual assault has feelings of self-blame and confusion as to the nature of that committed upon him? The reasonable thing to assume is that yes, such a feeling of self-blame or confusion is likely. And if that is the reason for the delay, the court may very well disregard the delay and still sustain a conviction. Therefore, mere delay in the context of a case of child sexual abuse must ultimately be seen, my lords, in the context of what is the nature of the crime. This crime has very unique dynamics to it. It is not a case involving an adult. A child's understanding of what has been done is not fully developed or mature. And in the FIR, my lords,
Yes.
what is recorded is a clear statement
Yes.
I'll read out the entire statement, my lords, to explain what is the ingredients made out to show that the ingredients for the offense have been made out. ಈ ದೂರಿನ ಸಾರಾಂಶವೇನೆಂದರೆ, ಫಿರ್ಯಾದಿದಾರರು ತಮ್ಮ ಪತಿ ಸೋನ್ಸೋ ಮತ್ತು ಮಗ ಸೋನ್ಸೋ ಹಾಗೂ ಮಗಳು ಸೋನ್ಸೋ ರೊಂದಿಗೆ ಈ ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ಆಗಸ್ಟ್ 2020ರವರೆಗೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಿದಾರರು ಈ ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿದ್ದ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರ ಮಗ ಸೋನ್ಸೋ ಫಿರ್ಯಾದಿದಾರರು ವಾಸವಿದ್ದು ಸಮುದಾಯದಲ್ಲಿಯೇ ವಾಸವಿದ್ದ ಸೋನ್ಸೋ ಎಂಬುವರಿಂದ ಲೈಂಗಿಕ ಶೋಷಣೆಗೆ ಒಳಗಾಗಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಿದಾರರ ಮಗನು ಈ ಸಮಯದಲ್ಲಿ 13 ವರ್ಷನಾಗಿದ್ದು ಮಲ್ಲೇಶ್ ಪಾಳ್ಯದಲ್ಲಿರುವ ಗ್ಲೋಬಲ್ ಸಿಟಿ ಸೋನ್ಸೋ ಶಾಲೆಯಲ್ಲಿ ಸೋನ್ಸೋ ತರಗತಿಯಲ್ಲಿ ಅಭ್ಯಾಸ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಘಟನೆಯು 2020ರ COVID-19 ಸಮಯದಲ್ಲಿ ಮೇ ಜೂನ್ ತಿಂಗಳು ನಡುವೆ ನಡೆದಿರುತ್ತದೆ. ಫಿರ್ಯಾದಿದಾರರು ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರು ವಾಸವಿದ್ದ ಸೋನ್ಸೋ ಸಮುದಾಯದ ಮಹಿಳಾ ವಾಟ್ಸ್ಆಪ್ ಗ್ರೂಪ್ನ ಸದಸ್ಯರಾಗಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಿದಾರರು ಸೋನ್ಸೋ ರವರೊಂದಿಗೆ ಪ್ರಥಮ ಪರಿಚಯವು ಸೋನ್ಸೋರವರು 2020ರ ಮಾರ್ಚ್ನಲ್ಲಿ ಅವರು ಪೊಟೆಟೋಸ್ ಮತ್ತು ಡ್ರಮ್ ಸ್ಟಿಕ್ಸ್ ಗಳನ್ನು ಮಾರುವುದರ ಕುರಿತು ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ
Potato drumsticks.
Please, my lords. They were selling potatoes and drumsticks. It was a small community, COVID-19.
All right.
Please, my lords. ಮಾರುವುದರ ಕುರಿತು ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ ಹಂಚಿಕೊಂಡಾಗ ಆಗಿರುತ್ತದೆ. ಫಿರ್ಯಾದಿದಾರರು ತರಕಾರಿಗಳನ್ನು ಖರೀದಿಸಲು ತಮ್ಮ ಮಗ ಸೋನ್ಸೋ ಸೋನ್ಸೋರವರ ಮನೆಗೆ ಕಳುಹಿಸಿರುತ್ತಾರೆ. ನಂತರ ಸೋನ್ಸೋ ಅವರು ಸೋನ್ಸೋ ಡ್ರಮ್ಸ್ಟಿಕ್ಸ್ ಗಳನ್ನು ಆಯ್ದುಕೊಳ್ಳುವುದಲ್ಲಿ ಬಹಳ ಸಹಾಯಕನಾಗಿರುವುದರ ಕುರಿತು ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಹೇಳಿರುತ್ತಾರೆ. ಸೋನ್ಸೋರವರು ಫಿರ್ಯಾದಿದಾರರಿಗೆ ರವರು ಗಂಡ ಮತ್ತು ಮಗಳು UAS ನಲ್ಲಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಅರ್ಚನಾರವರು ಸಹ ಫಿರ್ಯಾದಿದಾರರು ಸಮವಯಸ್ಸಿನವರಾಗಿದ್ದು ಕಾರಣ ತಮ್ಮ ಮಗನ ಸೋನ್ಸೋರವರಿಗೆ ತರಕಾರಿ ಹಂಚುವಲ್ಲಿ ಮತ್ತು ಗಾರ್ಡನ್ ಕೆಲಸಗಳಲ್ಲಿ ಸೋನ್ಸೋರವರಿಗೆ ಸಹಾಯ
Accused is not married.
Accused is, I believe she is not married.
Married, having daughter, my lord. She is pursuing studies, my lord, graduation. My lord, her father was in the same house, my lord. Father, my lord, age about 86 years. He resides in the same premises.
I'll read further, my lords, just to explain what the nature of the complaint is. ಕೆಲಸದಲ್ಲಿ ರವರಿಗೆ ಸಹಾಯವಾಗಲಿ ಎಂದು ತಮ್ಮ ಮಗನನ್ನು ಅವರಿಗೆ ಕಳುಹಿಸುತ್ತಿರುತ್ತಾರೆ. ಸುಮಾರು 2020 ಮೇ ಸಮಯದಲ್ಲಿ ಸೋನ್ಸೋರವರ ಫಿರ್ಯಾದಿದಾರರ ಮಗನನ್ನು ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಅಲ್ಲಿ ಅವರ ಆರ್ಟ್ ಅಕೌಂಟ್ ಅನ್ನು ನಡೆಸಲು ಕಳುಹಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. 2000 ಮೇ ಜೂನ್ ಸುಮಾರಿಗೆ ಅಂತಹ ಒಂದು ಭೇಟೆ ಸಮಯದಲ್ಲಿ ಸೋನ್ಸೋರವರ ಮನೆಯಲ್ಲಿದ್ದಾಗ ಸೋನ್ಸೋರವರು ಪೇಂಟಿಂಗ್ಸ್ ಗಳನ್ನು ಇರಿಸಲಾಗಿರುವ ಮಹಡಿಗೆ ಹೋಗುವ ಮೊದಲು ಸೋನ್ಸೋರವರು ತಮ್ಮ ಮನೆಯ ಮುಂಭಾಗದ ಬಾಗಿಲನ್ನು ಲಾಕ್ ಮಾಡಿರುತ್ತಾರೆ. ಒಮ್ಮೆ ಸೋನ್ಸೋರವರ ಮೊಬೈಲ್ ಫೋನ್ ನಲ್ಲಿ ಪೇಂಟಿಂಗ್ಸ್ಗಳ ಚಿತ್ರಗಳನ್ನು ತೆಗೆದುವುದನ್ನು ಪೂರ್ಣಗೊಳಿಸಿದ ನಂತರ ಫೋಟೋಗಳನ್ನು ಪೋಸ್ಟ್ ಮಾಡುವ ಮೊದಲು ಸೋನ್ಸೋರವರು ಅವರನ್ನು ಸೋಫಾದಲ್ಲಿ ಕುಳಿತುಕೊಳ್ಳಲು ಆಹ್ವಾನಿಸಿ ಸೋನ್ಸೋ ಅವರು ಅವರನ್ನು ಕೈಯನ್ನು ಮುಟ್ಟಿ ಮತ್ತು ಅವಳು ಅವನನ್ನು ತುಂಬಾ ಪಡುತ್ತಿದ್ದಾಳೆ ಎಂದು ಹೇಳಿ ಸೋನ್ಸನ್ನು ಚುಂಬಿಸಿರುತ್ತಾರೆ. ನಂತರ ಅವಳು ಅವನನ್ನು ತನ್ನ ಮಲಗುವ ಕೋಣೆಗೆ ಕರೆದೊಯ್ದು Please, my lords. Now, furthermore, as the statement proceeds, there is also a statement that says, in the course of one of the offenses, after committing one of the offenses, the accused tells the victim that, listen, if you tell this to anybody, both of us will be in trouble. Refrain from telling this to anybody. Now, my lords, there is a psychiatric diagnosis that says he's suffering from self-blame and confusion. There is a statement made before the police to say that there is a threat made by the accused that if at all this complaint is disclosed, you and I will both be in trouble. And my lords, coupled with the fact, we don't know what is the psychosocial development aspect of the boy, whether he understands sex and sexuality, whether he's in a position to appreciate the nature of the crime committed on him. When all of these is seen in totality, whether the delay can be explained, my respectful submission is that the delay can be explained. And the settled position of law being that in cases of child sexual abuse, delay cannot be a ground for acquittal, and there being also a settled jurisprudence to say that a victim's testimony by itself, absence material inconsistencies, can result in conviction. My humble submission before this court is, as against the rights of the accused, a victim has a right to be heard as well.
Yeah, I'm hearing you, sir.
Not before this honorable court, my
Yes.
lord. All I'm saying is that the victim has a right to make his case before the honorable trial court. That very right, my lords, is what is sought to be challenged in the proceedings under section 482 without the benefit of cross-examination or trial.
Learned senior counsel has put up some formidable points. We will answer that. You have
Please, my
said
lords.
something, we will answer.
Please, my lords, I have some citations on the point.
Here,
The
reply.
age gap is what is troubling.
Page 86 and 87.
Reply, your lordship.
Huh?
The way of reply, your
Yeah,
lordship.
yes, sir.
May I please take my lords through the judgments, my
No,
lords?
no, don't worry, I'll go through them. What are those? 1 minute.
So there are three main judgments that I'm relying upon.
Ranjit, I know.
One is Bhikkhu
Yes.
Tukaram Jadhav versus State of Maharashtra, which
Yes,
concerned
yes.
a conviction in a case of child sexual abuse involving delay. The court has extensively analyzed why there are delay in case of child sexual abuse and come to the conclusion that delay can't be a ground for acquitting an accused.
Now you told about this report. What is this report here?
Please, my lords, this is the report of the Women and Child
No,
Development.
that is report of what? Whose report is this?
This is the Ministry of Women and Child Development report, my lords.
Where it shows
780.
sexual abuse on boys more than
Please,
girls.
my lords. Please, my lords. And my lords, it is also more underreported for these very reasons. Now, my lords, coming to the judgment of the Honorable Kerala High Court,
This I've seen just in Ranjit. Yes.
I'll only point out the paragraph numbers, my lord.
Yes, idರಲ್ಲಿ ಕೊಟ್ಬಿಡಿ.
Paragraph
You have not
70.
indicated the paragraph numbers here.
Paragraph number 70, my lords.
Write the paragraph numbers. Yes.
Because one of the key paragraphs, my lords, in paragraph number 74.
Pasha sir, ನಿಮ್ judgments ಇದೆಯಾ sir?
Yes, one judgment, my lord, of Kerala High Court. My lord, where?
I just point out one thing, my lords. I'm so
identical
sorry.
case, my lord.
One the submission, Swami. In para number 74, when the Honorable Kerala High Court considers the constitutionality of the reverse burden of proof, it specifically refers to the fact that when the victim's testimony is the sole account available before the court must carefully scrutinize the evidence. No evidence is being allowed to be led by challenging the proceedings under section 482. Therefore, in principle, even the Honorable Kerala High Court says that so long as even one survivor's testimony is there, it is a matter of trial. Evidence must be scrutinized. At a summary stage of section 482, it can't be quashed, is my respectful submission.
Paras ಬರ್ದಿದ್ದೀರಾ? Yes, Jagdish sir.
Page 86 and 87. Report of Samalochana Varadi.
ಏನ್ ವರದಿ ಇದು?
This is the report, my lord, reporting of crime. District Child Protection Unit Officer has recorded.
CDPO ಅದು.
Yes. Your lordship can see the next page, first para itself. Graphic details of how incident is happened.
That is what the child has narrated to the CPO. We'll see. Yes.
My lord,
Reply.
reply, my lord, if your lordship takes it, my lord, Monday will add.
ಇದಕ್ಕ?
My lord, I had to consult, my lord, the report what they have filed, my lord.
The report is only for, the report will not go by
I had
that.
to take instruction from her.
Report will not sway the decision.
No, here,
It is only
Lordship-
information that I wanted to know. that.
And also
Crucial
to contextualize that offense against boys are not uncommon and more often than not committed by known acquaintances.
I think
86%
in,
of the
I think
offenses.
in this court, this is the only case.
Yes,
Please, my
my lord.
The first of the cases here.
Yes.
Because of underreporting,
Even,
my lord.
even other high courts, my lord, there is no case of this nature where boy has alleged complaint.
That is first time I am coming
Yes,
across.
yes, my lord,
My
no
lord,
case at
it
all.
is
we
one
could
of the
trace.
most
All the judgments you have relied on, they are, yes,
Madam?
delay insofar as the victims being girls.
Girls.
Please, my lord.
Minors being girls. This is the first time
I will only,
I think it's
First time, my lord, we could not
The
come across
country.
any decision, my lord.
I
at
will
this
only
point.
make one
first time in
submission.
the country a case has come up where
Please, my lord.
a boy is alleging that he has been sexually abused.
My lord,
Only make one.
And age gap is 51-year-old lady.
I will
most-
only make one submission.
Most
my lord.
important, my lord,
If learned
Lord,
senior
the
may
most
just permit me
important
one
aspect,
submission. I'll get back.
most important aspect, my lord. My lord, as on the date of commission of the offense, my lord, aftermath of that incident, whether this boy was mentally affected, what is the material, my lord?
No, and
No, now, my lord, after 5 years,
and you
my
say
lord,
there is material that he still
Now, my lord,
Allah,
and
still visited the accused.
yes, my lord, that is the text messages, my lord,
And continued.
that is part of it. My lord, not only one day, my lord, from May to June again they say, May is one instance, June is another instance. In between, my lord, continuously. Up to August, my lord, they were all visiting the house of this accused. Their relationship was normal as per that. Now, my lord, consulting some psychologists, developing a story. No, my lord, after thought, your lordship may kindly see the delay effect, my lord. Supreme Court has explained it. Though there are many decisions, my lord, that
No,
right
delay will always
delay,
give-
my lord, gives a scope for spinning stories, my lord.
That's what
This
I
is
said.
what it
in,
is very crucial it
What
is.
I have written in few cases.
Yes.
Delay will result in retrospective embellishments to the
Embellishment, that
allegations.
is what, try to develop, my lord, embellishment, exaggerations, concoctions, my lord, in 1973 Supreme Court in Tuliakali's case, my lord. That again, my lord, in Mera Singh case, Supreme Court has explained in 1994. These series of decisions, my
That is
lord,
why delay will
my lord,
always
delay-
result in retrospective
always-
embellishments.
Yes, my lord, here, now whatever the document, my lord, is after FIR. My lord, first FIR was prepared.
No, correct.
What is required?
Everything is after
My
FIR.
lord, it is after FIR, my lord. After FIR document also do not show as on the date of offense or immediately after the offense or proximate to this act, my lord, whether the boy was affected mentally so that he could not disclose to his mother or father. There is no material, your lordship. Now the crucial question is this, your lordship. My lord, the medical evidence is absent totally. Social welfare officer statement is also, my lord, narrating same what is there in FIR. My lord, FIR was got prepared, my lord, with a legal consultation so that the ingredients of section 4 and 6 could attract.
Advocates
My
drafting.
lord, yes, advocates drafting, my lord, that too in Kerala. This all, my lord, my lord, it is got drafted there.
That's
My lord, the
grossly.
most important aspect, my lord, that the Supreme Court in Muhammad Ali's case said, in a case where a complaint is lodged with legal consultation, court should be very careful in reading it. It should be read in between the lines. That is what, my lord, cautioned by the Supreme Court. Your lordship relied in many cases. My lord, the
2023
question-
SEC online SC
Yes,
950.
my lord, Muhammad Ali's case.
Followed
and
in Muhammad Wajid
Muhammad Wajid
951.
and Muhammad Ali's
Yes.
case. My lord. Here, my lord, whatever the document in the charge sheet, my lord, neither medical evidence nor psychologists say. Psychologists, my lord, possibly are likely. My lord, anyone can, my lord, this kind of hypothetical opinion, my lord, that question is immediately after the incident, whether this boy was mentally affected, psychologically affected so that he could not disclose for 4 years.
No,
And why 4 years after his mind was so
Complaint-
blotted out so that he could
Correct.
narrate it?
The narration in the complaint is the moment you touched him,
These are
he
all, my
began
lord,
to tremble, shiver. He did not know what to do.
What to do? All right, my lord, he has gone to her.
He began to kiss
He
him
has
is what
returned
is
to he has returned to his house. He has eaten, my lord. He
Eaten.
was normal. He has slept there. He has, my lord, again next day he has come to the house of accused. My lord, for 1 month normal. My lord, these are all, my lord, that We need not question this by all these aspects. Your Lordship has to visualize, my lord, that what would have been that. Yes, your Lordship. My lord, this is, my lord, in a case of this nature, the psychological mind, my lord, that, my lord, when the complaint is lodged with an ulterior motive, my lord, these are all these stories, my lord, could be developed. It is not impossible for any person, my lord, to.
No, it's not impossible. I'm not.
They have done it here in this.
No, no, it
But,
is not
this-
impossible for you, not impossible for him.
My lord,
Whatever.
question, my lord, reality, my lord, that real aspect, my lord, that a innocent should not be pushed for a criminal prosecution, which in all probability could not have happened. My lord, this is the question of
That's what
probability
even
is
Bhajan
very
Lal
important.
says.
Bhajan Lal's case, my lord,
Because if the incident is highly improbable.
highly improbable, my lord. Here, my lord, can this boy was of such a nature, my lord, if he was unconscious, he was, my lord, if
Obviously became unconscious the moment you touched her. Touched him, sorry. Yes.
well, what is the material, my lord, now to show that?
Right, sir.
Well, these allegations, my lord, can be written medically.
Sir, a
My
boy
lord,
who does, a boy who
medically,
doesn't, no, boy who doesn't know anything, 13 years or 14 years.
my lord,
Well, I don't
14
know
years
about that.
boy,
but-
my lord, by stature, he was more than 18 years. The doctor has, my lord,
Yes,
has
height
noted
can't be held against
he
him.
is not a boy of a funk boy, my lord, who could not narrate anything. He was developed, my lord. He has grown up in Bangalore.
that's
He has
what
studied
he
in
says.
school. He
The-
used to move with girls, my lord, and she used to
My
come
lord,
with the
again-
girls
The
to
com-
the house of the accused.
The complaint says that the moment you touched the boy who did not know anything, he began to tremble and could not react to what was happening.
Yes.
Then
My
you
lord,
began to kiss him and then took him. That is what is said.
yes, my lord, for this, my lord, for this narration, my lord, no scientific evidence. My lord, there should be something, my lord, whether in his life it had happened like that. Mere oral
In whose
narration, my
life?
lord. My lord, some medical assessment.
I know, I
This-
don't see a parallel to these facts. That's why I'm not able to get any
That is
precision.
also, my
No
lord,
parallel to these facts.
there are aspects, my lord, that, my lord, these kind of instances, something, my lord, mentally affected, my lord, is not diagnosed by any of the doctors.
No,
There
he's
there
not,
is no,
it
there
is
is
not
no
that he's
con-
mentally unsound.
It's a psychiatric
Not-
condition.
That
my
is the
lord, number
reason, my
one.
lord, that he
But
was a
to-
normal child. He was normally behaved. He was normally admitted to the school at Dubai. For 4 years, he spent as a student. My lord, after 4 years, why it has happened? Why he was able to disclose?
There must be some motive.
Some motive it is. My lord, the reason, my lord, medically it is not proved here. This boy was totally, for 4 years, he was funk. He was totally abnormal.
Abnormal?
Thereby, abnormal,
Material
abnormal,
illa anta ಹೇಳ್ತಾರೆ.
psychologically abnormal, your lordship. This is what it is. There must be some material to this effect.
I will make
No, my
just-
lord, if this is not proved, my lord, that it is an exaggeration only. Preparing, submitting an FIR after 4 years, my lord, in consonance with developed FIR, my lord. My lord, preparing all these statements, police also, my lord, they are, my lord, copying the same allegations made in the complaint. My lord, this kind of oral allegation, my lord, possibly could be concocted as an embellishment, as an exaggeration after 4 years. Delay itself, not that, my lord, I am saying
No,
here.
delay itself would not be
Not
fatal
be-
in all
would
cases.
Not, no doubt, my lord, that here the question, my lord, is what would have been the conduct of this boy, whether he was mentally affected or so. My mother doesn't say that, my lord, no instances narrated in the complaint. When this boy came home, I saw that he was totally abnormal. His mind was affected. I nourished him. I gave something. My lord, nothing was noticed on that day.
There is one statement saying he appeared lost.
No, my lord, not that. Yes, the text messages, my lord, has to be seen, not, my lord, now to say. Text messages produced by them, my lord, that is the reason, my lord, say, my lord, these text messages are ante litem documents.
Antedated.
Ante litem documents. Litigation started by FIR. My lord, these are all, my lord, text messages past of FIR it is. My lord, undisputed point of time, my lord, these text messages were there. In this text message, my lord, kindly see 196 or 119, my lord. 147, will Ashima kindly see. Well, there is normal instance it is. This should be given credence, not whatever developed now. It is their own document it is. Well, it is normal conduct. She never mentioned that the boy was totally disturbed in mind. He was sweating. I gave some treatment and all that. Mother should say, my lord, this. Mother should say, these are all psychological appreciation.
At that time, they didn't know that the offense had taken place.
No, no,
Or
no,
why
no
would they-
question of knowing. This is the, what it
No, no,
is.
he is, senior
This-
counsel is saying about the repercussions.
Repercussions of the act committed.
Repercussions of a touch.
Touch. That should have been sensed by the mother. She is the better to observe. Not by a doctor or psychologist after 4 years to say, likely to happen, likely to happen. For likely, my lord, everything likely it is. My lord, no criminal case will stand. Kindly see, my lord, that here,
No, if he was exasperated.
yes, my lord, mother should notice, my lord, that the clothes should have been disappeared or something should have happened.
Clothes, sir.
My lord, clothes of the boy should have been, my lord, in normal, not normal in condition. Mother should narrate all these instances. Nothing is there.
My lord,
My lord, this
all
kind
that
of
is a matter
story,
of
my
trial.
lord, is with an oblique motive developed on the
No,
basis
there
of
is, the
developed.
allegation further is remove the clothes also.
Yes, yes,
in the
that is
complaint.
what it is, my lord, that how
The
can.
allegation
my lord,
does not say he was forced to go out in that condition.
Yes.
No, no,
All you know,
true.
he was able to wear his clothes back and go
Took
back.
him into the bedroom, removed the clothes.
The
That's what
moment
narration
that, the moment the
goes on.
factual inquiry goes into that level of detail, my lords, my respectful submission, it's a matter of trial. Number one. Number two, my lords,
Nothing could be
injuries of the
improved.
body alone is not medical evidence. Injuries of mind is also medical evidence. To draw the dichotomy to say that a psychiatrist report has no bearing, but a medical examination report of a physical examination has a bearing, there is enough material by the team at Nimans also to show that children who have been sexually abused go through severe mental health problems. That is proof of the offense.
Those
I'm
are
happy
all-
to place that literature before this honorable court.
Those are all general literature reading will not help the prosecution in this case.
To
My
show
lord,
it is-
in this case,
to show
in
the
this
context.
case, what it is, kindly see, my lord, the text message right from, my lord, 1/4/2020, my lord, relevant date, what they are saying, my lord, May 22nd or May 1st. My lord, it's all normal.
You registered the incident in May, is it?
My lord, May 2020. Kindly see page 126
So
and 120.
because the incident is in May, you are saying it may have happened or not happened?
Must not have happened, your lordship. Kindly see this, my lord, page 126. The text messages are normal. My lord, if at all mother had noticed, my lord, she would have put it in the text message itself. My boy had come to your house, what you did? There is no such text message in this.
Mother ಗೊತ್ತಿದ್ರಲ್ವಾ ಕೇಳಕ್ಕೆ?
ಗೊತ್ತಿರೋದಲ್ಲ, ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದವರು.
Observations
ನೋಡಿದ
ಅಲ್ಲ.
ಬಾಯ್ ಬಂದಾಗ ಮನೆಗೆ ಬಂದಾಗ
trembling.
ನೋಡಿದಾಗ ಸ್ಟಬ್ಲಿಂಗ್. He was in nervous condition. He was totally
So that
mentally
condition was
affected.
over there only.
If it had not been noticed, my lord, now neither the police officer nor social activist to say it could happen, it may happen. My lord, those are all literatures. They can be written here. But
So
my lord, that
literature
cannot
won't
be-
help in criminal law.
My lord, the fact should be proved, your lordship. Fact must be there. It cannot be developed on the basis of theory to be.
Allow the
Here,
case to trial,
their
my
fact,
lords.
my lord, that it is this, my lord, kindly this document, my lord, this text messages, which is produced by themselves, is a part of charge sheet. My lord, it cannot be discounted. It is to be given
That can't be,
importance.
yes, correct, no doubt.
If it is taken, my lord, as a primary evidence, my lord, such kind of instance must not have happened. No, now what they develop, my lord, it is possible to develop. This should be given credence. Kindly see, my lord, it is from February up to August, my lord, till they departed India and went to Dubai. Text messages are produced by themselves. Kindly let them show, my lord, any one word by mother expressing the happening of such incident against the boy. Not even a single word, my lord, that it runs for more than, lordship, kindly see from page 125. And this is the best evidence, your lordship. Electronic evidence is the best evidence.
Correct.
This cannot be disputed by anyone. This cannot be edited also, and they have produced. And their document it is. This should be given primary
Part of the
importance.
records
This should
here.
be given primary importance. This is a primary evidence and the most foundational fact for the case. Anyone can spin stories, my lord, with an exaggerated version. It has happened now. It can be said like that. Why to go for trial? What you are able to develop, what they are going to achieve. If anything improves, my lord, it is almost to contradiction. It is. Read it as it is. This document, my lord, this document text message, if it is taken with their all 161 statement, social psychologists, well, whether it will outweigh it. Whether this documentary evidence could be ignored, outweighing their document. It is also their document, it is. Comparison, my lord, that is the reason, my lord. In 1965 Supreme Court, it is said that any document which is ante litem mortem should be given credence to post litem document. Post litem document, my lord, has no significance at all. Under these circumstances, my lord, kindly, my lord, these text messages right from 125 up to 176 for more than
50 pages.
It's more than, my lord, 50 pages it is. My lord, up to August, my lord, that up to September 15th, 9, my lord, it is 15/9. My lord, even after they went to Dubai, for about, my lord, 1 month text messages are there. Can that be so silently kept by boy? And the reason, my lord, that the most crucial aspect to be assessed, my lord, that, my lord, after 4 years, what had changed in the mind of this boy to tell this fact? Well, that is not, no one has assessed, no version is put, no explanation for this. I'm not canvassing the delay it is, but the factor, my lord, that it is to be considered by the court of law, my lord, that because these kind of stories are absurd in nature, that is covered by Vijayanlal's case, where it is, if it is absurd in nature, the proceeding is liable to be quashed. Possibly that it can be, it is a matter of trial. I am not going for matter of trial, it is something they want to develop it. Their own document, read it as it is. I have not invented anything, nor I have set up any defense here. I have come up here before this court only on the basis of a charge sheet material.
Correct. Only on the basis.
Only on the basis of charge sheet material. I have not produced any document. Let my document need not be considered. Consider only the charge sheet material, whether these text messages could outweigh with these post allegations made in this case. My lord, with this, I pray, my lord, that if at all, if any such instance had happened, my lord, that would have not been the normal text messages. This should be given important, it is.
Yes, Ashala.
Please, my lord. All I'm saying is that repeatedly it's been said, I have to prove all of it. Give me the chance in trial. Let the victim come and take the witness stand. Let him make his case. That's all my respectful
Can't
submission
improve
is.
it in witness box, something
I don't
you
have
will
to.
not be allowed to.
I don't have to. And my lords, just to also point out,
But one decision, my lord,
scientific evidence or medical evidence at the end of the
Good
day.
sir.
Yes, yes. Lord, 2024 Supreme Kerala, page 697, your lordship.
Yes, sir.
Lord, here, timely reporting, my lord, is an important aspect in a criminal proceeding.
Correct.
There is a delay, my lord, exaggeration, embellishment.
But that I told you.
Yes, it is.
It will result in retrospective
And my lord,
embellishment.
the Kerala High Court has exercised, my lord, the power under Article 226 and 482. Identical case, my lord, where POCSO offence was alleged. My lord, the proceeding has been quashed. With this, my lord, I pray, your lordship may kindly.
This appears to be an offense under 376, my lords. The judgment that I have produced is specific to a child victim. Therefore, and POCSO Act, my lord, is a special legislation. Parliament is deemed to have assumed the existence of the circumstances necessary to necessitate a legislation like this. Now to say that this is improbable, when the Parliament has said something like this is probable, and therefore made it a gender neutral offense. In fact, I must point out, my lords, this is not a reverse POCSO case. This is a POCSO case. Because the offenses under the POCSO are gender neutral.
That is a terminology for convenience I have.
I just wish to point out that it has somehow been seen as an exception to the general rule. It is not. It is equally probable that children, boys are also sexually abused. Please,
Ho gaya? Heard reserved. Any other judgments you have? Nothing.
No, my lord.
Anything?
If Full Singh is the one judgment.
Huh?
Full Singh judgment.
Full Singh.
If I can only seek liberty to produce the literature of Nimans on the subject of what happens to children in these circumstances.
Why will that be relevant?
Please, my lord.
We'll see. If I
Because
we'll
when these questions are being raised, why did he wait so long? Why did he not show obvious signs of trauma? There are explanations for all of that.
We'll answer all the submissions.
Lord, investigation is completed. Charge sheet is filed.
Yes.
In the charge sheet, my lord, there is no explanation as to the reason.
So that is why you are saying we should go by the charge sheet material.
Yes, my lord, on the basis of charge sheet, my lord, what was the position of this child as on the date of commission of offence? Whether it was disturbed? No material.
Delay is explained in the
Now
FIR.
they are coming after 4 years. The child was exasperated. He was totally under shock. By touch it is. oral
That is
allegations.
probable.
My lord, this, my lord,
Touch resulting in trembling is probable.
my lord, it is question fact, my lord, it is a fact that should be, my lord, at that time. These are all the instances, my lord, should have happened if incident had happened. That could have been happened if it is really happened. And that fact should be as on the date of commission of the offence. For that, my lord, in the charge sheet, there is no material. Neither the doctor stated, nor the social and nor the psychologist stated, as on that day, this boy was affected. Fact as on the date of offence, my lord, your lordship kindly, these are all the consideration, my lord, appreciation of evidence, which is, your lordship has to visualize at this stage itself. This is the reason, my lord, that the consideration is very, very important it is.
We'll
Not that
visualize.
visualize means by seeing, my lord, that.
No.
Kindly,
Imagining.
kindly go back to the stage, what could have been happened.
That's
Whether
what,
it could have gone unnoticed by mother. Whether mother would have left unnoticed this.
visualize ಬದಲು probable.
Visualize and ನೋಡಿ ಅಂತಲ್ಲ. ಅದು ಅದನ್ನ this lordship mind should go back to the stage of that.
We'll see where my mind will go.
Kindly.
Yes.
Thank you, Lord.
Yes.
Thank you, my lord.
Head reserve. Yes. 6 ಗಂಟೆ. ನೋಡೋಣ wait. Why is the learned advocate general here? Oh, smart meter.
101, my lord. Further hearing matter.
Smart meter. You look exhausted.
He's
After
had a long
playing-
day.
Huh?
He's had a long day.
Been
Not by
batting and
arguing, by
bowling in
playing.
the RCB match.
Wrong day.
RCB matches are keeping everybody busy, man.
No, if you're exhausted, then we'll.
No, well, I think they filed their objection today.
We
Your
have
Lordship,
filed our, my lords, I appear for the successful tenderer. We have filed our objections.
Successful tender in this smart meter.
They made them also a party.
Yeah, the entire petition,
ಮಾಡಿದ್ದೀರಾ?
in one of the petition contains.
So that definitely presupposes that you are the person who lost the tender.
No, it doesn't.
3/4 of the
I will
petition,
not even go
3/4 of
into
the
the
petition.
aspect of the tender. I will assure your lordship, I will not go into
But the
that
pleadings,
aspect.
my lords,
It would be
3/4 is
only
on the tender.
incidental to the matter where we will bring in those details, but it will not have a
Question
bearing
is
on
whether
the
they
matter.
need meter or not.
The
They are
question-
challenging that, making the tenderer itself as a party to this proceeding.
No, because
3/4
tomorrow
of
they
the
will say I was not made a party to it, so
that's-
therefore
see,
we made a party. We
She is
don't
right
seek
in
any.
making the tenderer a party. This is not a PIL. So
Well,
somebody should be there on record.
Correct, but the question is whether meter should be put in
She
a.
andre client is also lady, is it?
No,
No, no, the other matter, the
Adರಲ್ಲಿ,
client
yes.
is the lady.
Whatever it is, whether,
Otherwise, is a learned senior
Allah,
counsel.
no,
Yes.
from the entire petition, we don't know whether they want power, but they have filed a petition.
Whether.
Or whether somebody has said you obtain a smart meter, nothing is come out.
ಹೇಳಿದಿರಲ್ಲ
ಇಲ್ಲ
ಎಲ್ರಿಗೂ.
ಇಲ್ಲ ಬೇಡ ಅಂತ
Our
ಹೇಳಿದ್ದೀವಿ.
totally in their petition, not a single sentence that I have filed a petition.
us to take a smart meter.
They've asked you to take.
We'll
Let
take
us
So,
take what it
it
is.
should have been placed. Is it, my lords, if my learned friend is there, if you can show a document where Bescom has told him, you obtain a smart meter?
No, forget obtaining. a
No,
smart-
how-
they have not filed an application for.
What,
application
that's all
and-
right. Now, for the sake of the court, how did you arrive at this decision of imposing the smart meters on everybody?
The act-
One
no,
minute.
please.
What did the KERC tell you?
This is mandate.
What is mandatory?
I'll read it out.
Mandatory ಅಂತಿಲ್ಲ ಅಲ್ಲಿ.
I'll point it out.
Yes, madam.
My lord, I'll
KERC
just read
ಏನ್
it
ಹೇಳಿ-
out. I'll read out 2 minutes.
Lord,
Just
may I
read out
just-
central
even
electric-
before the learned advocate general, that's the second step. My lords, I would humbly submit, it's like a door. First, you establish your locus. If you have locus, I've raised in my statement 2 grounds. One, locus to question the tender, because the entire petition looks like they have questioned the tender itself and my selection. Number 2 on locus, if it's a private interest litigation, whatever action, it should affect your right. So you should have filed an application, then Bescom or somebody should have told you, you have to obtain a smart meter, which is missing. If these 2 elements are missing, the third element, why they made it mandatory, is a subject matter to be only in a PIL. You do not have a locus.
I'll answer that. my
Telling
lord.
me.
No, no.
Them, my lords.
The one answer.
Who do
to
not have the
Just to satisfy your lordship.
No, ಅದಕ್ಕೆ ಇದು
Wait,
ಹೇಳಿದ್ರೆ I will pass an order now, produce everything.
No, no.
Yeah.
That's what we have raised in our statement. Without that, my lords,
What we have done here, Central Electricity Authority says all new customer meters shall be smart meters with prepayment feature, provided the existing meters other than smart meters shall be replaced with smart meters with prepayment features within a time frame as specified by the central government. Second, Manoj, the regulation also speaks about Rule 5, saying that there should be smart meters, not only for new, but also existing. We said existing, we will not touch, because it will affect everybody. Only for new meters and prepaid meters, we are doing it.
All right. That
And
is,
they are all existing.
no, that is one thing. What, how much are you charging from a consumer for per smart meter?
4,900 and
4,998, which includes meter,
including GST.
installation, GST, everything.
Everything.
Installation.
4998.
90.
Plus it's not only the hardware,
98.
not only the meter, my lords.
Adralli have
That,
software.
that price includes installation
Installation.
and
All right.
also, my lords, it's installation test for the meter.
What
And al-
test?
Lords, every meter will have to undergo a test, which otherwise, my lord, BESCOM charges.
That's
for
your duty, sir.
No,
To put correct meters.
And also
Mineral
that price
oil.
also includes plus the integration with the system, because this is a smart meter, integration also.
Ultimately, as my Daniel said, Manoj, if we are saying that you don't have to install, they say we want to install.
All right. Another allegation is it is 900 rupees in the neighboring states.
No, Manoj.
Why are you charging 4,000?
I'm sure where there is
4,000 rupees
Let them
extra.
produce where there is.
Yavado, my lords, it's like this. They simply
No,
say.
we are, see, it may not be a PIL, but the court is interested that you should not mulct every citizen with enormous burden of imposition of 4,000 rupees extra. I thought people may give some,
It's
poor
like
man
this.
may not
Lords,
afford.
the petitioner
Manoj,
simply
I
makes a
prepared chart
statement.
of 20 states, Manoj, insofar as I just place it how where we are, it's equal to or less than other states, Manoj. I'll be able
So
to.
that is why,
I
on what rationale did you fix this 4990?
We have got it, we'll place it.
You leave about the petitioner.
No,
I
I'm
just want,
satisfying your lordship.
it is only for the court's consumption that you have to provide.
Along with the statement I prepared, along with the short note, what it is, I'll place it before your lordship.
Place that.
Please,
ಈಗ
please, my lord.
objections ಹಾಕಿದ್ದೀರಾ?
Having a Nokia old phone and a smartphone. If somebody has a old phone or even a smartphone, let's say
In
iPhone 10,
No, in
iPhone 16.
So, Allah, in retrospect now, Nokia was better. No
Was
disturbance.
ಅಲ್ಲ,
It's ಯಾವ್ದು?
Nokia ಅಲ್ಲ, ಇನ್ನೊಂದು 2000 ಬರ್ತದೆ.
ಅದೇ that same 3310.
33.
That was the
3110. Keypad.
And somebody makes a
Best.
statement, it is 900 there. Actually, my lord, my learned friend says he'll produce. They should be producing material to show it is available for 900 there. The same thing is.
That's what they have produced already.
On the
Lords, I
date
have
of-
Based on record, Hyderabad is giving it 900 rupees.
Lords, please see tabular column. Material is some document. Simply making an government tabular column does not make any sense here or there. I can also simply say it is the same, and I have said in
No.
the tabular column.
Madam is
Document-
silent.
Document is missing, not a single document.
Let them bring an army tomorrow. Now
Army.
when Rajeshri is come, who against
That's-
whom I have
that is
absolutely
exactly
no
wise.
prayer as
Rajeshri?
against, that is
Not, they have not come,
senior
they made a
advocate Mr.
party.
Fani. That is the
If I made a
successful
party-
tender. Now, there is absolutely no prayer as against him. Now they
Delete
claim,
ಮಾಡಿ.
no,
Party ಯಾಕ್
Delete
ಮಾಡಿದ್ರಿ?
ಮಾಡಿ.
then tomorrow they'll say you
Party
made
ಮಾಡಿಲ್ಲ.
certain allegations, you've not
Party
made us
ಮಾಡಿ
a
ನಾನು
party.
ಕೂತ್ಕೋಬೇಕು, I become an
Now
army.
if the learned AG wants an army, he
There's
can
a
bring in
single man army,
some more.
leave it
I have
separate.
absolutely
No,
no
I can-
objection.
I
We
can
can
brief
have,
you also.
we can have some more senior advocates over here. That's not the issue.
What,
Tata,
what kind of?
just one minute,
No,
let me
it is
complete,
Sir,
let
ನೀವೆಲ್ಲ
me.
ಹೇಳಾಯ್ತಾನೆ.
ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Saying that I'm
One
bringing,
minute, one minute.
ಈಗ you-
One
We are
minute.
not making personal attacks.
No, no personal
say-
attacks,
who's
no
AG
personal
attack
attacks.
now?
AG is bringing senior advocates army to
No,
argue.
no,
What is
let
this?
the, just one minute.
He
Let
is
me
above
finish.
us. He
Where is the
must,
question?
First
Advocate.
officer of the
Where is
court.
the question of?
Yes.
Where is the question of bringing?
Might I come?
He does not need anyone else.
If this is a shouting game, yes, they succeed.
Correct.
If you're going to argue, then we will see your lordship. Now, your lordship.
The
with
other
res-
way around, shouting game, they will succeed.
Yeah,
Otherwise, you will
absolutely.
succeed.
Because with respect to decibel levels, I don't think I can match it. Now, your lordship, with respect to
I
senior
don't agree
advocate
with
Mr.
that.
Panindra's party, if
My
I can
watch
be.
is showing, the environment is high with decibel level.
Absolutely. So there's absolutely no necessity. Number one, the learned AGs filed objections. They served us a copy on the last occasion. They seem to have served us a copy of objections with respect to that petition as opposed to ours. Now, if they make such mistakes, I cannot help it. All the details are with respect to
ಮುಂಚೆ
that
ಹೇಳಿದ್ರೆ
petitioner.
ಕೊಟ್ಟಿದ್ವಿ ಅಲ್ಲ,
but-
ಇವಾಗ ಬಂದು ಹೇಳ್ತಾರೆ.
ಅದ್ಲಾ ಬದ್ಲಿ ಆಗಿದೆ.
ಅಲ್ಲ, ಮುಂಚೆ we were not
Next.
served a copy of the
ಆಯ್ತು,
objection.
ಈಗ ಕರೆಕ್ಟ್ ಆಗಿರೋ ಕಾಪಿ ಕೊಡಿ.
They could have told
Now
us
we
1
will
week
have, now they will ask us to do a swap game. Next, with respect to this,
ಇಲ್ಲ, ಇಲ್ಲ,
we
you-
have,
Don't take that trouble. They will give you.
They will give us one more set. Next is, if they want to file their objections, let them also serve us a copy so that all together we will be able to start our arguments. Your
Yes, now.
My lords, I am filing my statement of
You
objections.
have already filed, is it today?
12,987.
Copy serve ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೀರಾ ಅಂತ my instructions. 12,987, whoever is up here.
ಓಯ್ ಒಂದು ಫಿಸಿಕಲ್ ಕಾಪಿ ಕೊಡಕ್ಕೇನು?
We'll give a
What is all this?
physical copy. I'll ensure it is served.
ಅಲ್ಲ,
Akash has been here
Yeah,
since
you've not seen
2:30 he's
anybody
been
there.
here.
What is this? ಅವ್ರು ಸಿಗಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ನೀವು ನೋಡಿಲ್ಲ?
How can you not see also?
No,
And
no.
more so
this-
in a power
What, how
matter.
can you not? What are you talking? Nothing, wait, yes. Now, serve a physical copy.
My lords, it's given.
ಈ
handed.
ಪೇಪರ್ಲೆಸ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ದಿನ ಬಿಟ್ಬಿಟ್ಟು ಫಿಸಿಕಲ್ ಕಾಪಿ ಕೊಟ್ಟಿರಿ.
Even I prefer.
ಪೇಪರ್ಲೆಸ್
physical.
ಕೋರ್ಟ್ ಆಗಲ್ಲ. We can make court less paper ಅಷ್ಟೇ. ಕೊಡಿ ಅದು. Physical paper.
Served, I am told.
ಇನ್ನೊಂದು ಯಾರ objection? ನಿಮ್ದು ಹಾಕಿದ್ದೀರಾ?
State has not filed objections in our matter, my lords, which is 101.1.
What is the difference, sir?
My lords, our facts are entirely different.
Because
my lords.
locus, they're trying to bring in a
My lords, we have
locus.
filed objections
If we
for the
have to
we'll
answer
give it-
locus,
we'll
then
give
we
it by
would
end of the
have
day,
to.
my lords.
My
We'll give it
my lords,
today.
our facts are completely
No, we'll
different.
give
My
it-
lords. We were specifically
it.
asked to take a smart meter.
We'll give it to them.
So that is the case that we are
So
canvassing.
if it's a smart move, please file it.
We'll give it today, my lords. We'll give it today.
Then objections, rejoinder ಅದಕ್ಕೆ?
Even if it's there, we'll complete it. Your lordship may fix.
Yes, these are all smart meter cases. So objections should be smart, short.
We'll make it brilliant, your lordship.
Yes. No problem. Bullet points. ಯಾವತ್ತು ತಗೊಳ್ಳೋಣ? Next Friday, we'll fix it. By then, you exchange all the pleadings.
That's one request. My learned friend wants his name to be reflected for R4.
ಯಾರು? ಮಹೇಶ್ ಚೌಧರಿ ಇದ?
Mahesh Chaudhary, in 12,987 of
ಅದ್ರ
25.
ಆಯ್ತು ಮಾಡೋಣ.
20th, my lords.
20th.
Friday.
Yes, madam, 20th, okay?
Please, might we request 2:30, your lordship?
2:30 only, yes.
Friday is okay.
ಅಲ್ಲ, ಒಂದ್ಸರಿ it stretches up to this point.
And
but
if
that day
there's some,
2:30.
if there's some reverse POXO then comes, then we are all doomed.
No, no, that was an important
Yes,
case.
absolutely,
Not-
absolutely.
Because not a single case in the country.
And both of them did a
Subject to
brilliant
their
job. Both of them
availability
are.
and subject to your lordship's convenience. It could be 19th or Monday, my lords, 23rd. Like instructing counsel has some difficulty on 20th.
He has taken so many dates for 20th. How will he have?
ಆಗಲ್ಲ,
it?
ಬರಲ್ಲ ಅವತ್ತು. Because if he comes here, I know what will happen.
There must be something connected with the family.
Yes, that is why. So if it is
19th,
on
if I'm very.
19th.
19th. ಅಷ್ಟ್ರಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀರಾ? Readings complete
No,
ಮಾಡಿ.
no, it's ready, my lords. We'll give it by today itself.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
We'll just
Rejoinder
give
if
the
any
copy.
file, madam. Yes, 19th ಆಗ್ಬೋದಲ್ಲ?
Please.
19, 2:30.
Obliged.
We should finish it that day.
Please.
ಇನ್ಯಾರು ಪಾರ್ಟಿ ಇಲ್ಲಲ್ಲ? ಅಲ್ಲ, ಅಲ್ಲ, ಇರೋರೆಲ್ಲ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಅಲ್ವಾ?
Four. There is still scope. 4 respondents, we don't know it.
In ours, it's only 3 minutes.
ಆಯ್ತು, ವಿಲ್ ಸಿ.
Yes, please. my lords.
ಮಯೂರ್ ಎಲ್ಲೋದು? ಜಗದೀಶ್?
That's Spurti.
CBI.
Spurti Hegde ಅವರು.
ಸ್ಫೂರ್ತಿನಾ? ಸಾರಿ. ಸ್ಫೂರ್ತಿ, ನೀವು ಪೂರ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಇವತ್ತನೇ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. 20 minutes. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಅವ್ರಿಗೆ ಮಂಡೇ ಕೇಳಿದೆ ಅಷ್ಟೇ.
ಆಯ್ತು, ಮಂಡೇ.
ಮಂಡೇ 2:30.
Tomorrow, my lords.
ನಾಳೆ ಹಾಫ್ ಡೇ ಮಯೂರ್. ಇಲ್ಲಾರೆ I would have taken, they have sat till 6 o'clock. Now I would sit definitely. But tomorrow is a half day where you can't miss at all.
The reason why I'm
ಆಯ್ತು.
forcing this court.
ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
Investigation is state, it's acting against me, no, my lords.
Correct. It's not that investigation is proceeded on that basis.
Trial is state, my lords.
Trial is state, yes. Monday, even if it is this time, we'll finish it. Yes. All right.
But 2:30 specifically, my lords.
2:30ಗೆ ಇರುತ್ತೆ ಎಲ್ಲ, but it may go on, we'll see.
Yeah,
Lot of things.
great.
Monday, you know, it's a heavy board day. ಎಲ್ಲಿ ಇವರಿಲ್ವಾ? ಮಧುಸೂದನ್. In this matter ಅಂತ 6 ಕಾಲಲ್ಲಿ ಸ್ಟಾರ್ಟ್
ನಾನು ಹೇಳಲ್ಲ. My friend is making a allegation against the council.
Suppression.
Suppression. No.
What happened to your hand?
By virtue of the, by virtue of the submission made my friend, every day this matter is posted before your lordship.
Well, even otherwise,
I do
all
agree.
matters are posted every
My
day.
senior counsel has been argued in this matter.
After that, I am not aware that I have.
Senior counsel ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು.
Mr. Ashok Karnali, ನಿಮಿಷ ನಾನು ಹೇಳ್ತೀನಿ. wait.
ಆಯ್ತು. ನಿಮಿಷ ಹೇಳ್ತಾರೆ.
Mr. Ashok Karnali appeared in this matter. After hearing this matter, your lordship granted order. This court granted an order. My submission before.
ಅದಕ್ಕೆ ಮುಂಚೆನೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇನೆ.
ಕೊಟ್ಟಿದ್ರು ಅದು. When I am not aware that further when the matter is taken for further hearing, I filed a NOC wakala.
ಆಯ್ತು.
ಅದೆಲ್ಲ ಆಯ್ತು. Your lordship given a permission.
ಮತ್ತೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ.
My submission before your lordship is who has played a fraud. ಅದನ್ನ ನಾನು make submission. ಅದಕ್ಕೆ ಮಂಡೇ ಇಟ್ಬಿಟ್ಟು.
ಮಂಡೇನೆ ರಿಪೀಟ್ ಆನ್ ಮಂಡೇ.
2:30 ಅವರೇನೋ
ಲಿಸ್ಟ್ 2:30 ಗೆ ಇರುತ್ತೆ. ಯಾವಾಗ ಮುಗಿಯುತ್ತೆ ಲಿಸ್ಟ್ ತಗೊಂತೀನಿ.
Just because of my friend urgency ಒಂದಿನ ಏನು 1 week ಇದ್ರು.
He is injured.
ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ ಸ್ವಲ್ಪ ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ.
ಸ್ವಲ್ಪ ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ ಅವರು.
ನಾನು ಹೇಳಿದೆ.
Have to take rest for 5 weeks. That was.
ಮತ್ತೆ why are you?
My lord, my only apprehension is that the stay is operating against me.
He has not filed an application for vacating this stay.
It's all right.
Till
Monday.
next date Monday.
Specifically
ಮಂಡೇ ಕೌನ್ಸಿಲ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಇದರಲ್ಲ ಇದಾರೆ ಅಂಡ್ ಈಗ 6 ಗಂಟೆಲಿ ವೆಕೆಟ್ ಮಾಡೋದು.
It's not fair on our part also. We have to appreciate the court. 6 ಗಂಟೆ ಆದ್ರೂ ತಾವು ಇದೇ ತರ ಇದ್ದೀರಿ ಅಂದ್ರೆ we should not misuse the court.
ಆಯ್ತು ನಾವು ಮಂಡೇ ಐ ರಿಪೀಟ್ ಆನ್ ಮಂಡೇ.
Please.
ಇದೆಲ್ಲ ಆಮೇಲೆ ಬರ್ಕೊಂಡು.
My lord,
ನಿತಿನ್ ಸರ್.
my lord, that NCLT matter, my lords, by mistake.
ಫಸ್ಟ್ ಕರೆದೆ ಅದನ್ನ. ಎಲ್ಲಿ ವೇರ್ ಇಸ್ ಧನಂಜಯ್? 4:45 ಮೇಲೆ ನಾಟ್ obliged to be there.
ಅದು by mistake ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. though the date was given.
ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ನಾಟ್ ಅದು ಲಿಸ್ಟ್ ಮಿಸ್ ಆಗಿತ್ತು ಅಂದ್ಬಿಟ್ಟು ಹಾಕಿದೆ. ಮಂಡೇ ನಾಳೆ ಅರ್ಧ ದಿನ ಸರ್. ಧನಂಜಯ್ ಅರ್ಧ ದಿನ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ.